Margo, can I ask you a favor?
Okay, Chairman, ITS and TV are ready.
Okay, so we will call to order the April 23rd, 2020 Metropolitan Nashville Planning Commission to order. Our first order of business is a roll call, and so I see on here, but before we do the roll call, I want to just say a few things before we start. Housekeeping items. And so the first one is we have a lot of people on the line. And so we need to make sure that in order for us to not get a lot of echoing and noise in the background when you're finished speaking, please mute your line. And that would be very, very helpful. And I appreciate everybody trying to do that. And that way everybody can hear each other. The second thing is when I say raise your hand, it's not raising your physical hand, although you could do that, but it's the icon in the app, and you have to push it, and then to raise your hand and to be recognized. Also, where you can also say, hey, can I be recognized? And we appreciate that, commissioners. This is our third meeting, I think, telephonically through a teleconference, and it seemed to go really well. The third thing is we're going to go very slowly, make sure we get everything right. This is relatively new for everyone, and especially the viewing audience and the public. And so we want to make sure we go very slowly. And if anyone has a question, let us know. And especially if I'm making an error, we want to make sure that we get things right. So our first order of business is the adoption of, we have to do roll call first. So commissioners, once I call your name, if you'll please say present, and we'll do roll call. So going down the list, Vice Chair Farr, are you present? Vice Chair Farr? Can everyone hear me?
Vice Chair, I think you're on mute.
I can hear the chair, but I can't hear the vice chair.
Yeah, I can't hear Vice Chair. Can you hear me, Lucy?
Chairman, I can hear you. If you want to continue the roll call, I will reach out to her and make sure that she has audio.
Okay, perfect. Commissioner Gobble.
Present.
Commissioner Haynes.
Present.
Commissioner Johnson. Commissioner Moore.
Present.
Council Lady Murphy.
Present.
Commissioner Sims. Commissioner Sims.
Present.
Commissioner Tibbs.
Present.
Oh, and Commissioner Vice Chair Farr is getting back on the line, and so when she's on the line, we'll record her as present. And I'm present, and that is 9 present, which includes myself. And I appreciate, commissioners, you being on the call today. It will probably be a lengthy call as we are going to hear a couple of items. And as we get into the meeting, I appreciate everyone's patience. Our next item of business is to explain the telephonic meeting. And so is our attorney on the line? Is Alex on the line?
Good afternoon, Commissioner Chairman Atkins. This is Quan Poole from the Metro Legal Department, and I am
hey,
here.
Quan, I'm sorry. Perfect.
That's okay.
And if you would explain,
as you know, the Tennessee Sunshine Law basically requires that any municipality or any government meeting be held in public, in person. However, due to the ongoing pandemic related to COVID-19, the governor has executed executive orders that temporarily suspend those sunshine laws that will allow government agencies, boards, and commissions to meet telephonically or electronically without running afoul of the sunshine laws. However, in order to do that, the board must, by motion, find that it is that the business that they are going to conduct is essential, number one, and that it is to the benefit of Tennesseans that the meeting be held telephonically or electronically.
Thank you. And so one of the things that we do is we will need a motion to say, and in the motion, whoever makes this motion, it will include that to move that we are electronically meeting and that it's necessary and essential to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak. Any planning rules that are in conflict with the governor's order are hereby temporarily suspended until the governor's order is no longer in effect. So in other words, this motion includes a suspension of our rules. Is that correct, Quan?
That is correct.
Okay, and so as we have done before, I'll ask the commissioners to raise your hand, or you can say, be recognized by voice, but it would be very helpful if you could raise your hand in the icon, your hand icon in the software that we are using. So we are ready for someone to make that motion. And we have, let's see here. We have Councilor Murphy.
Thank you, Chairman. I would like to make the motion to suspend our planning rules and the motion that it is necessary for us, proper and necessary for us to meet virtually to protect the health and safety of Tennesseans and carry out essential governmental business that is on our agenda today.
Thank you, Council Lady, and proper motion. And I see Commissioner Tibbs. Would you like to second?
I second that.
That's a proper motion. And any other discussion? I see, let me see here. And I see that there's I have to look, there's a long list of panelists that I have to look through here. So, and then to make sure. Okay, I see no other discussion, and I'll ask it by voice. Is there any other discussion? Seeing none, we will vote aye when I call your name or vote no. So we'll go through the list. Vice Chair Farr. Vice Chair Farr is still having problems. So we'll go to Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson. Commissioner Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
We'll try Vice Chair Farr again. Vice Chair, are you on? Vice Chair is still not on, so that's eight ayes and 0 noes. Ayes have it. And we are now on, and it's approved to have the telephonic meeting, and we are on to item C, which is the approval the adoption of the agenda. And the agenda was sent out to everyone prior to the meeting. And so if there will be, y'all will raise your hands again. So Commissioner Tibbs, would you like to make?
Motion to approve agenda?
That's a proper motion. And is there a second? If you'll raise your hands, and then Commissioner Johnson, you're recognized. Commissioner Johnson, you have to unmute yourself, though. There you go.
Chair, before I second I have a technical question to our legal counsel. Would that be appropriate for me to ask right now?
Well, is it dealing with the agenda or is it dealing with
Yes,
other
dealing
items?
with the agenda specific.
Yeah, ask your question.
Especially, sure. So agenda item is specifically concerning subdivision regulation. Tennessee Code annotated 13-4-304, as well as our subdivision regulation, states the Planning Commission shall approve, conditionally approve, or disapprove the concept plan within 60 days after the date of the regular meeting of the Planning Commission at which the application was first placed on the Planning Commission agenda. So that is today. So the reason I'm asking is, especially item number 31, we did receive lots of input, and as well as, last minute approved was, last minute report was, about an hour and a half ago. So if we approve the agenda, so it will confirm item number 31 will be considered as today's item agenda. So my question to our legal counsel is, at this point, who have authority to not have that item number removed from today's agenda and then, consider another day? The reason I'm asking is if we approve the agenda, 60 days clock will start ticking today. But if we don't put that item on agenda, 60 days clock will start ticking when that agenda item is placed on the Planning Commission meeting. So that's my question. Who has authority to remove that agenda and then defer to appropriate meeting date? Or is it even feasible?
Quan?
Okay. This is Quan Poole from Metro Legal. Thank you, Commissioner, for the question. So there are two separate provisions that are at play. And so one of them is 13-4-304 B, which states that after, as well as Commission Rule Roman numeral 8H number 1, states that within 30 days after a plat is submitted to the Planning Commission, it has to be placed on the agenda within 30 days. So just looking at my notes here, it looks like this application, this plat was submitted to the Commission back in February 12, 2020. It was first scheduled to be heard on March the 26th. And so it did meet that requirement at that time. Appropriately, the applicant deferred to the April the 9th meeting. On April the 9th, they deferred again to April the 23rd, which brings us to today. And so it is my understanding that that applicant no longer is deferring or agreeing to deferrals. So at the point that they state that they no longer agree to the deferral, it reverts back to that clock that is codified at 13-4-304B, as well as subdivision rule Roman numeral 8H1, which states that it has to be placed on the agenda within 30 days. Okay, and so obviously today would meet that requirement as far as that goes. Now there's a separate provision also in 13-4-304A, Commission, that you alluded to, that the Commission has to take some action upon that after its initial consideration within 60 days. And so, yes, that 60-day clock would start today, seeing that the applicant no longer wants to defer. But my advice to the Commission is that there wouldn't be discretion to remove it off of the agenda so that the 60 days clock doesn't start, because then it would be, then the Commission would be in violation of the other provision in 13-4-304, which requires it to be on an agenda within 30 days.
And Quan, let me ask, this is Greg, the Adkins, the chair. We could defer this item, but we, as the Commission, need to defer it, right? Correct.
That is correct. At this point, the staff really wouldn't have any more authority to defer the item, seeing that the applicant wants it to be heard. And so the commission would have the authority, if it so chose to defer the item. However, that would be considered an initial consideration. And so within 60 days of today's date, the subdivision application would have to be approved or disapproved, or else it would be deemed approved as a matter of law.
So we really need to put it on the agenda, but we can discuss it under the deferral motion. Correct?
That is correct. That
Okay.
is correct.
Commissioner Johnson, does that answer your question?
Yes, Chairman and our legal counsel. Yes, it addressed my question. So for that explanation, I will second the adoption of the agenda.
Okay, that's a proper motion, and we can.
Greg, sorry.
Yes.
This is Councilwoman Murphy. I'm sorry to interrupt. I had a further question on that explanation.
Yeah.
Oh,
okay. Yes.
I'm sorry to throw a wrench in things, but although we've made the motion to agree that this agenda has governmental essential business on it, could we determine that a subdivision is not essential business and it be deferred and not start any of those clocks that Quan laid out for us? Not to, I mean, sorry to like play game, game theory this out or anything, but just since the question was asked, does our ability to declare subdivisions non-essential business come into a play here?
Well, so before I ask the legal counsel to respond to that, the one thing that we need to be really careful is if we're going to hold this meeting and we declare one like subdivisions not essential, why would zoning matters be essential at that point? Why would we be essentially holding the meeting? And so if we got to be really careful about, in my mind, and be consistent, because if we're going to have a telephonic meeting and say that our business is essential, and it could potentially put any other subdivision issue in legal jeopardy. So I understand that it's a controversial subdivision, but we need to be really careful, Council Lady. And I'll hand it over to the legal counsel for his opinion.
Hello?
Thank you, Chairman. And I would agree exactly with what you stated.
No, I
what
think I'm
makes
okay. I managed. Someone was telling.
Oh, hold on. I think Vice Chair, I think you're off mute. Can you hear us?
Yes, sorry. IT was calling me.
Okay, you're with us, and we appreciate you're present for the meeting. Thank you.
Yes,
okay,
I'm here.
come on, go.
And so I agree exactly with what the chairman, what you stated, but also in addition to that, the governor's executive order doesn't suspend or otherwise toll the statutes that we're talking about, the statute that we're talking about in 13.4304. So this clock is going to start one way or the other. There's nothing in the executive order, although it suspends the public meeting requirement, it doesn't go so far as to suspend other state laws. And so the reason that this is deemed essential is because there's been no suspension of the time frame in 13.4304. It meets the definition of essential because the board, the commission would be placed in a position where if it doesn't meet, then any applicant could submit any subdivision they want, and it would be approved because of the Failure Act. So unless there was an equal suspension of the time frame in 13.4304, which currently there is not, that time still rolls regardless of if the commission meets or not.
Councilman Murphy, does that answer your question?
It doesn't. I mean, I think this is the same debate that we've had at the council. And I just was kind of asking for a clarification because I know the BZA has deemed certain types of applications non-essential. and they are taking up other types of applications. And so didn't know, and sorry, Quan, if that was an extra bar exam that we just put you through. So I appreciate it. Thank you.
Thank you, Council Lady. And we can discuss this item on the deferral motion for sure, if that's what if the commission so chooses. So we're on discussion. Is there any other discussion?
Yes, I have one, Chairman, please. I need a point of parliamentary inquiry, please.
Yes, Commissioner Sims, you're recognized.
Okay, thank you. Just as a point of parliamentary inquiry, the appearance of fairness doctrine, which in public policy has been used over and over again in different ways. I guess this is a question to our legal. How are we assuring that we are effectively using the appearance of fairness, particularly related to item 31?
Quan, you recognized.
This is Quan Poole from the Metro League Department again. I sincerely apologize. I'm not completely or totally familiar with, I believe you said the appearance of fairness doctrine.
Yes, it was raised a lot by letters to us.
Yeah,
Okay,
and so, yeah, go ahead, Quan.
I mean, I guess, or if Commissioner, if you're asking about whether their ability to appear in person or not to be heard in person.
On multiple counts, but my question right now has to do with the order. Or should this be discussed under item 31, or is it appropriate now before we actually adopt the agenda?
Quan, let me say this. Let me say this about that. There was a lot of discussion, Commissioner Sims, about fairness and transparency. And so the director and I had lots of questions and working with not only neighborhood groups, but attorneys and legal counsel, and trying to figure out the approach that is fair. And particularly item 31, I understand what you're saying. The issue was that it would have been timeline. We had to hear it. Now, under the deferral motion, we can defer that item.
Okay.
And so, but we have to do it as a commission, not administratively, if that makes sense. And so, the one thing that I will note for this particular meeting, and I was going to note it later in the meeting, but I'll note it now, is that we're trying this to see if we can do it, and we've raised concerns of fairness and transparency, and Lucy and I talked through them, and we asked ourselves, how could we make it seem as transparent as possible under the current pandemic situation? And so we've done that by allowing the public 4 ways to submit, to be part of this meeting and submit comments. And the first one is the public was able to email. We posted it on the website and all of the communications for the meeting. We also set up a voice recording. And then also we also have a call-in number, for those voice recordings. And then people can go to the courthouse and physically be a part of this meeting, and then and submit comments. And then they can also, we set up a phone line so they can call in live for this meeting. And so there are 4 different ways, highly publicized, to try to address some of these concerns. Now, if y'all think that you want to defer that particular item as a commission, and because of the comments and issues surrounding that particular case, that is something that this commission can look at and do and vote on normally. Now, I'd say under the adoption of the agenda, which is where we're at according to legal, that item should be placed on the agenda, and then we can address it under the deferral motion. Quan, do you have anything to add to that?
No, not at this time.
Commissioner Sims, does that?
No, I really appreciate your comments. I think the difference, is are we as a whole trying to make sure that we have an appearance of fairness? Of course, that has to do with the meeting. I was particularly related to item 31, but I agree that we can wait until we get there. So.
Okay, yeah, it will be under the deferral motions. We can discuss it, and then we can discuss it again if it doesn't get deferred. So we are still on the adoption of the agenda. We have a proper motion and a proper second, and I want to make sure if there's any other discussion. Commissioner Sims, if you will push your hand button again so it doesn't show that you're raising your hand in the app, that would be great. And I appreciate the question. All right, so we'll go through roll call vote again on the adoption of the agenda. And Vice Chair Farr. And if you all will say aye or nay for the adoption of the agenda. Commissioner Farr, seeing no other discussion, Commissioner Farr.
I approve. Sorry, I couldn't find my name.
Okay, yeah, there's a lot of people. All right, Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson. Commissioner Johnson? Here's
Aye.
perfect. Commissioner Moore?
Aye.
Councilor Murphy?
Aye.
Commissioner Sims?
Aye.
Commissioner Tibbs?
Aye.
Ayes have it. It's 9 ayes, 0 nays, and the adoption of the agenda. The agenda is adopted. Now we are on to the approve item C, which is the approval of the April 9th, 2020 minutes. And those were also sent out ahead of time. And is there a motion to adopt the minutes? And I see Commissioner Johnson. You want to make a motion?
I make a motion to approve April 9 minutes.
Thank you. And then is there there's Commissioner Moore. Would you like to second?
I second.
Perfect. Commissioner Moore seconds the adoption of the minutes. And is there any other discussion? Make sure I don't see any hands raised, and I don't. Is anyone on the line? Any commissioner want to discuss? Seeing no other discussion, we will do a roll call on the approval of the minutes. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
And the ayes have it. 9 ayes, 0 nays, and the April 9th minutes are approved. And so now we are on to the recognition of council members. And so we'll go through this really slow. There's a lot of council members on the phone, on the call, and I want to make sure we get all of the council members taken care of if they want to speak now or particularly on their item. And I appreciate all the council members and their patience for this process. We work a lot with the council members on zoning matters and subdivisions and all sorts of policy matters. And so I appreciate the council members being part of the call. I appreciate Council Lady Murphy for being on the commission and spending so much time with us together. So I really appreciate them. So we are on item D, which is the recognition of the council members. In the way that I would like to try to handle this. I would like to, if you're a council member, if you'll raise your hand in the app, instead of me going down the list, and I will recognize you. And so I see council member Stiles, you're recognized. And you'll have to take yourself off mute. There you go.
Thank you so very much, and good afternoon, commissioners. I just wanted to give my approval of two items, 30A, which is the Southeast Community Plan Amendment, and 30B, the Beeman and Turner properties. This is part of the existing Century Farms project that's being worked on right now, which is going to be providing several stores for Tanger, as well as additional corporate structures, hotels, and restaurants. It is a vital part of our community that's coming. Very excited about it. And the bringing in of the acres, the 2.92 acres, it does not change the format of the project at all. It's just additional land that would be incorporated. And there are 2 acres that are going to be set aside specifically for green space for the community. It has not been determined where that green space will be, but it will be a set 2 acres, and the developers are working with the community as well to see what that'll look like eventually when we get to that part of the process. So I just wanted to share my thoughts in advance.
Thank you, Councilor. Appreciate it very much. Thank you for joining us today. The next I saw was Council Lady Gamble. You recognized?
Having trouble with my mute button there. Thank you for the recognition. I am just wanting to speak briefly in support of Pineview Cottages project that is on the agenda today, actually under consent. And I just want to express and put on the record that we've had several community meetings about this project. There were some concerns about the development only having one ingress and egress route through an existing subdivision. There were many concerns expressed by the residents about just the increase of traffic. There's about 42 lots that's planned, and it's within the current zoning, so there's no zoning change, and we appreciate that. But just the idea of that increased traffic having only one ingress and egress. I worked with the developers and the planning department to look at and consider other options for developing another outlet. And other than the property south of the property that's being developed, there was really no other avenue to add another ingress egress at this point, unless the property south of the development is developed, and then we could add another ingress egress point at that time. So we'll be working on that and looking forward to that. In the meantime, working with planning and the developers came up with a plan to address the safety concerns, because there were a lot of safety concerns. The existing neighborhood that the new development will be traveling through does not have sidewalks, and there are children present. There are school buses that pick up kids when we get back to normal at some point. And there's a concern that having the excess traffic would hinder the safety there. So the developers agreed to add a 3-lane section on that street to address the traffic issue. And then with the safety, they agreed to put in a 200 yards, I guess, of sidewalk on that main road so that the students and children who are standing and waiting for the buses will have a safe place to stand. So I think that's an agreeable, compromise until we can get another ingress egress into that development, because there's about 180 houses in the current existing subdivision, and with the new subdivision there's another 42 homes. So just wanted to express that I appreciate the work of the planning department and the developers in trying to come up with some kind of solution for addressing the increased traffic and the safety measures outside of trying to get another ingress and egress at this point. Thank you.
Thank you, Lady. I really appreciate it. Next, I saw Councilor Benedict. You recognize?
Thank you, Greg, and thank you, Commission. So I am here on item 31, and I'm going to save my comments for when that comes up on the agenda. Thank you.
Okay, perfect. And then we have, I saw, let's see here. Council Lady Hancock, I saw you next.
Hi, thank you for having me. I appreciate you guys working to get this meeting done, even with the state of affairs in America today and across the world. The item that is pertaining to District 9 on the agenda is item number 18, 408 Ferris. And as you all are already aware, we've had some letters and some emails submitted in opposition from members of the community. We also have 3 elderly residents that have called me because they do not have access to the internet, and they're concerned about this density because most of the lots have 1 or more acres, usually 2 to 5 acres on this street and the street behind it. So while they, don't mind if someone wants to develop it, they'd rather it double in density instead of quadruple. And I really appreciate the staff recommendation to defer to the May 28th meeting, which hopefully can be in person, because again, several of these residents don't have the access that we have to do these online meetings. So they would appreciate being able to say their piece in person. Thank you.
Thank you, Council Lady. Council Lady Virtue, I saw your hand raised.
I'm speaking on 2 items. Item number 19, what's the longest that we can defer that agenda item out?
Director Kemp. Or anyone else, or
give me a moment to confer with Lisa. Typically, we have a time frame that we need to respond to council, but if the council member is open to a deferral, then we can. Lisa, do you know? Do you have the council schedule in front of you by chance?
Hi, Lucy. This item is scheduled for public hearing at the May council meeting. And so if there was an agreement that it would also be deferred at council, then our timing sort of gets put on pause. But if not, then we would need to make a recommendation likely. I'm sorry. Right now, we have it deferring 1 meeting, which would get us a recommendation before 3rd reading. That's assuming that the public hearing happens on May 5th. If the public hearing is deferred at council, then our time frame could be adjusted to acknowledge the deferral time frame that's set there.
When do y'all not meet during budget time?
We go ahead, Lisa.
We still have a meeting. We have 2 meetings in May, 2 meetings in June, 1 in July and 1 in August, and there will be a public hearing at council in June that was set by council a couple meetings ago. But our meeting schedule doesn't stop during that time.
Okay, because of this, and I think I shared this with you in advance. I know Councilwoman Porterfield also has too. Because this is relying on data for many agencies, and due to everything that's going on, we want to defer this to August.
And which item is that, Council Lady?
Item number 19, I believe. It's the moratorium.
Got it. Do you have that, Lisa, or your deferral motions? Council, we have the item.
What would be that date in August?
Lisa.
Hi, council member. That would be August 27th. And so the public hearing at council would also need to be deferred likely to September.
Okay. And then I'm also speaking on item number 32, that's project 123-83P-002. That's a PUD. This is a 34-year-old PUD. Had requested a periodic review on this PUD because of the age of it. And I need clarity on how I was notified, and the approval was the same day of my notification.
Director Kent or Lisa?
So the periodic review is basically council has laid out standards in Title 17 for the planning department to assess whether or not certain investments have been made in the project. And so they're fairly specific criteria. They're on page 141 of the report. And so staff is basically having to weigh the facts against each of those criteria. And then Title 17 also gives us a timeline by which we have to respond to the periodic review request. And so I would need Lisa to tell me when the project was submitted and how that would have been fit within that timeline. But just to be clear, there is a site plan that has been proposed within this PUD, and that has not been approved. And so that is just under review. And so I wanted to make sure that that was clear as well. Lisa, can you, do you know when this was submitted, the date this was submitted?
Thank you for that clarity. I thought this agenda item was the actual site plan. So this is not the site plan?
No, this is just the periodic review for the PUD. Right. So all this is asking the 5 criteria that we have. We just measure the facts against each criteria and determine if it's active or not. The site plan is not part of this application and is not being heard today.
Okay, so this agenda item, this is just you telling me your response to my inquiry.
Yes, this is just saying that under the standards that council has laid out for us under 1740-120, that we have found that the PUD is active based on the criteria. And so,
all right. Thank you so much. Y'all have a great meeting. Thank you so much.
Thank you, Council Lady. We appreciate it.
All right. Thank you.
All right. So now we are back onto, I saw Council Lady Porterfield. You're next in the queue.
Thank you so much for recognizing me. Council Lady Bircher actually already beat me to it. I was going to request that item number 19 be deferred, but she's already made the request. So thank you all so much for honoring that consideration, and I hope y'all have a great day.
Thank you, Council Lady. Is that all you had?
That was it for me.
Okay. And then there are a couple other council members on the line, and I just want to make sure we don't miss anybody. Council Lady Henderson, did you want to speak now or later? Council Lady Henderson. All right, and we have Councilman Poley. Do you want to speak now or later?
I'll wait until later.
Okay, thanks, Councilman Poley. Appreciate it. And then we had Council Lady Johnston on here. I want to see. You want to speak now or later, Councilwoman? And then I saw Councilman Rutherford. I don't want to miss anybody. And then we've already done Councilman Stiles. So, Director, is that all of the council members, or Lisa? I think I've got everybody.
I believe so.
Okay. And so I want to make sure if there's another council member on the line, please unmute your line. All right, seeing none. We're on to the next item, which is items for deferral withdrawal. Lisa?
We have the following items for deferral or withdrawal. Item number 1 on page 5 of your agenda, 2020 CP 000001. Staff recommendation is to defer indefinitely. Item number 2, 2020 SP 012001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 3A, 2020 SP 019001. The Crossings Mixed Use Development. Staff recommendation is to defer to the May 14th Planning Commission meeting. The associated case, item 3B, 8487P 001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 4 on page 6 of your agenda, 2018 S 209001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 5, 2019 S 086001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 6, 2020 S 041001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 7, 2019 HP 001001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 8, 2005 UD 006043. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 9 on page 7 of your agenda, 2020 Z 016PR 001. Staff recommendation is to defer indefinitely. Item number 10, 2020 Z 028PR 001. Staff recommendation is to defer to May 14th. Item number May 14th, 2020 Planning Commission meeting. Item number 11, 2020 Z 029PR 001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 12, 2020 Z 058PR 001. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 13, 2020 Z 059PR 001. Staff recommendation is to defer indefinitely. Item number 14 on page 8 of your agenda, 24784P 003. Staff recommendation is to defer to the May 14th Planning Commission meeting. Item number 15, 2020 NL 002001. Staff recommendation is to defer to the May 28th Planning Commission meeting. Item number 16, 2020 CP 010001. Staff recommendation is to defer to the June 11th Planning Commission meeting. Item number 17, 2020 Z 061PR 001. Staff recommendation is to defer to the May 28th Planning Commission meeting. Item number 18, 2020 S 054001. Staff recommendation is to defer to the May 28th Planning Commission meeting. On page 9 of your agenda, BL, item number 19, BL 2020-197. Staff recommendation per the council member's request is to defer to the August 27th Planning Commission meeting. Item number 20, 2019 Z 015TX 001. Staff recommendation is to defer to the May 14th Planning Commission meeting. And that's all.
Thank you, Lisa. And commissioners, you've heard these items, and I'm going to go through the list. And then after we go through this particular list to get it on the record, then we can discuss item 31 as we discussed. So let me go through these items for deferral. And Lisa, make sure that I'm correct. And the following items are for deferral or withdrawal. Item 1, 2, 3A, 3B, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and 20. Is that correct, Lisa?
That is correct. I would also like to check in with our person that's live at our remote station at the courthouse to make sure that there is no one there requesting any changes to the deferral item.
That's excellent. Please do so.
This is Greg Flexen with the Planning Department down at the courthouse. There is no one here requesting any changes to the deferral agenda.
Okay. Commissioners, you've heard those particular items, and we are now, let's get a proper motion in a second, and then we can get into discussion. So is there a motion to adopt the deferral agenda, the deferral items? Vice Chair?
I will make a motion that we adopt the items for deferral.
And that's a proper motion. And then Council Lady Murphy, you want to make a second, and then we can get into discussion.
Second.
Second, it's proper motion. We are now into discussion. Is there discussion for any other items, including 31? And raise your hand. Council Lady Johnson? Commissioner Johnson, you're right.
Thank you, Chair. At this time, I would like to propose to add item number 31 to deferral. The reason is because this item deserves more precise attention, including visual. Although, as a commissioner, we have read 71 pages of community input, 60 pages of those regarding to item number 31. Also, on top of 24 pages letter from applicant. However, having more fair and transparency involvement from the community, I think it would be so difficult for the community to express their concern, as well as capitalize Council Lady and community's input via telephone. So now Metro is going through the phase 2, opening up public and commercial business and so forth. So within the 60 days period, I think that will expire June 21st. If my calculation is correct. So we do have at least 3 meetings for us to meet and consider. So for that reason, I would like us to consider in-person meeting to physically discuss that item. For that reason, I would like to propose to add item 31 to deferral item.
Okay, so according to our director and Lucy, that Director Kemp, the developer would like to say a few words on this if we are going to defer it.
Well, I think what I would advise, if we've heard from council that part of the equation on the timing is the developer's agreement to deferrals. It'd be good to have on the record their views on that, and that way we can have it in the record, and then the commission can consider it.
And I think that's appropriate. Generally when we're in, our meetings, we always allow the developer, we allow some latitude for that. Lucy, you're absolutely correct. So is the developer on the line?
I believe that he's here. I need to have advice from the, can you hold one moment? ITS needs to unmute him. He's an attendee, and I don't have the ability to move him over. Hi.
Is the developer on the line now?
He is, but he's not unmuted. Give me just one moment, please.
Okay, thank you.
Okay, I believe.
Yep. Okay, and if you'll state your name and your address and which project, just for the record.
Yes. My name's Doug Sloan. I live at 6354 Torrington Road, Nashville, and I'm here to speak on item number 31.
Thank you, Mr. Sloan.
And I was able to listen in, and I appreciate the commission putting this meeting together. I know this is very difficult, and we greatly appreciate it. And I know the discussion earlier involved the deferral and the timelines that are required to hear a subdivision item. And I'd like to talk about that if I may, just for a minute. The initial application for this subdivision was filed February 10th of this year. The state statute, whether you're traveling under the municipal planning regulations or the regional planning regulations in 13.4.304 or 13.3.43, require that once the application is filed with the department, that it be on the agenda within 30 days. Now, it does allow that a applicant can agree to defer having it put on the agenda, but once it is put on, then there's 60 days within which it must be heard by the commission. That 60 days runs regardless of whether the item was heard or not. Once it's on the agenda, that clock begins to run. Now, the same statutes allow for the applicant to agree to a deferral, and it allows for the applicant to agree to an extension of time of the 60 days running. The statute's very clear in that it breaks down those two agreements by the applicant separately. The applicant, as I said a moment ago, the applicant can agree to defer, which is one thing, and then the applicant can agree to an extension of time. This applicant has agreed to defer twice at the request of the council lady and at the request of the department so that he could continue to have community meetings. And he has had a number of community meetings with a lot of attendance. What the applicant has not done, and there is no record of, ever agreeing to an extension of time, of the time period of 60 days. And I invite the council to look at 13.4.304A, midway through the paragraph, where it says the applicant of the commission's, the applicant for the commission's approval may waive the time requirement set in this subsection, and this is separate section, subsection A of that, and consent to the extension or extensions of the applicable time period. This applicant never did that. The applicant never agreed to an extension of time. And by law, this body had to take this item up 30 days after the February 10th date that it was filed. Well, the first meeting after 30 days. And that would have been, let's see here, March 12th would have been the first meeting after the 30 days ran. And it was from March 12th that the 60 days run. So the statute is, I think, clear on these issues, and they put those time frames in there so that when there's an application that meets all of the subdivision standards, as this application does, and as the department's recommendation shows that it does, they can't be held up and disapproved essentially by tabling it, by sliding it in a drawer and not addressing it. And so for those reasons, I have to respectfully disagree with legal counsel that the commission has the opportunity to defer this. I believe that the applicant has already agreed to do deferrals, but does not agree to a deferral here and has never agreed to an extension of time.
Okay, Mr. Sloan, so you're saying that your client does not want to defer anymore. He wants to move forward with a vote or no vote, yes vote or no vote. He is not willing to, under the circumstances of the pandemic, he's not willing to defer.
He does not have the opportunity to defer. He has deferred it as far as he can because of his contractual obligation. And he has deferred it, and he has had multiple community meetings. He has knocked door to door. He has drawn up a community benefits agreement and offered that. He has adjusted the plans to provide for additional open space and reduce the number of lots. And there's not anything more he can do with the time frame that he has.
Okay.
Okay.
Thank you. Appreciate it. Do you have anything else, Mr. Sloan?
Not at this time. Should I reserve 2 minutes for rebuttal?
Well, it's not, we're not officially on it. We're on a deferral motion, but you'll get that chance if we hear the item. So I appreciate that, trying to slip that in, but no. This is really just a courtesy, quite frankly, but we appreciate you, Mr. Sloan. We try to give leeway to all of, community and the developer, especially when we're talking about a deferral motion. So thank you for your comments today. All right, so we are back on to discussion on the deferral agenda. We've had a proper motion and a proper second. We're on discussion. Any more discussion on item 31 or questions from commissioners? I'm looking at.
My hand is raised, Greg. This is Councilwoman Murphy.
Yep, Councilwoman Murphy, you're recognized.
Thank you. As I go my hand up and down. Since we heard from the developer, I would like to hear from the councilwoman, if that's possible. I think her hand may have been raised. I don't know if she can speak or if we have to request her to speak, but I would like to request that we hear from the councilwoman at this time.
Yeah, council lady, you're recognized.
Thank you, Chair. So, and thank you, Council Lady Murphy. So, Mr. Sloan is correct with his timeline of events. Nonetheless, as Commissioner Johnson has outlined, there is a tremendous amount of opposition and some, I believe, legitimate concerns with regards to moving this through tonight. I think that as we go through the public hearing, that you will hear from folks on the side of that are opposed to this that do have at least one legal concern, if not more. And so I do think that as I've said, and as the letter that the commission has in their hands right now, I don't think this is the right amount of density for this location. I think a less dense property or less dense development would be better here. It is deep in the neighborhood. I'll let my letter speak for itself. And if we decide not to defer this, I'll expand on that later, unless you guys want me to right now. But I would prefer that the commission at least hear it. We already have a lot of folks that have made their comments. And so I think that it's important that we hear that tonight. And then so I would ask that the commission does not defer it at this time, but that once it's heard, if it's possible to be deferred. Is that right, Chair? It could be deferred after the hearing?
Well, it can be, but I will have to get legal counsel to give us an opinion of if we can legally defer it. My understanding was that we could. Opposing counsel seems to think that's not correct. So is our legal counsel on the line, Quan?
Excuse me. This is Quan Poole from Metro Legal Department. To answer, I guess, the specific question about whether it could be deferred, I think that it could be deferred, but again, that sort of starts the clock, the 60-day clock that we were talking about. But I also just wanted to touch on the other thing, like to me, and this is Metro's entire interpretation, there are two specific and separate clauses in this statute. And we're talking about TCA 134304. But one deals with the initial placement on the agenda. That has to be done within 30 days. When you look at the first part of in subsection A, though, it says the commission shall approve or disapprove a plat within 60 days after the initial consideration. up until this point, there has not been an initial consideration of the plat in one of its meetings. There have been 2 deferrals. And it's our opinion that those are not considered considerations of the application itself. Otherwise, those those deferrals to be used to sort of, okay, delay, and then all of a sudden you've got to act on my subdivision application on that last date. The other thing too that I want to point to, and this is coming directly from the Planning Commission rules, this is Roman numeral number 6, item J, and it talks about deferrals. And it says the commission may defer action on any item provided the reason for deferral is reflected in the motion to defer. If an item is deferred at the request of the applicant, any time restrictions normally placed on the commission will be suspended until that item is until that item is returned to the agenda. So in the current case, we had an initial item was initially on the agenda for March 26th, deferred until April the 9th. On April the 9th, it was deferred again until today's date of April the 23rd, which would invoke Roman number 6J, deferrals, until that item is placed back onto the agenda. These timing requirements that we're speaking about are suspended. Now, it's clear that the item is placed back onto the agenda day. The applicant doesn't want to defer, and so the timing requirements are invoked. And if the commission does decide to defer the action today against the will of the applicant, that is going to be considered a consideration. And because that's considered a consideration is the reason that 60-day clock would start.
Thank you, Chair, and thank you, Mr. Poole. So if we have the time, I would prefer deferral as I look at this. As the developer and I have had many conversations, the community and I have had many conversations, and Mr. Sloan is correct that that the developer has made efforts in earnest to work with the community. Having said that, the plan that he continues to bring does not fit, in my opinion, with the community, with this area of Inglewood. I have offered an SP and to go down that road, so that was something that I think that I could work on with these folks to try to find an amenable solution for the community. The developer, as Mr. Sloan said, he has offered a community benefits agreement with some concessions for the neighborhood. But again, I would like to make sure that the commission does have ample opportunity to clearly hear from folks and decide if this is, if this meets the subreg, if this meets the subreg criteria or not. So my preference would be to make sure that everybody can be heard fairly, and as long as the clock starts ticking from here forward and we're not at risk of anything there, then I do think a deferral would be great.
Thank you, Council Lady. I think both sides are lawyering up. So I'm going to hand it over. Well, number one, I really appreciate you, Council Lady, for being so patient with us and working with us on this. So then appreciate your comments. I think our director would like to say another thing. I think the neighborhood folks have an attorney as well, but we'll hand it over to Director Kemp. Director.
Yes, thank you. So the attorney for the neighbor who has identified himself as a representative of the neighborhood would like to speak. If y'all can give us and Chair, are you open? Can we entertain this now?
Well, so let's do this. Is there objection from any of the commissioners? I think that it would be prudent if we let the developer attorney speak, that we also let the neighborhood speak. So seeing no objection, which I don't, raise your hand if you object, or say, or unmute yourself and say you object. Vice Chair?
Thank you, Greg. I just want to get clarification. So we are still on the process. We're still voting on the items for deferral withdrawal. We are discussing a motion to put item 31 onto the deferral list, and we're having somewhat of a public hearing around that.
Well, it's what I would tell you is, generally we allow, Vice Chair, that's a very good comment. The one thing that I would say is that since we're having these telephone meetings, my thing is that we allow more leeway than we usually do because we're not in a public hearing. I wouldn't say that this is a public hearing. This is discussion on helping the commissioners decide if they're going to defer or not. And sometimes during our debate, during our discussion period, we allow people to speak. And so we are staying consistent with that. And I don't want it to go beyond the two attorneys is what I would say, Vice Chair. And
okay.
That
is totally fine. And so at the end of this, we will then vote on whether or not we want to add item 31 to the deferral list.
Yes, after all the commissioners get discussion in, yes.
Okay. Thank you.
Is there any objection with allowing? I believe, I'm always trying to make sure the commissioners and the commission allows leeway a little bit when we're trying to. This is obviously a controversial case. We're considering it in a different context, in a teleconference, and I think leeway is a good thing. Any objection? I don't see anybody. Does anybody want to? Any other commissioners? Without objection, Director.
Okay, thank you, Chairman. Okay, so in just a moment, you will hear directly via call-in from someone who will identify himself as normal and give the address and the like. So just give us 5 seconds.
Thank you, Director.
Thank you. Hello?
Hi, this is the chair. If you'll please state your name, who you represent, your address, and then we'll give you a few minutes to speak like we did the other attorney.
Thank you, Mr. Chairman. My name is Marshall Albritton. I'm an attorney in Nashville with the firm of Parker, Lawrence, Cantrell, and Smith, and I've been retained by and represent neighbors that are concerned about this project, including Robbie Lynn Hunsinger and Miss Margaret Littman. And I know that we're speaking only to the issue of deferral at this time. I had submitted a letter to the Planning Commission, which states our position regarding why there should be a deferral. We're concerned about the issue of notice in this case. I understand the technical nature of that there was an original notice sent out that I'm sure identified the place of the meeting being at the normal hall that you meet in, meeting room there at the Planning Commission offices, and that this was subsequently deferred and that COVID-19 intervened, and so the nature and place of the meeting was changed, but no new notice was sent out. So I'm concerned about the adequacy of that notice, not due to the fault of the Metropolitan Government or the staff. It's just that the original notice went out with a place and time, and no new notice went by mail to people to advise them. Now, folks would say you should be checking the website, but I think it would be reasonable for people to have assumed that it was where it had been noticed originally. But secondly, and most importantly, is that, again, not belittling the efforts of the Metropolitan Government or the planning staff, but the nature of this and the nature of the objections. And we've emailed our exhibits in to the planning staff. Having a genuine hearing where people can actually be heard and and see and be present. It's just not possible. It's not a really a meaningful opportunity to be heard, frankly, because of the circumstances. And that's a due process issue. That's bigger than rules and emergency declaration. These are due process issues that interested parties have. And so we want to make sure that you knew our position on that. And for those reasons, we respectfully request a deferral to as soon a date as can be had, where folks can gather and actually have a regular meeting and be heard. Thank you.
Thank you. And we appreciate your time being on the call. Director Kemp has one more item that on this particular issue that she needs to state. Director Kemp.
Well, so I think I guess the question before us right now is one of whether we should add this item to the deferral list. And so I would be interested in hearing from our attorneys, based on everything that we've heard, what the risk is, if any, for placing this item on the deferral, or if what our legal department's view is of how confidently we could move forward if this were deferred. In other words, there's what is the likelihood that this case would be taken to court and the commission would not have had an opportunity to weigh in. I'm concerned about preserving the commission's opportunity to weigh in on the case, and certainly the neighbors' opportunity to provide feedback as well. So could our attorney speak to that?
Yes. Quan, you're recognized.
Hi, this is Quan Poole from Metro Legal again. I certainly don't want to give any guarantees, but it is our opinion that if the commission were to defer this application today against the wishes of the applicant, that's going to be considered an initial consideration, or I guess I don't bad choice words. That could be classified as an initial consideration under 13.4304, and if it is considered or classified as an initial consideration under 13.4304, then the 60-day time period for which the commission must act is going to start. And if no decision is reached within that 60-day time period, it's going to be approved as a matter of law.
Thank you, Quan. But I know that Director Kemp.
What I'm concerned about is that we're hearing from the legal counsel on the other side, or on the applicant, from the applicant, that they view the timing different. I'm not weighing in whether that's right or wrong. We take advice from legal counsel. I just want to make sure that we are preserving the opportunity for the commission to weigh in on this case, and that's the goal. And I think I didn't mean to interrupt you, Chairman. That's all I wanted to say.
No, that's great. And
okay. And so again, I guess, sorry, maybe I probably didn't do a good job answering that question. It's our opinion that with those deferrals, that is basically operating as a waiver of those time requirements at that particular time. Despite that, even under the Mr. Sloan's position, today still wouldn't be the 60th day for which approval must be had. If we were to go back to the March the 26th meeting and calculate what that time frame would be, then there would be another commission meeting on May the 14th before the 60 days would have run, even if it were considered to have started back on March the 26th. Again, it's not our position that the time clock, the 60-day time period would start on March the 26th, but even if the time period did start on March the 26th, then the commission would have one more meeting at least on May the 14th before a 60-day time period would have even run from March the 26th.
Okay. Well, let me put in here to the commissioners is that here's where we're at with this item. We've got two opposing legal counsel. Well, we have three different lawyers expressing different ideas or different ideas on this particular subject. If we defer this item tonight, I would say that the commissioner would probably get into maybe get sued. So that's really, I guess it's really up to this commission to take all of those things into consideration on whether or not you want to put this on the deferral or to defer it tonight or to listen to the case. And so we are now on discussion still. And I think that Commissioner Johnson, your hand is raised on, and is it on discussion?
Chairman.
Yes.
I think most important date is we put this item on the agenda, so we know clock is ticking. But most important discrepancy from applicant lawyer and our Metro Legal is when clocks start ticking. Because applicant lawyer stated in March date, but I believe he spoke March 12th instead of March 26th. So if by any chance applicant lawyer starts saying clock ticking on the first, this item was placed on the agenda, that was March 26th, and then deferred April 9th, and then today. So if applicant lawyer were to take March 26th as a 60-day starting period, we still have one more meeting for us to consider this item, even if we defer the hearing tonight. But if we go with our Metro Legal's date, so that will be today, April 23rd, and then we will have 3 more meetings for us to take up on this agenda. So for that discrepancy, I would like to kind of hear exactly when the clock start ticking. Is it March or April?
Quan?
I think that's sort of the conversation that we've been again, Quan Pool Metro Legal. I think that's the discussion that we have. You've got 2 dates here. The applicant, the attorney representing the applicant, is advocating that his 60-day clock should have started on March the 26th. It's our opinion that if the board, that those deferrals are not considered an initial consideration under the statute, and therefore the 60-day clock would start running from the board's vote of deferral. If that's the way the board so chooses to go against the wishes of the applicant, then that 60-day clock would start from today. Commissioner, you are correct that if you're using March the 26th or if you're using April the 23rd for the 60-day time period, there is an additional meeting available to the commission, regardless of which of those 2 start dates would be used, based upon the statute.
Thank you. I just wanted to clarify because applicant legal counsel used the date March 12th. If that's the date applicant using, we have to hear tonight. But if March 26th is the date, regardless, if March 26th is the date applicant's lawyer represent, that's the day we were to put on the agenda. If they insist March 26th is the day, we still have 1 more meeting. But if I heard applicant representatives mentioned March 12th, that's why I just wanted to making sure exact which date applicant lawyers insisting the starting date.
I'm sorry, Chair, may I ask, are you directing that question to staff or to the applicant? Council Member Johnson. Commissioner Johnson. Old habits die hard.
So just for the clarification purpose, maybe it's prudent for us to hear their side of argument of the starting date.
I think that would probably be a good idea. Is there objection to that? Let's make sure I don't see any. Vice Chair, are you okay with that? State that again.
I am good with that decision.
Okay. Director Kemp, if you could get Mr. Sloan on the line again, that would be great.
This is Doug. I'm on the line.
Mr. Sloan, what is the date that you're using?
Sure, I'm using the March 12th date, and the reason I'm using the March 12th date is that that's the first meeting after 30 days passed from the time the application was filed. The application was filed on February 10th. 30 days from that would be March 10th or 11th. And the next date was so the next meeting was on March 12th. And so that's when I'm saying that the 60 days began to run. And if I could just point one other thing out, is that the commission took action by putting it on the agenda and then voting for a deferral in that meeting. I don't know how there's a distinction from the commission taking a motion and deferring it in March 12th or deferring it today and taking action. Either one, it's the commission considering it, taking an action, and then that's why I'm saying the March 12th date was when the time frame began to run. And if I could just, one other thing, if the commission fails to act within 60 days, the state statute says that the subdivision plat is deemed approved. So I think it's important to know that as well.
Chairman, may I speak of clarification on that from Mr. Sloan? Was the March 12th date the submittal date, or was it the date for the hearing?
It was the date, the submittal date was February 10th.
Okay. So you're arguing that March 12th was the date of the hearing that you submitted for, not the date that you submitted the project.
Yes, ma'am. I'm suggesting that according to state law, that's what's required for it to be on the first agenda, is the first meeting after 30 days, which is March 12th.
Okay, thank you. We appreciate it, Mr. Sloan.
Again, I appreciate the time. Thank you.
All right, we're Commissioner Johnson, did that answer your question?
Yes, thank you.
Okay, and I see we're on discussion, Councilor Murphy.
Chairman Atkins, this is Quantum from Metro Legal.
Yes.
I just want to sorry to jump in here. It's my understanding that there was not a March the 12th meeting. I believe that meeting was canceled outright because of that was the first meeting soon after the announcements about social distancing from the health department. And I don't believe the commission had that regularly scheduled meeting on March the 12th. So the first regularly scheduled meeting would have been March the 26th. If I recall the timeline correct, there was one commission meeting that was just outright canceled by the commission related to COVID-19.
Director, can you confirm? Yeah, let's confirm that. I can't remember what happened yesterday. I'm getting old, so Director.
Yes, I am too. So I just want to confirm. Just give me a moment.
Okay. We're confirming. Hold tight, commissioners. Thank you for your patience. And then Councilor Murphy, I'll call on you in a second. Let's get a clarification on this.
March 12th. The March 12th meeting was the first one that was canceled. The second meeting in March we held, but only moved the CIB.
Okay. Thanks, Quan.
Legal is correct, yes.
Council Lady Murphy?
That was my question as well. Greg, while not going to make a swipe that you're older than me, but I too, at this period of quarantine, have lost track of time, date, and everything in between. But I was also questioning the date of the 12th and whether that, since that meeting was canceled outright, was it on the agenda and everything on that? Was that being, what is the case law or the legal opinion there on whether that counts? But I think Quan basically covered that. So basically, we're throwing out the 12th because everything was canceled out of kind of emergency processes.
Is that right, Quan? That's your opinion.
Yes, that's my opinion, that we didn't have that meeting, so it was outright canceled. The next regularly scheduled meeting would have been March the 26th, the next meeting that the commission took up any items.
Okay, so I want to just to clarify, and gosh, I know that we're still early in the agenda, but just to clarify, so the 12th was everybody got canceled. The 26th, the applicant deferred on his own, but it was we only were considering the CIB that night anyway. And then on April 9th, it was suggested to be deferred because we were deferring a lot of things as we worked out all of these technical situations of how do we hear from people? How do we meet virtually? Do we have to look at each other? Do we just vocalize? And I mean, I'm sure that this is not the only case in Davidson County, let alone across the state, that this is going to be potentially litigated. But I will throw out to you, the Metro Council's executive committee, ad hoc committee, looked at some of these things extensively. And they're just to go back to this, kind of what do we take up, what do we not? In talking to lawyers about what we take up and when we meet and deadlines, there was legal advice, not about this, given to me, about legislation in general. And it was because the executive order is not exactly clear as mud about what can be taken up and what cannot. And I think that this is a murky area, and that's why we have 3 different legal opinions. And quite frankly, I think if this went to court, we might get a 4th or a 5th or what have you. And so really, as a quasi-judicial body and quasi-legislative body, I guess, I don't know, I don't think technically are there. I think we're just quasi-judicial on this one. I think the determination and interpretation is somewhat up to the commission here. Now, I am not an attorney, so this is not adding a 4th or 5th, 6th, 7th, or 8th opinion, but Greg, as an attorney, or Quan, if you want to give us some more advice that maybe this is just something that we need to hear the case on. We need to hear the slides. We need to hear the public comment of the people who have come out, if they have come out, and move forward, because I think that I think at this point, we have split the baby every which way we can. And I think we just need to keep it on the agenda, hear the arguments on both sides, hear the neighbors out, and let's make a decision then. I think at this point, it's premature to make this motion. And I understand that if, I don't know, Chair, correct me if we have a motion on the table or not, but maybe I'm making a motion to table that, and let's get this meeting moving.
Thank you, Councilor. We don't have an official motion to put this item on the agenda. We were on discussion, overall discussion. Commissioner Johnson was about ready to make a motion to put this on the deferral list. So we don't have an official motion, but I want to make sure that we get just out of respect to all the commissioners, make sure that we get all the, if you'll let me ask the question, is there any other discussion on deferral before we get into the council lady's motion? Is there any other discussion in general? I want to make sure if people would raise their hand. And I see Commissioner Sims.
Yes, sir.
So, Council Lady, hold your motion for a second until everybody gets discussion in, just out of respect. I appreciate that, if that's okay.
I think Councilwoman Murphy raised a very good question. Is this quasi-judiciary or quasi-legislative? Because I think that matters in terms of our moving forward in the deferral or not. And I'd like clarification on that for the public.
Council?
Well, with subdivision, I mean, if we're talking about item 31 specifically with subdivisions, it's more of a ministerial function because this body does not, because this type of application doesn't go on to council. So the board is basically in a quasi-judicial role in determining whether an application meets the subdivision regulation. If the board finds that it does meet the subdivision regulations, you're supposed to vote to approve. If you find that it doesn't meet the subdivision regulations, you have to cite to the record material facts or reasons why it doesn't comport to what the subdivision regulations are. So if we're talking specifically about number 31, yes, it is more of a ministerial function.
Thank you, Quan. Does that answer your question, Commissioner Sims?
Yes, it does. I think it has to do with how consistently we are. I like what the attorney from Parker Lawrence basically said, is we don't have jury trials or other important tribunals during this time because we are making a final decision.
Thank you. Any other discussion? So there's been a motion. So Council Lady, would you repeat your motion? Is the motion
Greg,
to approve?
I think my motion was to get moving, so I guess I should restate that into a motion to proceed or a motion to accept the agenda.
Okay, yeah, and it's a proper motion and it's already been seconded. So we are on that motion. Is there any other discussion? And Commissioner Sims, are you raising your hand for discussion, or are you? Vice Chair Farr?
I just, again, I'm clarifying. So Commissioner Johnson never made an actual motion that we would defer item 31. That was just brought up in discussion. So we don't have an additional motion on the table?
No, we don't. And I want to make sure that, we generally try to be pretty lenient on our parliamentary procedure. I try to be lenient. We follow the book. Obviously, we try to be lenient and try to be, to the book. But no, there was not. We had a motion. We had a second. We were on the discussion for the items to be deferred. And then in the discussion, and earlier in the meeting, there was discussion about item 31 being added to the list. So so we are on discussion, but I want to make sure everybody's comfortable voting on the deferral list. So the vote would be to continue to have item 31 be heard.
And we do always have the chance, if after we hear it, if we decide at that point that we do want to defer it and we want to think about these other implications, we'll have that choice again when we hear the item.
Yes.
Got it.
Yes, we will.
Okay.
Commissioners, is anybody else discussion before we vote? So the motion is to approve the deferral list as read, and item 31 will be considered tonight as a public hearing. Any other discussion? I'll make sure. Seeing none, we will go for roll call. Vice Chair Farr.
I approve. Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson. Commissioner Johnson? Can you repeat?
Aye.
Commissioner Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
Ayes have it. 9 ayes for those items to be deferred. And just for clarification, item 31 will be heard still on public hearing. So we are now on to the consent agenda. Lisa, I believe it's Lisa. Lisa?
Sorry, I was trying to get myself unmuted.
Oh, there we go.
Yes, apologies. We have the following items that are recommended on the consent agenda. Before I do that, just let me read something into the record here. Items on the consent agenda will be voted on at a single time. No individual public hearing will be held, nor will the commission debate these items unless a member of the audience or the commission requests that the item be removed from the consent agenda. And as information to our audience, if you're not satisfied with a decision made by the Planning Commission today, you may appeal the decision by petitioning for a writ of cert with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Planning Commission's decision. To ensure that your appeal is filed in a timely manner and that all procedural requirements have been met, please be advised that you should contact independent legal counsel. Our consent agenda begins on page 9 with item number 21. Item number 21, 2020Z006TX001. It's a request to amend Titles 6 and 17 of the Metropolitan Code, the zoning requirements pertaining to short-term rental properties. Staff recommends approval of the amendments to Title 17. Item number 22, 2020Z007TX001. It's a request for an ordinance amending Metropolitan Code Chapters 1564 and 1720 to require all driveways to have an apron to be paved with a hard surface and to prohibit the runoff of gravel into the public rights-of-way. Staff recommendation is to approve amendments to Title 17, including a substitute to clarify that this applies only to construction of new driveways. Item number 23, 2020S039001, Pine View Cottages. This is a request for concept plan approval to create 42 lots on a portion of property located at Dickerson Pike at the current terminus of Tuckahoe Drive. Staff recommendation is to approve with conditions, including additional conditions that the developer agreed to regarding off-site road improvements. Item number 24, 2006 UD 001002, Twice Daily. It's a request to modify the standards of the Metro Brentwood Town Center Urban Design Overlay for properties located on Old Hickory Boulevard to permit a convenience store. Staff recommendation is to approve the modifications with conditions. Item number 25, 2020S081001, Woodlawn Subdivision. It's a request for final plat approval to create 4 lots on properties located at 3700 Woodlawn Drive. Staff recommendation is to approve with conditions. Item number 26, 15877P006, the Hickory Hollow Retail Commercial PUD revision and final. It's a request to revise a portion of the Hickory Hollow Retail Commercial Planned Unit Development for property located on Bell Road to permit an automotive service use. Staff recommendation is to approve with conditions. Item number 27, 2020 HL 003001 at 2001 Lebanon Pike. It's a request to apply a historic landmark overlay district on property located on Lebanon Pike. Staff recommendation is to approve. Item 28, 2020 HL 004001, 421 Church Street. It's a request to apply a historic landmark overlay district for property located at 421 Church Street. Staff recommendation is to approve. Oh, and apologies. Item number 37 under other business to accept the director's report.
All right, commissioners. Thank you, Lisa. We are on item F, which is the consent agenda. And let me read these numbers and make sure we're correct. And that is, these items will be on the consent agenda. Item number 21, 22, 23, 24, 25, 26, 27, 28, and 37. Is that correct, Lisa?
It's correct. I also wanted to check in with our team at the courthouse location, remote location, to make sure that there is no one there. And after that, to check in with our team at the call center to make sure we don't have any calls. So Greg first.
All right, Greg, you're recognized.
This is Greg Claxton with the Planning Department at the courthouse. There is no one here with comments on the consent agenda.
Okay, thank you, Greg. And are there any call?
This is Lucy at the ITS call center. We do not have any calls to remove items from consent, but I would recommend giving 30 seconds or so, Chair, to see if anyone calls.
All right, let's all take a pause then. 30 seconds. Let us know in a minute, Lucy. Give them a minute.
Yes, sir. I should have brought the Jeopardy theme song over here, Chair. I'll do that next time.
Yes.
We have not received any phone calls that would remove an item from consent.
Okay, and if somebody would, so we are ready for a motion to approve the consent agenda. Commissioner Gobble, you're recognized.
I move approval of consent agenda.
All right, and Commissioner Johnson, you want a second?
Yes, Chair, I will second, and I would like to inquire earlier this evening, Council Lady Henderson and Councilmember Pooley both stated they would like to see agenda item comes. So should we invite them to speak at this moment before we take any action?
Of course, I would love to. Let's see if Councilman Pooley, are you?
No, I don't need to speak. If I'm here to speak, if anybody has any questions, but if it's going on consent, I'm just going to keep my mouth shut and let that ride.
Okay, thank you, Councilman. Council Lady Henderson. Let me see. There. Oh, yeah, Council Lady Henderson. I see her on the app, but I can't hear her. Can anybody else hear Council Lady Henderson? Any other?
It's not Council Lady Henderson that's on this bill. It's Johnston.
Oh, Council Lady Johnston, you're recognized. Sorry about that. Council Lady Johnston?
Yes. Can you hear me?
Yes.
I'm sorry. I've been toggling back and forth between the computer and the phone. So I'm in the same position as Councilman Pulley. No need for me to speak if it's on consent unless anyone has any questions.
Okay, commissioners, any questions? I don't see anybody raising their hand. We'll make sure, or by voice. Seeing none. Commissioner Johnson, you're recognized for.
Thank you, Chair.
Oh, forgive me. This is Lucy. I apologize for interrupting. I got a text from Councilwoman Henderson, who does not wish to speak on this item.
Oh, perfect. Okay, thank you, Commissioner. Thank you, Director. Anybody else before?
Yes,
Commissioner
Chair.
Johnson?
One quick clarification. Item number 22, Title 17 revision, and I believe the proposal does not apply to existing driveway, but only apply to new development. But I think the text does not clearly state it, but just wanted to clarify with the staff. That's the intent.
Lisa?
That is the intent, and we specifically included it in the motion to say that we were approving the amendments to Title 17, including a substitute to specify that this would apply to construction of new driveways.
Great, thank you.
All right, Commissioner, are you making a second? Is that correct?
Yes, Chair. So I second.
All right, any
consent agenda.
Okay, perfect. Any other discussion? Please raise your hand or let us know. And seeing none, we are on roll call for approving the consent agenda. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
All right, ayes have it, 9-4, none against, and the consent agenda passes as reported. And now we are on to items to be considered, which are the public hearing items. And that leaves us, just for clarification for everyone, and y'all make sure I'm correct on this as well, is that we're going to hear 5 cases tonight, and that would be items 29A and B, item 30A and B, item 31, item 32, and 33A and B. Is that correct, Lisa?
That is correct, Chairman.
Okay, thank you. And so we are on to the items to be considered. But before we hear the items, I want to remind everybody we're getting a little bit of feedback. So if you could sound feedback. So if everybody would make sure that they mute their line after, or make sure you're muted, and I appreciate that. So in order for us to do this tonight for the public hearing cases, I want to go through the process of how the commission and Lucy and I and the vice chair, we've tried to be as transparent as possible. So for the commissioners and listeners at home, we have provided multiple ways to participate in this telephonic meeting. Normally, as y'all know, we take the applicant first, then the supporters, and then the opponents. Because of the different ways, actually 4 different ways that people and the public can participate, we have to take the supporters and opponents together. And so I want to make sure everybody, when they're speaking, make sure that you clearly state your name, your address, and then if you're an opponent or a supporter or an opponent. To help us, please make sure that you state your name for the record, since we can't see you, and your address, and whether you support or don't or oppose the particular request. As usual, the first way that we took public comment was by email through comments, and we did that through Tuesday at 3 o'clock at the start of each public hearing. Today, Lisa will give a summary of how many email comments we were received on each particular item. Secondly, we also took voice recordings through Tuesday at 3 p.m., and those will be played live during this particular meeting. I want to thank everyone who took time to call in advance and keeping your comments within 2 minutes, or trying to keep it within 2 minutes. We appreciate this new process, that particular new process. Thirdly, we have a call-in number for members of the public who wish to call in and testify. Please wait. This is going to take some time. Please wait until the public hearing for your item begins before calling. And it's in a queue. And so we don't want you testifying for the wrong case. So we want to make sure that you're in the right case. Fourth, we have we have a remote location at the Metro Courthouse where folks will be observing social distancing, meeting CDC guidance. I want to thank the staff for being there and helping with that while the public is waiting to testify. And so, Lucy, can you identify who is the lead at each location, just for the commissioners to know?
Sure. So Lisa is going to read in the number of comments and reference those. And then we at the call center will play voicemail and recordings that we've received, and we'll loop in direct live call-ins to the commission during the public hearing. And then lastly, Greg Claxton was and is physically at the courthouse to see if anyone is there and wishes to also speak directly to the commission.
Okay, perfect. So for each items, we'll start by taking the testimony from people at the courthouse to minimize the amount of time they spend in line there. We want everyone to be safe. And then after that, we'll then play the voicemails and ask people who wish to call in who left us a voicemail. And so we appreciate everybody's patience. We advertise this on all of our materials. You saw it in the beginning of the comments that were submitted to you. So I've already told you which items we're going to hear tonight. And so now I believe, are there any questions of the process? I want to make sure by the commissioners. I want to make sure that if you'll raise your hand, or is there any questions? Vice Chair, are you good to go? I feel like we've got a pretty good process.
I'm good to go.
Okay, so I don't see any of the commissioners raising their hand for questions. Don't hear anybody either. So, Lisa, we are ready, I believe, for the first item. And why don't you start on item 29A?
Chairman, can you confirm, sorry, Lisa, can you confirm that everyone sees the slides, and the slides should be on your screen? So if commissioners can let me know if they don't see a map of Davidson County with a big star on it. Sorry to interrupt. I just want to make sure everybody has the information.
Commissioners, you all see it?
Okay. Thank you.
All right. I don't see anybody raising their hand or asking questions. So go ahead, Lisa.
Jason Swagger is the reviewer, and he'll be presenting this item.
Oh, I'm sorry. Jason, my apologies. Thank you, Jason.
Jason, you'll have to unmute yourself on WebEx.
Can you hear me? Hello?
Yes, we've got you.
Okay, I hope everyone is safe and well. This is Jason Swagger. I will be presenting items 29A and 29B. For a start, I would like to say that I'm finally able to present in my tuxedo t-shirt. While I'm presenting these two items together, the commission must vote on each item separately. Next slide. This is a request to rezone property from OR20 to OR40 and cancel a portion of a planned unit development overlay that applies to the property. Next slide. The approximately 2.5 acre property is located along Shepherd's Hill Drive and is outlined in blue. The area highlighted in red is the remainder of the overlay. The subject property includes a surface parking area, and the remainder of the overlay that is not part of this request includes 2 commercial buildings.
The adjacent property to the east along Shepherd Hill Drive is classified as an office. Next slide. Staff is recommending approval of both requests. The existing zoning is OR20, which permits office as well as residential uses. However, in this case, the overlay limits development to commercial. The proposed OR40 zoning district permits office and residential with a density of approximately 40 units per acre. Next slide. This is in the Madison Community Plan, and the policy is regional center. This policy is intended to create enhanced areas for intense mixed-use centers that serve a large area. The policy that applies to the adjacent office building to the east, this transition is intended to serve as a transitional area between the Gallatin Pike commercial corridor and the existing single-family neighborhood to the east. Next slide. Staff finds that the proposed OR40 zoning district is consistent with the policy. Dense housing adjacent to intense commercial corridors is appropriate as it provides bodies to support nearby businesses. Residential and office uses also provide a transition between the commercial area along Gallatin and the residential neighborhood to the east. Since the overlay limits development to only commercial, then the overlay needs to be canceled to permit any residential uses. Since the proposed OR40 zoning district is consistent with the policy, then staff is recommending approval of OR40 and the cancellation of the overlay that applies to the property. And as a reminder, each of these items must be voted on separately. Thanks. That concludes my presentation.
Thank you, sir. Are we going to do B now, or are we going to?
He presented both of them together.
Oh, good. I'm sorry. Thank you, Jason. We appreciate that. So we'll open this like normal. We will open this item up for a public hearing. And I believe that the applicant is on the line, right, Lucy? Or getting on the line? Director Kemp, are you there?
Chairman, this is Sean Shepard in the ICS call center, and we do have the applicant on the line. We can enter him into the meeting if you're ready.
We are ready, and we appreciate it.
Hello, can everyone hear me?
Yes, welcome. And just as a reminder, you have 10 minutes as the applicant, and you can save 2 of the 10 minutes, and Sean is going to let you know when that 2-minute point comes up. Welcome, and please state your name and address.
Thank you. Tripp Smith, SNH, address is 2606 Eugenia Avenue. We are the civil engineer and applicant on the project. I'm not sure much else I need to say, and I'll try to keep it brief. From Jason's presentation, I will say we met with staff late last year, kind of talked to get some clarity on what was involved in the PUD overlay, as the client was considering pursuing a hotel per the approved PUD plan from '98, I believe. But then after coordinating with staff and the council member, sounded like the best use for the parcel was to cancel the PUD and continue either with the base zoning at OR20 or move to a more intense zoning, which was supported, as Jason said, with the T5RG policy. Outside of that, and feel free to correct me if I'm wrong, I think this item would have been on consent agenda unless it had, but there was opposition from one resident on Shepherd Hill Drive. We made an effort at the councilman's request to reach out to that resident, and we did not hear anything back. I believe we were notified of the opposition email around April 3rd, reached out shortly thereafter and never received a response from that opposition. So I will save the 2 minutes for rebuttal in the event that opposition wants to speak or that I can answer questions. But I think that concludes what I need to say.
Thank you, sir. Appreciate you on the line today. And we'll save 2 minutes your time for rebuttal. Now we are on to the remote location. So, Mr. Claxton, is there anyone at the remote location?
There was no one at the courthouse to comment on this item.
Okay, thank you. I appreciate that. Now we're on to the call-in section. And Lisa, have you received any voice messages on this particular item?
We have not received any voicemails on this item. We received one email. And Sean will let us know if there's any live call-ins.
Okay. Thank you.
Chairman, this is Sean Shepard. We do not have any live call-ins on this item.
Okay. All right. And so there's no other opposition other than the one email. Is that what I'm hearing then?
That's correct.
Okay. Well, seeing no other one wishing to, before we do that, is the council person on this item on the call?
Councilmember Zach Young is the council member representative, and he is not on this call.
Okay. And so I don't believe that there's a need for a rebuttal. And so unless the applicant wants to say anything else, does the applicant want to say anything else?
Yes. Can you hear me?
Yes, we can hear you. Go ahead.
Yeah, I will just add that we did send an email to the effect showing the councilman's support of the project. He requested that we show him a rough conceptual plan, and then I believe I sent an email to the Planning Commission inbox that was a copy of that correspondence with him indicating his support of the rezone and the PUD cancellation. That's it.
Okay, thank you. Appreciate that. Seeing no one else wishing to speak and hearing no one else wishing to speak or no other emails, etc., close this item for public hearing. And commissioners, we are now on to discussion. And so for this particular item, let's try it this way instead of just going through the list. If any of the commissioners would like to speak, please raise your hand, or we'll try it that way first. I'm looking through the app and making sure if anybody wants to speak by voice, say so. Let's try this. Let's try a motion. That way we can kind of move the meeting along. I know we're going long. Is there a commissioner that would like to make a motion? We have Vice Chair Farr. Would you like to make a motion?
I will make a motion that we approve staff's recommendation on, oh my goodness, I just lost the item number. Item 29?
Yes, and we're going to do.
I was going to do 29A.
Yeah, so we'll do both. So 29A first. And
yes. So I would like to make
proper motion.
Yes, you got it.
Proper motion. And Councilor Murphy, you're recognized.
Second.
And you second that motion. Any discussion? I'm looking. Any discussion from the commissioners? Seeing no other discussion or hearing, we'll do roll call. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tidd.
Aye.
Ayes have it, 9-4, none against, and item 29A is approved. Now we're on 29B. Vice Chair Farr.
I will make a motion that we approve staff recommendation of item 29B.
That's a proper motion. Is there a second? Need some hands. How about Councilor Murphy? You made the last second. Councilor Murphy.
Second. Motion.
Second. And any other discussion on 29B? And I'm not seeing any or hearing any, so we are now on roll call vote for 29B. Vice Chair Farr.
Aye.
Mr. Gobble.
Aye.
Mr. Haynes.
Aye.
Mr. Johnson.
Aye.
Mr. Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
Ayes have it, 9-4, none against. 29B is approved. Now we are back on to, not back onto, our next item is item 30A. And we're gonna, who's the staff member going to present that? Is that Jason?
Yeah, it's Anita McKay.
Oh, Anita, hey.
Hi, Commissioners. So I'm presenting the amendment request for the Southeast Community Plan. Next slide, please. Here's the I-24 corridor. The study area is outlined in bright pink. The Bell Road interchange is immediately north, and to the northeast is the Hickory Hollow Global Mall area. The crossings area is east of the interstate, and the Hickory Hollow Parkway interchange is connected to the study area, and the new interchange portion is under construction. Old Franklin Road abuts the study area to the south and connects across the interstate, and Cane Ridge Road connects the study area to the west. Next slide. Here's a closer view of the area. Staff recommends approval of the plan amendment. Next slide. A bit of background. In 2015, the policy was changed to district destination retail. We wrote supplemental policies to assist the applicant in crafting their specific plan. In 2016, the owners added a property to the development. They wanted to use it for residential uses, so it didn't require a policy change at that time. Next slide. Now the owners wish to add another small property, which does trigger the need for a plan amendment. In this case, the area is designated for a mix of uses in their specific plan. It's also an opportunity for us to simplify the supplemental policies now that the SP has been in place for a few years. It's important to note that the applicant is not requesting any additional entitlements beyond what they are already allowed to build today. Next slide. Here's the Nashville Next Growth and Preservation Concept Map. In red is the large Hickory Hollow Crossing Center area. Next slide. Currently, several policies converge. The district destination retail area is in dark blue. The Hickory Hollow Center is in purple, including the portion adjacent to the study area. The Crossings area, suburban mixed-use corridor, district employment center. To the southeast in bright green is the Mill Ridge Regional Park. To the south is Suburban Community Center. Civic policy in bright blue abuts the development. To the west and south is Suburban Neighborhood Evolving. And conservation features of waterways and steep slopes, shown in green, are found throughout the area. Next slide. Also, the transportation network shows the area's connectivity. I-24 has interchanges at Hickory Hollow and Bell Road. Bell Road is designated as an arterial. A portion of Cane Ridge Road is also an arterial. Old Franklin Road and Preston Road are collectors, and Crossings Boulevard is an arterial. Next slide. Planners work with Councilmember Stiles and community organizations to hold 2 community meetings. At those meetings, the community shared concerns, including the removal of natural features and large trees across the site, as well as their wish to ensure quality development standards. The community also expressed enthusiasm for new development, jobs, and services. Next slide. Now for the details of the amendment request. The applicant's first request is to add this small property. It's about 3 acres located along the north side of Old Franklin Road to their development's district destination retail policy. As you can see, currently it is surrounded on 3 sides by that policy. Next slide. The development area currently is guided by supplemental policies shown in red outlines that were put in place in 2015 to assist in creating the specific plan. As of now, there are 4 areas. Next slide. The current supplemental policies focus on being pedestrian friendly, providing travel and housing options, and transitioning to less intense uses abutting the surrounding residential area. Next slide. In order to simplify the supplemental policy, staff recommends removing 2 areas and focusing on the transition area along the western edge. Next slide. The supplemental policies for the transition area currently, as they're written, are repetitive, and so they can be combined into one area. Next slide. To recap, staff recommends one small property be added to district destination retail policy, to delete 2 supplemental policy areas, and to combine the remaining 2 areas into one supplemental policy to address transitions. Staff recommends approval. Now Patrick will present the associated rezoning request.
Patrick, you on? Patrick, you may have to unmute yourself, sir.
Okay, audio check.
Yep, you're there.
Okay, this is Patrick Napier from Land Development presenting the associated SP amendment, item 30. Next slide, please. This is a request to amend signage and development standards, revise sub-district boundaries, and to add 2.92 acres into the SP. Next slide. Staff's recommendation is to approve with conditions and disapprove without all conditions if the associated plan amendment is approved, and disapprove if the associated plan amendment is not approved. Century Farms history. The Beeman Turner Properties SP, referred to as Century Farms, was originally approved in February of 2015 and has since undergone 2 previous amendments. The amendment in 2016 to add acreage and the amendment in 2017 to amend signage standards. Next slide, please. The current zoning for the site is specific plan mixed use. Specific plan mixed use is a zoning district category that provides for additional flexibility of design in order to provide ability to implement specific details of the general plan. AR2A requires a minimum lot size of 2 acres and is intended for uses that generally occur in rural areas. The proposed area for the addition of the SP is currently zoned AR2A. Next slide, please. Current policy for the site is T3 neighborhood evolving, which is intended to create and enhance suburban residential neighborhoods with more housing choice and improved connectivity. The district destination retail policy is intended to enhance and create districts where large footprint, auto-centric retail and complementary uses may draw for regional or multi-state areas. Conservation policy is intended to preserve environmentally sensitive features and land uses through protection and remediation. The proposed policy, the area which is proposed as an addition in the SP currently contains T3 neighborhood evolving policy. As stated in the previous presentation, the community plan amendment proposes to change the land use policy applicable to the 2.92 acres of land, which currently contains the T3 neighborhood evolving policy, and will be changed to district destination retail to match the remainder of the SP. Note that the conservation policy is intended to remain on the site. Next slide, please. The image you're seeing now is the currently approved sub-district map for the Century Farms SP. The area highlighted in red on the left-hand portion of your screen is the area that will be added with the amendment. Next slide, please. This image currently displays the proposed changes within the SP regarding the sub-district locations. The primary intent of the amendment is meant to shift the internal boundaries of the sub-districts, modify signage standards for the retail sub-district along Interstate 24, and to add acreage as previously stated. The modifications to the signage standards along the interstate are consistent with the intent of the district destination retail policy. No increase in entitlements regarding height or dwelling units is proposed within the amendment. No increase to the allowed floor area ratio is proposed within the amendment, and the approved floor area ratio will remain as approved within the previous amendment. The floor area ratio stated within the SP is meant to allow flexibility of design when various sites are developed. The area added to the SP will be located within the office concentration sub-district in the left-hand portion of your screen. The amendment serves to shift the location of existing development entitlements internally to the site. While a broad range of uses are allowed within the SP, the limitation of height, parking, and stormwater infrastructure, as well as landscape buffers, will impact final bulk when structures are constructed within the SP. The proposed amendments maintain the pedestrian facilities proposed within the current SP to increase walkability and connectivity within the larger neighborhood. Additionally, sensitive environmental features will continue to be preserved and utilized to enhance the proposed development. Residential and neighborhood transition subdistricts located on the perimeter of the development to provide transitions to the surrounding area will remain. Next slide, please. In conclusion, staff's recommendation is to approve with conditions and disapprove without all conditions, subject to the approval of the associated plan amendment. Therefore, staff recommends approval with conditions.
Thank you, Patrick. We appreciate that. And so now we are ready to open this item for the public hearing. And I believe Sean is the applicant ready to speak.
Real quick, I apologize for interrupting, but I just need to recuse myself from this.
Okay, so noted. Commissioner Tibbs recuse herself.
Chairman, this is Lucy. Forgive me for interrupting. I'd like to suggest that we recommend if folks want to call in live to the commission that they begin calling in now while the applicant is speaking so we can queue them up if we do have callers.
Okay, let's, please, as the director has said, let's encourage callers to call in, and very good advice. Thank you, Director. And Sean, do we have the applicant on the line?
Chairman, we do have the applicant on the line for this item, and she's going to be live right now.
Hello.
Hi, it's Catherine Withers. Can you hear me?
Yes, and if you will, yes, please state your name, address, and all that.
Okay. All right. This is Catherine Withers. My address is 615 3rd Avenue South, Suite 700. I'm a planner with Barge Design Solutions, and we are representing Century Farms LLC in these applications. We really appreciate the efforts that the Commission and Metro Planning and IT staff have put into making this meeting happen today, and thank you. The two applications before
you start, you'll have, out of your 10 minutes, you can save 2 minutes for rebuttal. Appreciate you being on the call. Thank you.
Yes. The two applications before you represent what amounts to a housekeeping amendment to add an almost 3-acre parcel at 3141 Old Franklin Road that staff commented was surrounded on 3 sides by the Century Farms development. And we would pull that into the SP and then also amend the SP to accommodate a long-awaited retailer, as Councilmember Stiles mentioned in her comments. And no additional density beyond the previous approval is requested with this application. The SP was first approved in 2015 after much community input. Since that time, the development team has attended 30-plus community meetings over the last 5 years and has become an active member of the community. We participated in 2 community meetings on this particular change before you today, and attended CNAP meetings during this time and have been working closely with Councilmember Stiles in the process. So in the past, the plan was amended before, first to add acreage and then to revise it to make way for IKEA within the retail subdistrict. And as you know, IKEA has chosen to not expand their building footprints. So the developers had to rethink the site. So that led to the changes that are included in this application. So with this amendment, the key change is that the retail district has been split in 2, shifting a large part south towards the new interchange where land is flatter and better able to accommodate them. We've heard the community very much wants to be able to buy a pair of socks without having to drive to the next county. So we're very excited about the opportunities that this retailer is going to provide for folks living in the community to be able to spend their tax dollars here in Davidson County. So with this amendment, this request to add the 3-acre parcel is because its previous owner decided to sell, and the property was only left out of the original change because that owner didn't want to be part of it at the time. So now it doesn't make sense for it to be left out in the neighborhood policy since it's now owned by the applicant. As mentioned before, these applications are not proposing an increase in density. The boundaries have been balanced so that we're not deriving any additional square footage. The basic premise of the development to be a mixed use with different uses is still present. TDOT is currently working on the long-awaited Hickory Hollow interchange, which will open interstate access up on the south side of I-24 to the rapidly developing portions of Antioch and southeast Nashville. The Century Farms development is constructing over 2 miles of road that will link this interchange up with the existing street network. TDOT is on schedule to complete this interchange in a little over a year from now. The system of connector roads will be in place this fall, several months prior to the interchange opening. Included with those roads are 4.4 miles of 12-foot wide multi-use sidewalks along the Parkway Road network. And as part of the TDOT project, there will also be a pedestrian and bike pathway across I-24. So we're very excited that pedestrian and bike access across I-24 in Antioch is happening. So the Century Farms development is a positive change for the community and has already brought 2,000 jobs to the area with the first tenant, Community Health Systems. Under construction right now is a freestanding ER and the first residential offering. In the review process is a medical office building, and on the drawing board are restaurants, shops, grocery stores, and hotels for future phases, so that residents will be able to live, work, and play within the community and not have to drive long distances to the amenities that they're currently missing. We respectfully ask for your support of these applications. We accept the conditions of approval and will continue to work with Councilmember Stiles through the process. Thank you.
Thank you, and we'll reserve your 2 minutes for rebuttal. Did she have 2 minutes left, Sean? We'll make sure. I believe she did.
Yes, Chairman. I was running the timer and they had well over 2 minutes left, so we'll start them with 2 minutes at the rebuttal if there is one.
Perfect. Thank you. We'll reserve 2 minutes. And now we go to our remote location. Mr. Claxton, is there anyone there wishing to testify on items 30A or 30B?
There is no one at the courthouse for this item.
All right, thank you. And then we are now on to the voice call-ins. And Lisa, have we received any voice messages on this item?
We have not received any voicemails. We have received 4 emails.
And were they for or against the project?
1 against, 3 in support.
Okay, thank you. And we are now to the point where if anyone wishes to call in on this item, they should be placed in the queue now.
Chairman, we do have some live callers, so we'll be sending those in just shortly. The first one should be coming in momentarily.
Okay, I want to thank everyone who called in.
Are you ready? Okay, thank you. Chairman, we do have some live callers, so we'll be sending those in just shortly. The first one should be coming in momentarily.
Okay, I want to thank everyone who called in.
Hey, caller?
Yes.
So, and before, on this call-in piece, we're not able to display the timer visually, but Sean will keep track of time, and she will also give a 30-second warning when the time is up. Do we have any callers on the line yet, Sean?
Chairman, we do have, it's the same caller. We have reminded this caller, and we will remind all our callers, that if they are watching the live stream or the television while they're calling us, they need to mute their computer or their television before coming into the call, because otherwise we get feedback. There's a little bit of a lag on the TV stream. So for this caller and all callers, if you call in live, please mute your television before you're placed into the meeting. And at this point, we will place that caller back into the meeting right now. And I'm being told they're in the meeting now.
Okay. Is the caller on the line?
Hi.
Hi, this is Chairman Atkins. I hope that you're doing good today. So thank you for calling in. And what you'll need to do is state your name, your address, and if you're for the proposal or opposed to it. And then you can, and then give us your thoughts.
Thank you. I'm Twana Chick from the Cane Ridge community at 5967 Cane Ridge Road, here with 4 areas of concern. We are asking for deferral on the 2 items to allow for addressing all concerns. First is the lack of repairing or improving Cane Ridge Road between the 2 roundabouts. They claim it is Metro's responsibility to fix between the roundabouts because Metro Water tore it up during improvements, but these improvements were done for developers. As Mayor Cooper recently demonstrated, Metro can save money when we hold our ground. Hold this developer responsible for improving and repairing this section of roadway with shoulders and repaving. Metro should not accept more financial burden. Leaving that section completely unimproved only serves to funnel traffic into a commercial development. This omission will place unreasonable and unnecessary future costs onto Metro government. Second, we in the community have asked for 2 decades for sidewalks on Cane Ridge at the apartments. Century Farms plans do not include sidewalks or pedestrian crosswalks for this chunk of Cane Ridge where over 2,000 people live in Chimney Top, Summit, and Bell Hollow apartments. What sense does it make to place shopping or employment within walking distance of 2,000 people and not finish a section of sidewalk to get there? Our third issue is the height of the proposed sign. Much of this land sits above I-24. They are asking for an exemption to erect a sign of 110 feet, even though it would already be setting way above the interstate. They said that they already promised this to their tenant before approval, as was just confirmed by Councilwoman Stiles. There is another commercial development of several hundred acres.
30 seconds.
In Councilwoman Lee's district. A variance here may create a precedent that causes that developer to also seek a variance. Not allowing the next development the same exemption may set us up for expensive and unnecessary litigation that will cost Metro, and we can't afford that regardless of council lines. We should be fair and consistent to avoid legal challenges. Finally, our community is dissatisfied with the lack of undisturbed planned green space. The recent request by Councilwoman Stiles to join in a landscaping committee for Old Acre McDonald notwithstanding, these plans...
Holly, your time is up. Please finish your thought.
Well, I'm sorry, what?
That's your time. Please finish your thoughts. Thank you.
Okay. These plans do not reflect sufficient undisturbed landscape, especially in light of them requesting to add 2.92 acres, which is a net gain of 1.0 acres of green space. We are asking for deferral to address these concerns. Thank you.
Thank you. Appreciate your comments very much. All right, Sean, we're ready for the next call in.
We're placing the next caller in now.
Hi, we are getting ready to conclude the meeting. We'll have 2 minutes to take your comments. Please state your name, address, concern, support, or opposition to the item. Are you ready? Okay. Okay.
Chairman, this particular caller is representing a neighborhood organization, and they have requested 5 minutes. So I will be running the timer for the 5 minutes as requested, unless you interrupt at the beginning and tell me otherwise.
No, 5 minutes. Thank you.
About a slide presentation.
Is the caller on?
Put them on.
Okay, I do not. Oh, we do have a slide presentation that is on. And
Thank you.
Hello, how are you? Welcome.
Yes, good afternoon, Mr. Chairman. My name is John Stern, and I'm speaking to you in my role as president of the Cane Ridge Community Trust, 6688 Nolensville Pike in Cane Ridge. This is certainly something new. I appreciate all the work that's gone on to get us this far. Specifically, we're concerned about a number of things, not the least of which is the amount of information that the developer had promised to give the community so that we could properly evaluate what was going on with this plan. I first got involved in it about a year or so ago, and I met with the principal of the development, and he hooked me up with Hunter G. And Hunter and I had a great talk about creating a very positive mixed-use development in the community. But then I think they fired Hunter and brought Barge on. So what we got is really no movement in the quality of what is a huge development. I know y'all reviewed the Nashville Yards recently. It had 3.5 million square feet of office, 1,000 residential, something like 400,000 retail. And let's get in and take a look at what this is. Next slide, please. Are y'all seeing the slide?
Yes, I believe we are. Yeah.
Yes, they're on.
Thank you, Lisa. Have we lost Mr. Stern? We can't hear you, Mr. Stern. Sean, have we lost him?
Chairman, we have just received the call again. He was dropped off, so we're in the process of putting him back in. I have paused the timer.
Okay, we are going to put you back in.
Okay, he is back in now.
Thank you.
Hey, sorry. I'm not seeing a slide, but are you guys? There we go. Next one, please. Next slide, please.
I did advance the slide.
Okay, well, it's not advancing here. What do you guys, let's try a, it's not.
Chairman
I'm not.
and caller, I have paused the timer. I wanted to interject here and say that depending on how Mr. Stern is viewing this meeting, there may be a lag between what we see on our screens and what he sees on his screen. So he might be more comfortable just trying to proceed with his verbal comments because it may be that there's a few seconds of delay before he sees the slides. They are advancing on our end, but that's just a function of the stream. So
okay. All right. Yeah, it's taking like 45 seconds to advance. So right there, you're looking at a marketing piece that is put out by the developer showing you what is planned and what currently exists on the property. You'll notice that their proposal and the development that they're selling goes all the way to Bell Road and all the way then up Cambridge Road to Old Franklin Road. You'd go to the slide that says Century Farm Entitlement. I was working on making a point regarding the immensity of it. As I said, the Nashville Yards development was a little under 5 million square feet. When we first got this, we went in and asked Metro Planning and the developer what their entitlements were, and neither of them were either able to give it to us or were not unwilling to give it to us. So we created a demonstration, or we created calculation based on the information we had. In fact, the entitlement for just their office is up around 18 million square feet. And they've been selling or been telling the community that it's at most 5 million. To understand the size of this thing, we have the remnants of what is the Hickory Hollow Mall. It's now a hodgepodge of excellent uses, but it's not a very attractive thing in our community. This development is 3 times the size of the entire mall. If you it is the size of 700 football fields. And looking further into it, if an inch of rain, on the next slide, if an inch of rain was to drop on this site, it would produce 7.4 million gallons of runoff. Now, I'm sure that's an issue that they'll be dealing with later, but this is an immense project. It is the largest project in Davidson County.
Caller, you have 30 seconds.
Great. Defer, please, and the developers failed to give us information. We would appreciate it deferred until a time when we can actually converse. The developer has refused over and over to provide traffic studies, detailed landscaping plans, design plans. It is for a site this big. We really
Caller, your time is up. Thank you.
Well, thank you all. I appreciate your patience, and we'll look forward to the time we're able to see each other face to face.
Thank you, Mr. Stern. I appreciate your comments. We are on to, do we have another caller, Sean?
Yes, Chairman, we do have another caller, so we'll be adding that person in just a moment.
Thank you.
I'm sorry, don't. That's what I thought. Okay.
We're doing some clarification with the caller that we have on the line about their preferences regarding being put in the meeting. Hold on just a moment, please.
Thank you. Commissioners, thank you for your patience. We knew this would be a long process, but I feel like we're getting through it pretty good.
Okay, Chairman, we have confirmed that the caller we had in the queue did not actually desire to be placed into the meeting at this time. And I'm looking at my counterparts here in the call center and seeing that we do not have any other calls in the queue. So I think at this point, the live call-ins that we have available have been put into the meeting, and you can continue with the public hearing.
Okay, thank you very much. And we are now seeing no one else wishing to speak. The applicant has 2 minutes, and then we'll ask the council member if they want to speak. So let's put the applicant back on the line. 2 minutes.
Chairman, the applicant should be live to speak, and I'll be running the timer for 2 minutes.
Great. I'm here. This is Catherine Withers here.
Good.
Okay. So just a few comments we wanted to address. Metro Water Services is repaving the road that they've damaged. The Cane Ridge Road, we can't build the sidewalks off property. They're owned by someone separately, and there is not enough right-of-way in Cane Ridge Road for us to continue sidewalks off-site. The traffic study is posted on the developer's website, and Councilmember Stiles is going to distribute that information. And then also, stormwater will be managed within the development to meet all water quality and quantity regulations. The post-construction stormwater runoff rates will be equal to or less than the redevelopment rate, and water quality standards will be achieved through a series of filtration measures, including mechanical best management practices, bioretention, pervious pavement, and other low-impact techniques. So that will all be included in future development. Oh, and also Smith G is still under contract to work with us on this site. That's all I have.
Thank you. And we want to see if the councilwoman wants to speak. And I think, Director, does the councilwoman want to speak?
Thank you, Chair. I am,
Welcome.
yes, I am actually okay with the comments that I made at the very beginning of the meeting.
Okay.
Thank you.
We appreciate it. Thank you very much. And seeing no one else wishing to speak, we'll close the public hearing. And we are now on to discussion. And how about Vice Chair, do you want to start us off?
Sure. I must say that the scale of this project, as was pointed out by Mr. Stern, is amazing. I don't think I had quite figured out how significant it was. That said, it does seem like a fairly well thought through plan. I thought the one comment about the sidewalks on the residential side was interesting, and I wondered if staff could speak to that and whether whether sidewalks are required, or it does seem like trying to make this a walkable community would make a lot of sense. I don't know if anyone on staff can speak.
Was that a question to staff? Just clarifying.
Yes.
Sorry, Vice Chair. Okay. Patrick or Lisa, can you respond to the question? Would you mind repeating that one more time about the sidewalk?
Sure. I wanted to ask what one of the commenters had spoken about in terms of the lack of sidewalks, one of the concerns that she had about lack of sidewalks in the residential area.
Hi,
Okay,
yes,
this
this
is-
is Lisa. Oh, go ahead, Patrick, you take it. Go ahead.
Okay. So for all the new streets that are proposed within the SP, sidewalks will be required. I believe the commenter may have been referring to a portion of Cane Ridge Road. And now there is a portion of Cane Ridge which does not contain frontage of the SP. However, the streets that are being built along this frontage for Cane Ridge will contain sidewalks, and those have been shown on previous plans and the plans we have under review right now.
Okay. Okay. I think I'll listen to others at this point. That was my only real question.
Commissioner Gobble?
First of all, let me point out I accidentally missed the rebuttal computer issue. But anyway, I did hear all the public comments. Other than that, I tend to go along with the staff's recommendation on this. It seems to make sense based on the scope of what we're trying to do. So I'll listen to the other commissioners.
Thank you. Commissioner Haynes?
No comment. I think given the addition of the small piece of property and no additional density, I'm going to support staff recommendation.
Thank you. Commissioner Johnson?
Thank you, Chair. First of all, I would like to thank Metro ITS and the planning staff team. You guys are working amazingly, and it's so refreshing to see presentation via on my PC and understand. And also, it's great to hear from public input via live call-in, which is greatly helpful. And I know it's lots of work, and really appreciate your hard work to make it happen. So as for the comment from the caller concerning the neighbor, sounded to me it's like commenting a large portion of the SP. I think we won't be able to renegotiate previously approved SP. And what we are front of us is 2.95 acre. And comparing our old plan and a new proposal, seems to me it is more improvement. And I think it's really conscientious about a transition to existing planned development into residential area. So I think this plan is a well thought out plan. And I tend to agree with the staff recommendation.
Thank you. Commissioner Moore?
I agree with what's been said so far, and I support staff's recommendation.
Thank you. Councilwoman Murphy? Councilor Murphy?
Thank you, Chair. I will say that, it's always scary when you have large projects like this for the community, and it can be overwhelming for the council member. And so what I've heard tonight from this presentation is that staff has done a great job at reaching out to the community, that there have been, I was astonished at how many community meetings there has been over the years. This district, the council person actually sits behind me. So in the previous council term, I heard a lot about development in this area. And one of the reasons I chose Council Lady Stiles to be my vice chair for the council planning committee is because the Southeast so often feels that they are not heard, or things are being put on them that they do not want or support. And so to hear the council lady support of this project, and that she clearly has, for just being about 6 months on the job, clearly was involved in this and thinking through this. I really trust her recommendation that this is something that her community supports and needs. And so with that, I would I don't think we've gotten to the end of the alphabet, but I'd be happy for you to come back to me for a motion when it's proper.
I'll do it. Thank you, Council Lady. Commissioner Sims.
I want to thank Tawana Chick. She is such a good leader out in that community, and the councilwoman for a lot of meetings and really trying to represent well this area. I did go out here and it is huge. I had no idea how big this area is. And it does feel to me, and I don't know for a better word, kind of unfair that they can't get a roundabout repaired or sidewalks in front of the apartments in an area this huge. I'm not sure that it's the ability of this SP to make that happen, but I would like to just recognize that they do have a couple of real needs out there and that are legitimate. But I think the staff's done a good job. I think we have to go with SP based on this just 2 acres. And so I agree with the staff.
All right, thank you, Commissioner Sims. I believe Commissioner Tibbs is recusing himself. Is that correct, Commissioner Tibbs, on this item?
Yes, it is.
Okay, thank you, Commissioner. You're appreciate that. So we'll go back to the council lady. Are you ready to make a motion, council lady?
Yes, I did want to make a motion with a brief comment. Thank you all so very much. Thank you, commissioners, for your time. Thank you for putting this together to be able to allow for public comment, and thank you to those that called in as well to give your concerns. I would like to make a motion at this time to move for approval.
Oh, well, yeah. Council lady, I'm sorry. It's Council Lady Murphy who makes the motion. I apologize.
Bless her heart. Council Lady Stiles, this is my turn to make.
Oh, did someone bless my heart? Oh my goodness.
Oh God.
Oh, bless my heart.
I will say that Council Lady Stiles has been my designated on our virtual meetings. Council Lady Stiles has been my designated motion maker and committee. So she is very used to getting called to make a motion. So if y'all will give her a little room there. So with that, I'd like to move for staff to approve the recommendation of the staff.
That's a proper motion. And then is there Vice Chair, you want a second?
Wait, Chairman, forgive me for interrupting. Just wanted to have a procedural note here. This is Lucy. There's 2 motions.
I'm sorry. 30A. Yeah, we're on the motion, Council Lady, would be to approve staff's recommendation for 30A first.
I move approval on 30A.
Thank you.
And I'll second that.
And Vice Chair seconds that.
Yeah.
Any other discussion? And please raise your hand or by voice. Seeing no other discussion, we're ready for a roll call vote on 30A. And Vice Chair Farr? Aye or nay?
Aye.
Commissioner Gobble?
Aye.
Commissioner Haynes?
Aye.
Commissioner Johnson?
Aye.
Commissioner Moore?
Aye.
Council Lady Murphy?
Aye.
Commissioner Sims?
Aye.
And Commissioner Tibbs recuses himself. So ayes have it, 8 ayes, 0 nays. And we are on item 30B. We'll need a motion. Council Lady Murphy?
I'm sorry, I've lost the number, but I move for approval on
30B. Thank you. It's a proper motion. And Vice Chair Farr?
I second.
That's a proper motion. And is there any discussion? If you'll raise your hands in the app or by voice in the call. Seeing none, we're ready for a roll call vote. Vice Chair Farr?
Aye.
Commissioner Gobble?
Aye.
Commissioner Haynes?
Aye.
Commissioner Johnson?
Aye.
Commissioner Moore?
Aye.
Councilor Murphy?
Aye.
Commissioner Sims?
Aye.
And Commissioner Tibbs recuses himself, and that ayes have it, 8 ayes, 0 nays, and item 30B is approved. Now we are on to, and I just want to thank everybody for that particular item. We are now on to item 31.
Hey, Chairman, this is Lucy. I'd like to just take a moment to address the technical issue that came up during the last hearing. Relating, one of the speakers noted that when looking at the television, the slideshow that he had sent in was 30 seconds delayed. That's actually a federal requirement that ITS has to comply with to make sure that there are no obscenities or the like. We know no one would ever put obscenities in a presentation to the commission, but my advice to the folks for this next case, and we do have additional items that the community would like to present, is just to focus on the presentation and not the television, if you will, because what the commission is seeing is the presentation. We're not watching the stream from the TV. Does that make sense? I just wanted to make sure that the folks who want to present materials at the meeting aren't focused and trying to speak to the television.
Yes.
Is that clear?
Sense.
Okay.
Yeah.
Okay, thank you.
Thank you. And now we are ready for, and we'll remind people of that when they're speaking on this particular item, because I know there's a lot of people. Before we get started on this particular item, it's going to be a long one, and so we need to be patient, and I appreciate everybody's patience and letting everybody speak and going through this process. So item 31, I think, is Logan going to be our presenter?
Yes, Logan's here.
Go ahead, Logan. You're recognized.
Great. Item 31 is a subdivision application. Next slide, please. The request is to approve a concept plan for 30 lots on Ivy Drive in the Inglewood neighborhood of East Nashville. Please note that there was a reference in the published staff report for 31 lots. This was a clerical error. The plan has gone from 32 lots down to 30 during the review process, and the reference to 31 was from a previous plan. The current request is for 30 lots. Next slide, please. Staff's recommendation is to approve with conditions. Next slide, please. The site is zoned residential single-family RS10 and is surrounded to the north, west, and south by RS10 zoning. The properties to the east that front onto Moss Rose Drive are zoned residential single-family RS20. Next slide, please. This application is for a cluster lot subdivision, which is an option that is provided in the subdivision regulations and in the zoning code, and can be applied for under the existing entitlement. In other words, no rezoning is proposed with this application. The cluster lot subdivision does not allow for more density than what would be allowed for under the existing RS10 zoning. The cluster lot subdivision allows a reduction in lot size to work with the existing topography, environmental features, and to create open space. Next slide, please. Included here is 1, the basic criteria necessary to apply for a cluster lot subdivision, and 2, the methodology for determining the lot yield for the property. This language is pulled straight from the zoning code. Essentially, the property must be zoned a R or RS district, and it must be 10 times the minimum lot area for the existing zoning district. If this is the case, then the property can apply for a cluster lot subdivision, and the proposed lots can be reduced down to smaller base zoning districts in terms of minimum lot size. Then to determine how many lots can be applied for in this cluster lot subdivision, you take the total area of the property, remove 15% of this area from the calculation for streets, and divide the remaining 85% by the existing unclustered zoning district minimum lot size. So if that might have really confused you, we've got the number breakdown on the next slide. So applying those standards or requirements and lot yield methodology to the Ivy Drive application looks like what you see on the screen. The site is zoned RS10, so it meets that criteria. The RS10 zoning district requires a minimum lot size of 10,000 square feet. 10 times this minimum lot size would be 100,000 square feet. The property being applied for is just over 9 acres and works out to 394,218 square feet. So the property meets the criteria necessary to apply for a cluster lot subdivision. Then when we look at the methodology to determine how many lots can be applied for in this cluster lot subdivision, we take the total lot area of just under 400,000 square feet, remove 15% of this for streets, and multiply the total lot area by 85% to get 335,000 square feet. When we take this area and divide it by the minimum lot size of 10,000 square feet, we get a yield of 33 lots. So under the cluster lot subdivision option, the maximum number of lots that could be realized would be 33. And a caveat with this would be that the maximum number of lots would be contingent on complying with all other metro requirements. Next slide, please. Also setting the stage of how we review subdivisions, the role of policy in reviewing subdivisions is limited to providing guidance on which section of the subdivision regulation that the application should be reviewed against. The language in the land use policy is not used to determine the appropriateness of the subdivisions, only to which section of the subdivision regulations we use. Next slide, please. The approximately 9-acre site is located south of the Bend in Ivy Drive and currently contains 2 single-family houses. The plan proposes 30 single-family residential lots with 2 lots fronting onto Ivy Drive and the remaining 28 lots fronting onto 2 newly proposed streets. The lots that front onto the newly proposed streets are shown to be a minimum of 5,000 square feet, with the 2 lots that front onto Ivy Drive being approximately half-acre lots. These 2 lots that front onto Ivy Drive are required to meet the compatibility standards of the subdivision regulation. Due to the topography of the site, there are several critical lots being proposed with this application, and these critical lots would be subject to the hillside development standards within the Metro Zoning Code. A stream partially bisects the property and separates the 2 lots on Ivy Drive from the cluster lots to the west. Here on the screen in the red circle, you will see that the stream stopped abruptly halfway through the site. This is because the applicant went through the proper process with the Tennessee Department of Environment and Conservation to have the stream partially reclassified as a wet weather conveyance through a hydraulic determination process. This is why it stops halfway. Also on the plan, you will see recreational facilities and stormwater management facilities centrally located near the stream, but outside of the required stream buffers. Next slide, please. To reiterate, this subdivision was reviewed against the standards of Chapter 3 of the subdivision regulation. Staff found the subdivision to meet the minimum standards of the RS10 zoning district, and the proposed streets have frontage on either an existing street or a newly proposed public street. All reviewing agencies have recommended approval or approval of conditions of this application. Next slide, please. So I mentioned earlier with the site plan were the compatibility standards that apply to the 2 larger lots on Ivy Drive. These standards are also found in the Chapter 3 of the subdivision regulations. These standards are applied in neighborhood maintenance areas when lots are created by subdivision that front onto an existing street. When all of these conditions are present, the 4 standards that are on your screen shown now are applied. And essentially these standards require that the lot size, the lot frontage, the street setback, and orientation of the lot to be consistent with the surrounding lots as defined in the subdivision regulations. So again, breaking down the math behind these standards, on the left-hand side, we see the requirements that are determined by running this compatibility standard analysis. We see here a minimum lot size required of 22,892 square feet, a minimum lot frontage of 76 feet, a required front setback of 20 feet, and the lots are required to be oriented to Ivy Drive, consistent with the surrounding properties. On the right-hand side, we see the proposal in this application, and we see that the proposed application meets all of these standards. Next slide, please. In conclusion, staff finds the proposed application to comply with all subdivision regulations and zoning code sections pertaining to subdivisions, cluster lot subdivisions, and infill subdivisions and neighborhood maintenance policy areas. All reviewing agencies have recommended approval or approval of conditions, and therefore staff's recommendation is approval of conditions. Thank you.
Thank you, Logan. We appreciate that. So now we are ready to open this item for public hearing, and the applicant will have 10 minutes. And Sean, can save 2 of the 10 minutes for rebuttal. Is the applicant on the line, Sean?
Yes, Chairman, we do have the applicant on the line, and he should be good to speak.
Okay, please state your name and your address.
Thank you, Chairman. My name is Doug Sloan with Bone McAllister Norton, and I represent the applicant, Mikan Development, who's seeking approval of subdivision application for 30 single-family lots, 2 of which face Ivy Drive and meet the lot comparability standards, and 28 of which are proposed through the cluster lot option of the Metro Zoning Code. I want to thank staff for the presentation that they've made. I think they did a thorough job walking through the hurdles that exist in creating a cluster lot option. And as you try to use the cluster lot option to preserve natural features on properties such as trees and streams, as this plan has proposed here. And also the lot comparability standards, which I know that the Planning Commission has wrestled with for a number of years, but it feels like we've finally come up with a way to develop lots that fit for infill development and meet development standards that are set by previous development here with the 2 lots that face Ivy Drive. And as stated in the Planning Department's analysis and recommendation, this application meets all of the requirements of the zoning code and the subdivision regulations, and will have to meet all of the other metro regulations, including stormwater, public works, fire marshal, and all other regulations that might pertain to the development of this property moving forward. The cluster lot option is designed specifically to try and preserve natural resources. And not only is the stream being saved here, but the applicant has worked closely with a tree conservation group to identify heritage trees and other trees within the property that need to be saved. This property was initially advertised last year in May of 2019 for sale, and in that advertisement, they listed this as a development site for cluster lot development. In November, my client approached the property sellers, and they worked out an agreement. Immediately after that, he worked closely with a group to come up with a development to bring forward and to show the council lady and met with Council Lady Benedict before filing the application to show her what his intentions were. After meeting with Council Lady Benedict, Mike Kenner went around and knocked on doors in the area to talk to the neighbors, to get a feel for what their concerns were, and also has held 2 community meetings to try and talk to the community, explain to them what he's trying to develop, and to be responsive to what their concerns were. Those discussions have led him to reduce the number of lots, reconfigure the site plan, or I should say the plat, and to enter into, or to offer, I should say, a community benefits agreement. He offered this to the community, and 3 of the highlights, there are several issues that are raised, but 3 of the highlights in regards to the community benefit agreement is a donation of $50,000 to go towards sidewalks on Ivy Drive, an obligation to continue work with the tree conservation group as they start development, and a requirement that he follow their advice in saving the heritage trees, and a requirement regarding the materials that are used on the homes within the development to include brick and block on the structures, none of which are a part of the requirement of the cluster lot option zoning regulations or the subdivision regulations. Those were efforts that he was making to try and address some of the concerns that were raised. Again, I would just ask that the commission refer back to the recommendations of staff. And I also want to quickly point out, just because of the conversations earlier today, I feel like it's necessary to bring up a case that was determined last year, the Joe Pennington versus Metro case. And in that case, the applicant met all the subdivision regulations, and the application was denied by the planning department. And in that planning meeting, Emily Lamb, who was an attorney for the Metro Legal Department at the time, stated that it was a requirement that if the applicant meets all of the regulations of the subdivision regs, for Metro subdivision regs, that the planning commission has to approve it. Furthermore, that she cited case law on this that says the Metro Planning Commission is an administrative body, and when exercising its function of approving or disapproving a subdivision plat, it is controlled by the regulations adopted for its guidance. It has no discretion or choice but to approve a subdivision which conforms to the regulations. This rule of administrative law is consistent with the general rule of law in Tennessee and concerning land use planning. In the decision written by Judge Perkins, he states the subdivision regulations make provisions for areas which have been previously subdivided and are predominantly developed in residential areas, otherwise known as infill subdivision. The subdivision regulations have specific criteria in order to demonstrate compatibility with the general plan, and its application complied with all, and this application complied with all of them. The area is designed, is designated rather as neighborhood maintenance. In the general plan, the regulations require that certain criteria must be met and determined compatible for the proposed infill lots and the surrounding parcels. He goes on to say that the application met all of that criteria, and therefore he remanded it back to the commission to approve the subdivision, the application. And I would submit to the commission that what is before you today is the same. It's the same set of circumstances here. The applicant meets all of the subdivision regs and the zoning code, and as laid out by the staff, it should be approved. And I've reserved the rest of my time for rebuttal. Thank you.
Thank you, sir. Sean, how much time is left?
Chairman, there were about 2.5 minutes, 2 minutes and 36 seconds. So we'll reserve 2 for rebuttal when we get to that point.
Thank you. So now we are First, as we've done in the last two cases, we will thank you, Sean, for doing that. And we'll reserve 2 minutes for rebuttal for the applicant. We will go first to the remote location, and I want to, Mr. Claxton, how many folks do we have there at the remote location?
We have no one at the remote location.
Okay, we have no one at the remote location. I appreciate that, Mr. Claxton. And now we will go to the voice call-ins. All of the members, Lisa, are there any voice messages on this particular item?
Chairman, we do have voice messages. We also received 53 emails in opposition to the item.
Okay, and the commissioners have received those, right? Correct?
Yes,
Those
that's
comments,
correct.
they've been posted, yeah. Okay.
That's correct. I need to, I'm sorry, I have to switch what I'm sharing. So if you can just hold on just for a second.
Chairman, while Lisa is preparing the voice mail recorders, I just wanted to clarify for the commission that this was a voicemail box set up by ITS, and folks could call in and leave a message, and we gave them some guidance as to how to do that on the website. And then I believe there's about 25 minutes of call-in recording that we'll hear. And so at this time, we might let folks know that if they want to call in for the live meeting, it'll be about 25 minutes. And then they can start calling in and queuing up. We do already have some folks who've called in and are on hold, but just wanted to give you an update there.
Thank you, Lucy. And just so everyone knows, we did, why don't you tell everybody that people could call in and all that? And leave a voice.
Yeah, so what you're about to hear now are the voicemail recordings that we've received over the last few days, and we'll play those. There's about 20 to 25 minutes of recording with multiple callers. And then at that conclusion, then we will open the live, or the live line is already open, but at that point, the commission will entertain that. So I just wanted to alert the public that if you do plan to call into the meeting, it will be after we hear the other public comment feedback from the recording. So it'll be about 20 to 25 minutes before we go to the live callers.
Thank you.
Chairman, I'm ready to start playing, if that's okay.
Please do so.
Hello, my name is Ann McHugh, 2322 Fernwood Drive, Inglewood, calling about Ivy Drive, number 2020F064001, calling to oppose the development of 32 new homes. This is not compatible with the area. It's twice as many houses that would be compatible. And definitely opposed to having a virtual meeting, which we cannot attend, which is in favour of the developer. Please pass on my opposition to this development. Number 2020F064001. Thank you. Have a good day.
Hi, my name is Catherine Parker, and I live at 3605 Brush Hill Road in Nashville, zip code 37216. And I'm calling to oppose the development on Ivy Drive in Inglewood. I feel that 32 homes is way too much cluster building. And it can be done if the land needs to be sold and built on. There are many other ways to do that respectfully for this neighborhood. I definitely oppose it. And I also feel like it's a bit unfair that this is all happening virtually right now, where we really have no time to respond in real time. And I'm hopeful that the committee will keep that in mind for the next vote. Thank you so much.
Hi, my name is Charles Weingartner. My address is 2408 Andrew Place. I'm a concerned homeowner calling in regards to Concept Plan 2020S 064001 at 3901 and 3905 Ivy Drive. This plan would be an absolute disaster for our neighborhood. The only open space on the cluster plan is a federally protected stream, the new storm water retention areas, and the steep slope between the two housing areas. Our neighborhood is a quiet place where red foxes, deer, wild turkeys, beaver, dozens of other different species and migratory birds live. This would destroy priceless sanctuary areas and green spaces that they live in along the Cumberland River bluff. Ivy Drive is not near a main road. Both ends of the street have a sharp 90-degree turn to the connecting drives. The added traffic congestion would be dangerous to children and entirely debilitating to the recreational activities that our community cherishes and enjoys. Additionally, this virtual hearing is unfair and discriminatory to us, and it clearly favors the developer. I urge you to not approve this cluster home concept plan. This is not beneficial to our neighborhood's growth in any single capacity. Thank you so much.
Hello, my name is Greg O'Loughlin. I live at 1410 Hemlock Avenue, Nashville, Tennessee, 37216. I am calling in opposition to case number 2020S 064001, the development on Ivy Drive. This is a terrible plan for the neighborhood. It does not reflect the neighborhood design, and you guys have the full authority to not approve this concept. If we kept it to what is currently the RS10 model for this neighborhood, they would be allowed to build around 16 houses, but they are seeking an end around for profit to build 30 plus houses. This is inappropriate for the setting. This goes against Nashville's next cluster development plan, and this is not even a cluster development plan. This is simply trying to smush as many houses as possible into the available land. This is not acceptable, and I stand in strong opposition to it. Thank you.
Hello, my name is Heather Lose, and I live at 3819 Moss Rose Drive. I am speaking in opposition to case number 2020S-064001, also known as 3901 Ivy Drive. The first thing I'd like to say is that I am opposed to holding a meeting this way. I believe that this meeting should be disordered in order to allow neighbors to show up in front of you today and voice our opinion on this proposed plan, which will have such a negative effect on so many lives. These lots, as proposed, are not clustered. This is a concept plan allowing to build as many RS5 homes on as much of this RS10 property as is possible. The stated 30 home equation does not consider the odd shape of the lot or the unbuildable areas. This plan does not save any currently open land except for the federally mandated stream area, the required stormwater retention areas, and the steep slope between the RS10 and RS5 homes. This property would provide for a subdivision of 16 RS10 homes, and we urge the Commission to exercise your right to turn down this particular cluster home plan, which is being used not to cluster development, but to effectively shoehorn as many RS5 lots over this entire RS10 property. Thank you so much for hearing my voice. Goodbye.
Good morning. My name is James Haggerty. I live at 1702 Riverwood Drive. I'm opposite Ivy Drive. I'm calling about the Ivy Drive development plan that is being considered at this next meeting on April 23rd. It is number 2020S-064001, and I am opposed to this plan in its current form. I feel that it does not meet the character of the neighborhood. I feel that there I believe there to be legal precedent for this not to move forward in its current form, and I ask that you reject this plan in favor of one that more fits the character of the neighborhood and is less damaging to the landscape, to the wildlife, to the trees. There are several issues with runoff, et cetera, et cetera. I'm sure other people and yourselves are already aware of these. I just ask that you reject this current plan and that we all put our heads together and come up with a better one. Thank you, and have a good day. Stay safe.
Yes, hello. This is Jeffrey Parsons. I live at 4111 Moss Rose Drive, and I'm calling about case number 2020S064001. I'm opposed to it, as are about 160 of my neighbors. I understand that there's a hearing scheduled for April 23rd, but it is a virtual remote hearing. It's clearly unfair to us neighbors. We can't assemble or respond in real time to the hearing. It clearly favors the developer. And I'd also just like to say that this cluster lot option that the developer is going to use is just a run around the code in order to put twice as many homes as would, practically fit on this property. Thanks for your attention.
Hello, my name is Joel Jansen. I live on 2712 Shadow Lane. I am calling an opposition. I'm calling to oppose concept plan 2020S-064001 on 3901 through 3905 Ivy Drive. I live in this neighborhood, and with what seems to be planned, the 30 homes in that lot just seems like it's totally unnecessary and totally inappropriate for this neighborhood. Cause a lot of traffic congestion and just really disturb a lot of people in this neighborhood as far as construction traffic and overall traffic when it's all done, and it'll just kind of really ruin the whole spirit of this neighborhood. And I don't know, I'd like to see keep things the way they are here. And thank you very much for listening to my comment. Thank you.
Hi, I'm calling because my name is Caitlin Doyle, and my husband, Zach Smith, both oppose the plan, and the number is 2020S-064-001. This is on Ivy Drive. It's for the cluster home concept plan. We believe it's unfair that we won't be able to be there for the virtual hearing, and it's discriminatory to us, and it clearly favors the developer because we cannot assemble in real time. We have over 160 residents that oppose this plan, and we know the Planning Commission has full authority not to approve the cluster home concept plan. If they would like to, let's keep it to a regular subdivision and only build 16 homes as opposed to the 32 because this is on property that has 2 houses on it now.
My name is Laura Yankee. My address is 3931 Ivy Drive, Nashville, Tennessee, 37216. I'm calling regarding case number 2020S-0640001. I am opposed to the approval of this concept plan. I am calling to urge the commission to deny approval for this. My husband, our 3 children, and I live on this street. We love our community. Unfortunately, many of the characteristics of this community are going to be destroyed with this development that has little support, if any support, among the residents on Ivy Drive and the surrounding streets. There are so many reasons why the neighbors, including our family, are urging you to not approve this plan. First, this cluster development violates many of the standards that have been set forth in our city's own municipal polity. Our quiet street resembles nothing like a major throughway. Dense development like this plan belongs where there's access to public transportation, where there's proper infrastructure to handle the heavier traffic that this development is sure to bring. Our street is regularly occupied by bicyclists and joggers and families strolling their children. and an addition of 30 plus homes at the end of the street will undoubtedly create safety issues. Not only does this development reduce the quality of life for our residents, but it will also devastate the habitat of our wildlife population and cause irrevocable damage to the surrounding environment. Additionally, the homes that are downhill will undoubtedly see flooding and water damage if this development goes through. In no way does this proposed development meet our own legal standards. No version of this concept plan has even proposed building homes that are clustered. It's simply a design plan that puts as many homes as possible on RS5 lots where there's currently RS10 zoning. All of the surrounding lots are RS10 and some are RS20. The stated 30 plus home equation is generic. It does not consider the odd shape of the lot or the areas on the lot that are just not buildable. This plan does not save any open land except for the federally mandated stream area, the required stormwater retention area, and the steep slope between the RS10 and RS5 homes. Currently, this property would provide for a subdivision of 16 RS10 homes. I am strongly urging you all to exercise your right to turn down this particular cluster home option. It is just that. It is an option that you may approve or deny, and I am begging you to see that this development is in no way harmonious with our residents or our neighborhood. Thank you so much for your sincere deliberation over the many ways in which this plan violates our city's own guidelines and regulations.
Hello, my name is Lou Vargo. I live at 516 Riverwood Circle in Inglewood. And this is a call in reference to the case number 2020S, like Stephen, -064-001. This is the proposed development on Ivy Drive, just a couple of blocks from my house. And I'm calling in opposition, strong opposition, to this development. And I'm also voicing my opposition to the online or virtual Planning Commission meeting. This is antithetical to civil discourse, and it is antithetical to allowing people to show up to voice their opinion. It will not allow me to show up to voice my opinion in real time and make my argument, and allow the neighborhood to make their argument collectively in an effective way. So thank you very much. Thank you for serving the city, and I appreciate you taking the time to listen to my voicemail. Thank you very much. Please.
Chairman, this is Lucy. I asked the staff to pause this at the 14, a little more than halfway through, to ask that the commissioners please confirm that they can hear all of the comments being entered into the record. I haven't received any feedback, but I think it's important to get on the record that the commissioners are able to hear all of these comments.
All right. Let's just go down the list and check with each commissioner. Vice Chair Farr, can you hear everyone?
I can hear everyone. I'll just say periodically it's like we get double feedback. Maybe that's my issue, but we can hear them.
I get some double feedback too. It was probably through a third of the call, but I could still hear them.
Right.
Okay, perfect. Commissioner Gobble?
Same for me. It's been clear except for that one little section that I could hear what they were saying.
Commissioner Haynes?
Same for me.
Commissioner Johnson?
Yes, Chair. I can hear from my PC. My phone goes on and off, but I'm sitting in front of my PC and I could hear every word presented.
Okay. Commissioner Moore?
I could hear most everyone. There were about 3 of them that I did get feedback, but could still make out what they were saying.
Okay. Councilor Murphy?
I actually enjoy the kind of robotic tone of it. It's been, it keeps me listening.
It's keeping me alert and awake, so I can hear it loud and clear.
Mr. Sims?
I am getting some feedback, but I can make out what they're saying.
Okay. Mr. Tibbs?
Yeah, just like everybody else, I guess I'll just end it though, that if whoever is controlling, if you do hear that echo, if you could kind of work on that at that point, because one of them got pretty distracting, but like Councilman Murphy said, made me listen closer, so there was some advantage, I guess, to it, but if they could just watch that, that'd be great.
Okay. All right, there you go, Director.
Thank you very much. We'll start, we will press play. Thank you.
Thank you.
Vote against it.
Hi, my name is Robbie Lynn Hunsinger. I live at 4021 Ivy Drive, and I am strongly opposed to the concept plan 2020S064001. This concept plan is for a cluster lot development at the end of our street, Ivy Drive, in an incredibly quiet and secluded and pastoral neighborhood with terrific environmental resources and wildlife resources, basically centered right on these lots. I urge you to exercise your option to disapprove the cluster lot. A subdivision would maybe take maybe 16 homes on this property, but there's extreme grading, there's a federally protected stream, there's a lot of issues with this property. If you did RS10, like the rest of the neighborhood, RS20 adjoins this property, by the way, but if you did RS10, if you just approved a subdivision, we would have maybe 16 homes. They want to put 30 homes on this property. It's supposed to be a cluster lot, but the lots are not clustered. They cover the entire property except for where federally mandated around the stream and where it's state mandated that they have these water, stormwater areas to catch we're very concerned about the flooding that may happen. Anyway, there's stormwater retention areas. Trying to wrap this up. In addition, neighbors did not get the required notification of this public hearing. They have gotten no notifications which are required for this public hearing to go forward. And we find the nature of this format, the virtual format, very discriminatory against our group of over 160 members. We're 160 neighbors against this proposal. We can't show up and speak. We do need to do pre-recorded comments. We cannot do rebuttals. It's very much favors the developer, this particular format. My number is 615-708-8034. Thank you for your time. We appreciate it. Bye-bye.
Yes, my name is Robert Goodwin, and I live on Riverwood Drive. And I just wanted to say that I oppose the development on Ivy Drive that is supposed to include 32 cluster homes. It is not right for this residential neighborhood. It is most all the homes on that street have at least a third of an acre and is zoned RS10. And it just isn't going to, the traffic is limited to very few streets to get out to Gallatin Road, and I am just opposed to this plan as it is right now. I'm not opposed to developing that property on Ivy Drive. It's just that 32 homes, I believe, is just way too many for this area. There's not an area like that in the whole neighborhood. So that's my position on this development as is today for 4/21/2020. Thank you very much for your consideration. Bye-bye.
Hi, this is Sylvia Johnny Tropany of 3920 Ivy Drive. I'm calling regarding case number 20205-064-001 at 3901 Ivy Drive. I am opposed to doubling the houses on Ivy Drive from 32 to 62 in one short block. This is in a suburban T3 neighborhood that is not near a main corridor, not near public transportation, not near commercial amenities, does not have sidewalks, will become unsafe and congested from additional traffic, probably additional 60 cars. The land includes steep grades, a stream, an underground spring, and is above houses who will be compromised from flooding. You have the power to hear our voice. Please vote no. Thank you.
Hello, this is Tim Kiernan. I live at 2205 Demarius Drive, Nashville, Tennessee, 37216, and I'm calling in regards to plan number 2020-064-001 note. Or wait, sorry, never mind. Yes. So that's 2020-064-001, and I'm calling to oppose the plan because it will put undue stress on our neighborhood, and the Planning Commission has a full authority to not approve this cluster home concept plan option. Please keep it at only 16 homes rather than 32, as the neighborhood and resources are not equipped to handle that for a 2-lot property. Thank you. Come by the neighborhood to check it out, and you'll see how inappropriate it is for them to build that. Thank you.
Yes, this is Wayne Harper. This is regarding case number 2020-S-065-001, Ivy Drive proposed development. On February 28th, I sent a very detailed email to Logan Elliott regarding the Ivy Drive proposed development. Please review it and act accordingly to protect properties from flooding. Bottom line, before any construction starts on the Ivy development, 3 culverts need to be replaced, and the creek needs to be dredged to support the massive volume of water being displaced by this development. So please read the letter and get this into the hands, if you would, of people that can review this. I'm Wayne Harper. I am opposed to this, by the way, because of the flooding. And I would be glad to talk to anybody about it that needs to, so I can explain. I've been here 11 years. I know how it works. The creek will definitely flood if this will flood the properties all through that area if this development goes through. There's currently just 2 houses and then no asphalt driveways. So you can imagine 32 houses, concrete driveways or asphalt is going to displace a massive amount of water down that valley. My number is 615-975-8083. Thanks a lot.
Hi, this is William Chest. I live at 3815 Moss Rose Drive in Nashville. I'm commenting on the Ivy Drive concept plan 2020-S-064-0001. My wife Jackie and I have lived here for 17 years. We're just downhill from the beautiful property. And the creek that starts on this property from the underground springs there flows through our backyard. We've already had serious flooding issues here, and the creek overflows even now after a day or 2 of rain. And I think the idea of building 31 cluster homes there will be a disaster for flooding issues for us and our neighbors. I also feel that the cluster houses are not appropriate here in any way. This is the heart of a settled, peaceful neighborhood. It's not the edge of a neighborhood. There are no other cluster homes near here. There are no other non-brick homes like these will be in this neighborhood. I think this plan should be kept to the regular subdivision, which allows a maximum of 16 homes this is a property where only 2 homes have ever stood. There are 160 residents who have stated opposition to this plan. This entire neighborhood is covered with yard signs against this. And I think these facts alone should tell you there's something out of balance here. Mayor Cooper's campaign promise was that there would be a new focus on quality of life for the average homeowner in their neighborhood. And this development would destroy the peaceful quality of life that we enjoy here. I just don't understand how the maximizing profits for a few wealthy people should take priority over the quality of life of the many homeowners who've lived for decades in this neighborhood. And I believe anyone who has taken the time to come out and view this neighborhood would easily see how inappropriate cluster homes would be in this location. Thank you. Bye-bye.
Chairman, that concludes the the audio recording. And so at this time, I would recommend that we go to the live call-in portion of the hearing.
Okay, thank you very much. Appreciate that, Director Kempf. And I want to thank everybody that is called in. So we are now ready to take those particular calls from members of the public who are calling in. Your screen should show and has showed the call-in number. As a reminder, please only call on this particular case, not the others. And when you begin your testimony, state your name, address, and whether you support or oppose the item like we've done in the previous 2 hearings. So Sean will keep track of time as well, like she did earlier, and she will let you know when you have 30 seconds left. You have 2 minutes. And so, Sean, are we ready to take the first caller? Well, just tell us, how many calls do we have so far? Do we know, or the queue?
Thank you for calling the comment line. Yes, well, I am coming through right now.
Sean?
Chairman, you have the first caller on the line. I will start the timer when that caller starts speaking, just so everyone is clear on how I'm handling that.
Okay, and you're telling them to state their name and address and all that?
Yes, they're getting those instructions before they're placed into the call. Perfect. So when they come in, they can begin speaking as soon as you indicate that you're ready for them, and I will start the timer only when that person begins speaking.
Okay, thank you, Sean. All right, we're ready for the first caller. Hello.
Thank you. I'm Marshall Albritton. I'm the attorney for some of the landowners. I request 5 minutes if that would be possible.
Okay, 5 minutes.
Is that acceptable? Hello?
Chairman, this is Sean Shepard. I think I heard you say that you were comfortable with this caller having 5 minutes. Can you confirm that for me, please?
Yes, I'm comfortable with that.
Okay, I will be starting the timer for 5 minutes. Thanks.
Okay, go ahead. You can start now for 5 minutes, sir.
Thank you, Mr. Chairman and members of the commission. You heard from me earlier, and I'll try to be brief. This plan does not, it does allow for more density in reality, and you can see that by the plan. All the boxes that are crammed into this section. It does not provide for less grading. In fact, there'll be more grading and mass grading on this site. There'll be twice as many homes and twice as much traffic. So I do not believe it meets the intent of the cluster lot subdivision. But secondly, it does not comply with the subdivision requirements or zoning code. I have submitted exhibits that now I will go through, and those should be available and printed and posted for you. Let me know if you can't see them, but I'm going to go through them. So I'm looking first at the grading plan, and I have notes on there. They're numbered 1 through 5. The grading plan shows that the applicant has not complied with the subdivision regulations under 3-3 suitability of the land. Number 4 says prior to concept plan approval that has a subdivision where there are lots designated as critical, the applicant shall provide the executive director with a preliminary grading study and a description of the measures to be taken to protect the natural features of the critical lots, to minimize changes in grade, cleared area, and volume of cut or fill, and to control adverse impacts on the critical lots during and following the period of site disturbance, to align streets to minimize disturbance of slopes, and to identify easements along property lines. Now, if you turn back to my exhibit, let's start with number 1. If you can count the contour lines, those mark every 2 feet on this map. Starting in the back corner of this, if you start there and you go from the edge of the cul-de-sac and you go forward, that's a 20-foot drop across that cul-de-sac. That's a 20-foot grade that is going to be a 20% grade, a 20-foot drop that is applicable here. So there's not been a real grading plan submitted that shows the finished grade. These contours, the reason I've submitted these other copies here, including the Metro GIS, is to show that the contour lines match those lines. This is not a grading plan showing proposed grade. So what that means is he's just drawn this circle on this map. He's got 20 feet he has to contend with, which means he will either have to cut the uphill side where the critical lots are down 20 feet, or he will have to build up the back half where the question mark is on my map and the area for stormwater. He'll have to build that up 20 feet, or he will have to do some on each side. But in either case, what he's going to end up doing is damaging these critical lots because there's going to be a significant amount of cut, or he's going to have to build up the downhill slide. And when he does that, he can't just build a wall. He has to build back into the area that's now reserved for stormwater. So he's going to be building into his stormwater area. Now proceed to number 2, which is near the end of the street. And you'll see an area where 3 contour lines come together coming across the road. That means there's a 6-foot drop and about a 4-foot stretch of that road. He can't build that. He literally can't do it. Now look at number 3. There are 3 lots. These are supposed to be 50 feet across, and the 3 that I've marked are not 50 feet across. That's according to your subdivision regulations. 4, he's supposed to submit to get the cluster lot development. He's supposed to submit recreational facilities that are based on the demographics of the area. And all he's proposing to build is that walkway. He has not submitted anything to the commission to show how that is based on the demographics of the area. And then finally, the cul-de-sac is too long. If this is a walkable subdivision, it's supposed to be 250 feet or less. And I've marked it out.
Caller, you have 30 seconds.
Matching his scale, and it's over 320 feet from the cul-de-sac back to the turnaround. That's as fast as I can possibly. Oh, finally, the sidewalk around the cul-de-sac. If he builds that sidewalk will have an elevation, a slope from left to right that's not allowed by the sidewalk standards. All of these things are proved by what he has submitted. This does not comply with the zone and the zoning in the recreational development.
Caller, your time is up. Please finish your thought. Thank you.
Thank you. That's all I have. I went as fast as I could. Thank you.
Thank you. John, we're ready for the next caller. Sean, are you there?
Yes, the caller should be in now, Chairman.
Okay, please proceed. State your name and address.
My name is Laura Yankee. My address is 3931 Ivy Drive. I left a message, but I wanted to call with a couple of additional items. First of all, thank you so much for all of your time tonight. I know that this is going to probably go later than typical meetings do. The first thing I wanted to address is Miken's claim of working with the neighbors. We've consistently asked for less density, which he has consistently refused to do. The second thing is his offer of $50,000 in sidewalks. which is essentially 60 feet of sidewalks on our street, which is just, kind of like a slap in the face. Finally, I really just wanted to say that throughout this entire meeting, calls have been dropped. Feedback has been terrible. The lag time with the slides has, made it very difficult to follow. And I think, if anything, this needs to be deferred, but preferably you would just vote no, because this has been a really difficult format to express ourselves. That's all I have. Thank you.
Next caller.
Right, Chairman, the next caller is in the meeting.
Hello.
Hello.
Please proceed. We're ready for you. State your name and address.
Hi. My name's Donna Center, and I thank you for taking my call. I live at 4112 Brush Hill Road. I'm approximately 1.5 miles from this property. On legal and government regulations and paper and according to metro requirements, it seems this development meets all of your criteria. But have you driven the neighborhood? Do you know what this would do to our neighborhood? I'm 1.5 miles away, but we have no sidewalks, and we deal with the drive-through traffic from Briley and Gallatin Road now. Adding this subdivision would increase the traffic and danger for our neighbors and families walking, strolling, and walking their pets. We deal with it every day now. This is a beautiful, quiet, historical neighborhood with large lots, grassy lawns, and mostly single home lots. Please look at the people, listen to the people, and make a decision based on the quality of life for the citizens here that live here and have lived here for decades. Thank you very much for listening.
Thank you for calling in. We appreciate it. Next caller, Sean.
Chairman, the next caller is in now.
Hello. Please state your name and address. Begin. Thank you.
Thank you. My name is Matthew Burgess. My address is 2906 Shadow Lane, and I'm against this development. Thank you for your patience tonight. I know it's a long evening, especially in these trying times. I don't know what this developer is talking about because no one came to my door or my neighbor's door to ask us what we think. And I work from home, so they're lying. And if they're lying about this, what else are they lying about? The neighborhood's already crowded. That's become more obvious during this pandemic as we walk the streets with our kids and dogs. And adding more houses will obviously add more people to a historic neighborhood that can't handle. You've already heard about the stream and the runoff. I don't need to go into that. But before you decide anything, you should come check it out for yourselves. You can access it from my place. There's a marshland back there, and not just after a rainstorm. So with more water, it's just a disaster and more lawsuits waiting to happen. I understand that progress needs to happen and lot owners have a right to sell. So a possible solution in our zip code 37216, home to thousands of people, we do not have a dog park. We have 2 high schools, but no dog park. And Ivy Lane would be a great location for that. There's several acres, room for parking, and plenty of dogs are in the neighborhood. I know because they're already using my yard. There's even room for a kid's playground. With the Metro's help, the homeowners could sell, the developers could still develop something, and Inglewood would get a much-needed facility. So in these COVID days,
Caller, you have 30 seconds.
Provides a way for us to interact with each other, get some respite from isolation, and still have a way to remain socially distant. So please don't allow this development, please. But if you have to develop something, make it a park. You can bring your dog, and I will walk him myself. Thanks for your time tonight. Everybody stay safe. Appreciate you.
Thank you. Next caller. John?
The next caller is in now, Chairman.
Welcome. Please state your name and address, and you can start.
My name's Robert Goodwin. I live on Riverwood Drive, and I'd like to thank the ladies and gentlemen of the commission. This is an awkward format for me, and I suppose a lot of other people too, but so please excuse me if I stumble through my words. I oppose this project as is, meaning that I think 30 homes is not keeping with the neighborhood whatsoever. I'm not against developing this property, but moving from an R10 to R5 creates a situation there's nowhere close to the existing properties. I think that's what you're supposed to do, is fit in with the neighborhood. Well, this project as it is, it doesn't. There's only 30 homes on the entire block right now. So the street's so narrow, it doesn't even have a white center line. There's a question of flooding in this particular area because it's kind of like a valley situation landscape. But I'm not any kind of an expert on the things that they've mentioned about the environmental impact. But I also think that due to the pandemic that we're under, a timeout regarding a final decision might be considered. Just like they moved the income tax deadline, as you know, it's been adopted too. It wasn't a hard line. You can do it. You all have the power. I wish everybody on the commission could take a drive down Ivy and see this area in person and how the proposed project would have a negative dynamic
You have 30
on the
seconds.
surrounding area. As you can see on the map, there's only a west and a south direction to enter or exit this area because of the river. And I think the additional 40 to 60 cars would pretty much be a serious problem. I appreciate the opportunity to let you know how I feel. Best regards, and I hope you all can have dinner pretty soon. Thank you.
Thank you. Next caller, Sean.
Thank you.
All right, Chairman, we have the next caller.
Hi, welcome, and please state your name and address, and you can begin.
This is Russell Chest. I live in the 3800 block of Moss Rose Drive, just down the creek from the proposed development. I'm opposed to the development.
Is that it, sir?
Do I get to speak?
Yes, please.
No. I'd just like to take issue with the developer's claim that he has reached out and tried to work with us. I attended the only two physical meetings we had, which was an overflow crowd of 100, 150 people, everyone opposed to this. And he has made no concessions other than what he's required by law to have conceded the two houses. And the proposal that he would build a sidewalk is not, the only reason we would need a sidewalk on Ivy Drive is to handle the increased 60 cars that would be added to our neighborhood if this goes through. Those are small streets surrounded by other small streets. We're near the river. People walk their dogs, ride their bicycles. It's a peaceful, settled neighborhood. This is the heart of a peaceful, settled neighborhood, and this does not in any fashion fit a harmonious development or compatibility with our neighborhood. Okay, thank you, and I appreciate everyone listening tonight and hope everyone has a good night. Thank you.
Thank you. Appreciate it. Next caller, Sean.
All right, Chairman, we have the next caller.
Hello, welcome. Please state your name and your address, and you can start testifying. Thank you.
Thank you. My name is Maggie Gigandit. I live at 2403 Claypool Street, and I oppose the development plan on Ivy Drive. The purpose of the law allowing this cluster home development cannot be to cram as many houses as possible into a hilly, wooded area in the heart of an old neighborhood of single-family homes away from any businesses, main roads, parks, or public transportation. To me, this situation is exactly why we have a planning commission in the first place, to prevent irresponsible, inappropriate construction projects in places where they simply do not belong. I'm concerned about the traffic that will occur in our neighborhood. Our neighborhood doesn't even have painted lines separating lanes on the roads. Because we aren't connected to main roads, we don't have through traffic. These roads are simply to get to the houses that are already here. Beyond the traffic, I'm concerned about the runoff issues in our neighborhood. My neighbors already have issues with runoff. It will only get worse when this construction goes into effect with new roads, a cul-de-sac, and trees are torn down. My neighbors will have a very real issue. I think you've heard such an emotional response from our neighborhood because we know our neighborhood and we know how absurd it is and clearly irresponsible to allow this many homes to be built on this area. We will be the ones to listen to the chainsaws tearing down trees that are older than most residents. We'll be the ones to listen to the cement trucks filling in this natural area to build nothing more than a monument to corporate greed.
Caller, you have 30 seconds.
Do not allow this plan to go in effect as it is. I understand there will be development here, but I ask that fewer homes be built because our neighborhood and that land can only sustain fewer homes. Thank you.
Thank you. Next caller.
Chairman, you have the next caller.
Hello, welcome. Please state your name and your address, and you can start testifying. Thank you.
Great, and good evening, Commission. Thank you all for your time and patience. My name is Jennifer Tribble, and my address is 2411 Milton Drive. I would like to voice my strong opposition to the development as planned on Ivy Drive. As you've heard tonight, we as the residents of the neighborhood have very serious concerns about the stormwater and flooding implications, additional traffic, lack of open space, and negative effects on biodiversity and wildlife habitat. This design as planned simply does not work in our neighborhood. I currently live in a house that is almost 100 years old. These decisions have extremely long-term implications. I urge you as the Commission to not approve these plans as described and consider the vast opposition from us, the residents and taxpayers of Nashville. Thank you.
Thank you. Next caller.
Chairman, you have the next caller.
Thank you. Welcome. And please state your name and your address, and you can begin to testify. Thank you.
Hi, my name is Rachel Glidden, and I'm at 1930 Riverwood Drive, and I am in opposition of the Ivy Drive development. The conversation around the development is obviously one that the residents in the area, myself included, are especially passionate about, and you've heard statistics and legal reasons all evening as to why people think this is a bad idea, but I'm not going to pretend I'm an expert on that. I just want to speak as a resident and someone who's really passionate about this area. Like I've never called in about anything like this in my life, but I've lived in Nashville for 10 years and Inglewood for 5, and I love this area. There's a lot of reasons why, and you know, the lot sizes and just the beauty of the area is one of them, but just how passionate everybody is really important to me, and I think it speaks volumes to the unique quality of the community in this area as to why everyone's come so strongly about this issue and against the development. I think that if the developer were to, you know, make more than 16 homes on this lot, it's just giving into corporate greed if we allow them to do that. You know, in the last 10 years, I've seen so many areas of Nashville change as everybody else has, and that's not always for the better.
And I'm not saying all development is bad, but I think in Inglewood and Ivy Drive in particular are some of the best places left in our city and really truly retain the character and qualities that make this city in Nashville a city worth living in. And, you know, good council people, like, I really appreciate...
Oh, you have 30 seconds.
And considering all of this, but I would encourage you, if you haven't, to walk through the neighborhood and just really take in the natural beauty, take in the community, and consider whether you think that this actually makes sense. I don't think it does. And I really appreciate your time. Thank you so much.
Thank you. Next caller.
Chairman, you have the next caller.
Welcome, and please state your name and your address, and you can begin your testimony.
Good evening. My name is Matthew Bonds, and I live at 3519 Gulf Street in Inglewood. I'm against this cluster lot and this proposal, because although there are many reasons to deny the cluster lot option on this item and to send this proposal back to the drawing board, as many people have suggested, and there are many reasons to respect the, God knows, hundreds of residents of Inglewood who are against it, I would simply like to point out the incongruity of it. The developer, Mikan Development, has two residential projects of which they are very proud, Richland Station and Treaty Oaks. Both of these projects are on flat land that does not have any creek running through them. Both of them are houses squeezed into as small an acreage as possible, no more than 3 feet apart. Now, although that is unacceptable, it is perhaps slightly less unacceptable in these two projects. Treaty Oaks was originally commercial zoning. Richland Station is only a stone's throw from Charlotte Pike. Richland Station is located right behind Budget Breaks with a Burger King across the street. This proposal tonight is nothing like that. Ivy Drive is about as far from the comparable commercial stretch of Gallatin Pike as a neighborhood can be without actually falling into the Cumberland River. These kinds of developments may be all right if you're 1 block from a commercial strip, but they're totally wrong for a charming, quiet, narrow residential street that's deep in the heart of Inglewood. So please vote it down. Thank you.
Thank you. Next caller.
Okay. Chairman, you have the next caller.
Hello, welcome. Please state your name and your address, and you can begin your testimony. Thank you.
My name is Betsy Ragland. I live at 3817 Moss Rose Drive, and I am against the subdivision on Ivy Drive. I live downhill from the proposed subdivision and currently experience massive flooding in my backyard. I'm extremely concerned that this will be even worse given the massive destruction of the proposed site. This is an extremely quiet, family-oriented neighborhood, and I believe adding 30 more homes will change the dynamic entirely. I just don't think dense cluster homes fit into the vibe of our neighborhood. I'm also very concerned for the wildlife that have called that particular area home for many years. I also believe there are safety issues with the sudden increase in traffic. 30 homes equals at most 60 vehicles. Crime is also a concern. I just believe that dense cluster homes belong in adjacent major thoroughways, not deep in pastoral RS10 and RS20 neighborhoods. I encourage the commissioners to take the more than 150 neighbors that will be directly affected by this nightmare into consideration. I feel this virtual meeting is unfair. Our voices deserve to be heard, and our quality of life needs to be considered, and our physical appearance should be allowed. Surely there is a better option. And by the way, Mike never knocked on my door, nor did I receive any notification regarding this issue. Thank you very much, and I appreciate your consideration.
Thank you. Next caller.
Chairman, you have the next caller.
Hi, welcome. Please state your name and address, and you can begin your testimony. Thank you for calling in.
Thank you very much, sir. My name is Nathan Walls, and I'm a resident at 2310 Milton Drive, and I am here to express my vehement opposition to the proposed 30, I believe it's now 30 houses, still 30 too many, at Ivy Drive. And I'd like to begin I'd like to initially say that that the forum in which this meeting is being held is wholly inadequate, and I respect and appreciate the fact that we are under COVID-19 provisions. However, I think the onus is upon this body to defer this until we can have a proper hearing in a traditional public forum, so that, as the legal counsel for the Save Ivy Drive movement mentioned, our rights to due process are not so blatantly circumvented. Now, that being said, I'd like to say that I also live directly behind this proposed development. As I told you, I live at 2310 Milton Drive. I share a very large border with this proposed development. And I actually went over and looked at the property when it was on the market. And, you know, it was certainly quite a long shot, but you know, it certainly needs to be preserved. And I have had the pleasure of living in this part of Nashville for about 5 years now. I've lived in Nashville my entire life. I grew up here, and it's really saddening to see our ecological diversity.
Caller, you have 30 seconds.
Thank you. And I just want to implore you to defer, to not only defer this proposal, but relegate it to the ash bin of history where it belongs, because it is going to utterly destroy an ecologically delicate and vulnerable area. Thank you very much. Among other things, of course. Thank you.
Thank you. Next caller.
Chairman, you have the next caller.
Hello, welcome, and please state your name and your address, and you can begin to testify.
Hi, my name is Jim Gregory, and I live at 1000 Glenview Drive, Nashville, Tennessee 37206. And I am the chair of the Nashville Tree Conservation Corps. I'm calling in to support the community that lives near Ivy Drive, and I speak with them against the building of clustered lots in order to preserve this neighborhood's integrity and quality of life. I am also calling in, of course, to speak for the amazing trees on this property. And I ask that any and all tree canopy preservation measures be considered with your decision. The surrounding area of this community has just experienced tremendous loss from the tornado of March 2020. And now, more than ever, preservation of our remaining patches of intact tree canopy is vital for the future prosperity of our amazing, resilient city. Thank you for everything that you do for our city, and have a great evening.
Thank you. Next caller.
Chairman, you have the next caller.
Welcome. Please state your name and your address, and you can begin your testimony. Thank you.
Thanks. My name is Brian Owings. I'm at 3920 Ivy Drive. I've lived in this neighborhood for 20 years. I'm in strong opposition against this. This whole idea it's a bad idea. This is a really peaceful neighborhood. The idea that possibility of 60 cars and 30 homes in this area, this kind of density is not necessary. We're 2 miles from Galveston Road. There are other ways to do it. I'm not opposed to a development, but you know, I can see 8 or 10 houses there, but 30 that's crazy. It's ridiculous. There's a floodplain down Moss Road. It's just going to be a big problem there for the folks that live there, not to mention the traffic. And I just ask you to drive the neighborhood and see how out of character that whole idea would be. Just wanted to give you my 2 cents. I hope you'll vote no. And also, just the whole idea of this virtual meeting is completely unfair. And I actually have never been notified of this happening either. So thanks for your time. Hope you have a good night. Thanks. Bye.
Thank you. Next caller.
Not to mention,
Chairman, you have the next caller.
and I just ask you to drive the neighborhood and see how out of character that whole idea would be. Just wanted to give you my 2 cents. I hope you'll vote.
Hello, is the next caller on?
Hi.
Yeah, please state your name and your address, and you can start your testimony. Thank you.
Chairman, hold on just a second. We're trying to get the next caller
Would
in.
you be able to turn down the volume of the meeting? We're about to place you in. Oh, no, I'm sorry. I think it's, hold on 1 second. She has slides.
Chairman, the caller states that she sent in a visual exhibit, and so we're confirming with Lisa that we have the slide to post up there. What I might...
That one.
Okay, we have the exhibit now.
On the screen right now, there will be a lag time.
Thank you, Director. Let me know when the caller's on.
Thank you.
Chairman, you have the caller now.
Thank you, and welcome. Please state your name and your address, and we appreciate you joining the call. And you can start.
Hi, my name is Robbie Lynn Hunsinger. I live at 4021 Ivy Drive. I am strongly against this development. I know many of you have heard from me, and I will be brief. And I do appreciate your time. This is an incredibly long meeting, and I appreciate your patience. I wanted to mention just a couple of things. The Subreg 2017 Chapter 3 requirements for improvements, the suitability of the land. It says that the applicant shall provide the executive director with a preliminary grading study and a description of the measures to be taken to protect the natural features of the critical lots, and we don't see that. And I understand that my slide is on the screen. I don't see it. I do have a slide to show.
So, ma'am, the slide, due to federal law of a 30-second lag, it will show up. So if you'll just talk about it, it will eventually show up.
Okay, I'll do that. I created an image with the grading highlighted. The grading is the identical grading on the original plot. No grading plans seem to have been submitted with how he's actually going to do this. And one of the things that concerns me is the stormwater retention areas. One of them goes over a grade that is 19 feet. 19 feet slope, a 19-foot drop. I can't see my slide now, but it's the one. There we are. The retention area just above the creek on this slide. That is a 19-foot drop that obviously runs right into the creek. The one to the left of the creek runs right into lot 21.
You have 30 seconds.
Okay, I'm going to hurry here. The other thing is that, as Mr. Elliott stated, the cluster lot option is not supposed to change the possible density for this land. And in our case, in this particular land, because of the grading, because of the stream, because of the geography and environmental factors, you cannot fit 30 RS10 homes on this property. You can fit about 16, and that seems to break the cluster lot option that has been submitted. And I also wanted to say...
Caller, your time is up. Please finish your thought. Thank you.
I will. Thank you. The other item is Municipal Code 1712-090. He is required to submit recreational facilities with this plan. There's no room for them, but that is part of his job, and it's required to submit with this concept plan. We don't see any place for that. I think he has failed to submit.
Caller, your time is up. Thank you.
Thank you.
Thank you. All right, next caller.
Chairman, you have the next caller.
Welcome, and please state your name and your address, and you can start your testimony. Appreciate you calling.
Hi there. Hi. Thanks for taking my call. My name is David Schneider. I live at 2315 Demarius Drive. This topic has been a hot topic in our neighborhood for the last 2 months. A lot of discussion among the neighbors, and so for that reason, I was very interested in listening to the staff presentation, having the opportunity for them to review the plan and highlight some of the potential positives. I did notice that the emphasis of that presentation was the compliance and the fact that the plan had met with all the relevant regulatory approvals. This would suggest that it is a good idea if something is approved. It's something that people want. It's a good idea. But obviously the folks who have called in today begs the question, good idea for who? I was also interested in Mr. Sloan's testimony representing the developer. If I followed correctly, I noticed that he used his time to not emphasize the merits of the plan, but to counsel the commission that they are obligated to approve it. I don't know if that's true. I have no authoritative knowledge in case law or municipal code or issues of compliance. I can only speak as a resident that walks by this property every day with my 2 kids and strollers. They're beautiful lots. It's a beautiful.
Caller, you have 30 seconds.
Sure. We'd love to welcome other people into the neighborhood, as everyone has said. We're not opposed to having 4, 6, 8, as many as 16 lots and having people join this wonderful community. But 32 is just it's a gross outlier that is really quite abundantly obvious if you just lay eyes upon the site. And that's really all the testimony I think anyone needs. Thank you.
Thank you, sir. Next caller.
Hi, sorry.
Chairman, we're working with the caller to have them mute the meeting before we place them in.
Thank you. I'm ready.
Thank you.
Thank you.
You have the next caller.
Welcome. Please state your name and your address, and you can begin your testimony. Thank you.
Thank you. My name is James Haggerty. I live at 1702 Riverwood Drive. I am directly across the street from Ivy Drive. If you're looking out my front door, you're looking at Ivy Drive. And like everyone else that you've heard from, I am vehemently opposed to this idea. I'm not opposed to development per se, but I feel that this is irresponsible and does not suit the character of the neighborhood, as everyone else has said. I believe it's going to create some safety issues, both environmentally, for wildlife, and also for people. That many cars, it cannot fit, and I think it needs to be re-examined and scaled back to a more responsible number that is in harmony with the neighborhood, because this current plan is most definitely not. And I would ask that you really listen to what people are saying here, the people that live here. I've been a homeowner here at this house for 15 years, and this development would directly impact my quality of life negatively and everyone else in this neighborhood. The traffic flow, everything about it is just irresponsible. And I would beg you to really look at this carefully. And also, I want to let you know that I received no notification of this meeting, and I would really hope that we can do this in a more public forum, because I believe these concerns are valid, legitimate.
Oh, you have 30 seconds.
Thank you, and should be done so in a public forum. Thank you for your time. everyone stay safe, and I appreciate it. Thank you.
Thank you. Next caller.
Chairman, you have the next caller.
Welcome. Please state your name and your address, and you can begin to testify. Thank you.
Hi, my name is Dwayne Henson. I live at 3907 Ivy Drive, directly adjacent to the proposed cluster. I'd just like to say that in addition to all of the points that have already been made, I also would like to thank you for jumping through all the hoops to host a virtual meeting. I've done it for years, and I know what a pain it can be. And I also know from doing that it significantly impacts the ability to have a bunch of people in a room and to play off of them and to read their responses. And I want to go on record as saying, had this not been a virtual meeting, I think that the comments of everyone would have a lot more impact than they do currently. But I'd also like to say that this is hard to do just talking to a phone. My main issue is stormwater. As I mentioned, I live directly adjacent. And currently, when we get a decent rain, my backyard kind of fills up with water. And that's even with the paved ditch that goes across the property currently. Now, if you look at the plan, and I did not send in any supporting documents, I did not know that was an option. However, I had one printed out to bring to a physical meeting. But if you look at the plan, the stormwater drain type, whatever it is, the black line that goes down and under the road has two 90-degree curves in it. And I would...
you have 30 seconds.
Thank you. And I would just like to remind everyone that is a recipe for disaster because those will get clogged. You wouldn't believe the amount of stuff that washes off my property from the rest of the block. So I'm just curious how you guys are going to support me when if it gets approved, that it floods my house. Anyway, I strongly urge you not to approve this plan. Thank you.
Thank you. Next caller.
Chairman, you have the next caller.
Welcome, and please state your name and address, and then you can begin testifying. Thank you.
Yeah, hi everyone. My name is John Yankee. I live at 3931 Ivy Drive with my wife and 3 children. I won't go over the reasons why everybody else has already stated their opposition to this plan. I'm not against all development. I am, a reasonable number of houses can be placed there, but I think this is too many. I'd also like to draw attention to possible issues with emergency vehicles as a result of the grading and the long cul-de-sac. I don't know if they would have issues there. And if you look at the plan, the stormwater pipes also have 4 90-degree turns to accommodate all the housing. And I think that may cause an issue with debris buildup. Anyway, again, I'm against the plan. I'd like to thank the commission for their time, and thank you.
Thank you. Next caller.
Chairman, you have the next caller.
Welcome, and please state your name and address, and you can begin your testimony. Thank you.
Hi, my name is Heather Lose. I live with my husband, John Reed, at 3819 Moss Rose Drive. I was on hold when someone else mentioned the 90-degree bends and the water pipes on the plan. These are a terrible design because of the way that runoff happens on this property. These are certainly going to clog with debris. And so my question would be, if this plan is approved as planned, who is going to maintain this inferior design, and who is going to protect me and my neighbors over here on Moss Rose when those clogs invariably happen and we get flooding? The second thing I want to question is earlier, Mr. Sloan suggested that the stream had been termed a wet weather conveyance by TDEC. I would double check that. To my understanding, it was classified as a stream. It is a spring. It's got fish in it. It is not just a stormwater conveyance. The third thing I want to say is, just like all of our other neighbors that have piped up about this, no one visited us about this plan. We just kind of stumbled across it.
Okay.
Thank you. And we're just very disturbed that the quality of our living could be so negatively impacted for years, along with all of our beloved neighbors. So thank you so much. I know this meeting is going on forever. Thank you so much for hearing us, Planning Commission. Please do the right thing. That's all I've got to say. Thank you.
Thank you. Next caller.
Chairman, this is Sean Shepard. I wanted to confirm that at this moment, we do not have any additional calls in the queue. We're going to take a small pause to make sure that we don't receive any more right at this moment. While that's happening, Lisa Milligan is queuing up an additional audio file. We were made aware while the live call-in was happening that we had one additional voicemail, and we wanted to make very sure that that was entered into the record. And then, so we'll play that, and then I'm also seeing, as we're getting that ready, that we are receiving another call. So if you would check in with me again after we've played this voicemail, I'll let you know where we are with the live call-in.
Okay, thank you. Lisa, play it.
Hi, my name is Brian Owings. I'm calling about case number 2020S064001, 3901 to 3905 Ivy Drive. I'm calling in opposition of this case. I've lived in this neighborhood for 20 years.
Yes, Chairman, I'm sorry it was playing. Were you all not hearing the audio?
No.
Okay, let me restart it. Apologies.
Hi, my name is Brian Owings. I'm calling about case number 2020S064001, 3901 to 3905 Ivy Drive.
Chairman,
I'm calling in opposition of
I
this
can hear from my
case.
PC, but if you are on
I've lived in this
phone
neighborhood
device,
for 20 years.
the file is not playing.
Oh, okay, got it.
Yeah, if you log in, you can hear on the PC.
Got it.
Thank you, Commissioner, for the clarification. Lisa, would you mind restarting that one more time, please?
Thank you, Lisa. Sorry.
No, we need to know. If any commissioner can't hear it, please let me know so we can make sure that you are able to hear all of the materials being presented.
Hi, my name is Brian Owings. I'm calling about case number 2020S064001, 3901 to 3905 Ivy Drive. I'm calling in opposition of this case. I've lived in this neighborhood for 20 years. I live on Riverwood Drive, but I own the house at 3920 Ivy Drive. And I know that street and this neighborhood very well. This is a terrible idea for many reasons. The traffic is going to go through the roof. You're going to add probably 60 cars for 30 houses. There's a floodplain on Moss Rose below that area. There are no sidewalks. It's just a crazy idea. It's a bad idea. And it's going to, there are no businesses nearby. The main corridor is Gallatin Road, which is about 2 miles away. It's just a terrible idea, and it just reeks of greed. And I I vote no. I hope you will do the same. Thank you. Bye.
Okay, thank you. So that concludes the voicemails that we have on file, and we do have 2 additional live call-in numbers. So with your agreement, Chair, we'll go back to the live call-in portion.
All right. Yeah, next caller.
Chairman, you have the next caller.
Welcome. Please state your name and your address, and you can begin to testify. Thanks.
Carolyn Breda, 2808 Shadow Lane.
You can begin testifying.
I
Thank you.
want to applaud the Planning Commission. I know these are difficult times. I also want to applaud my fellow neighbors who have come in so many numbers to express their views. My personal view, how is it that any rule, especially one called an option, can allow one developer to come into our neighborhood and violate it in opposition to the vast body of regulations that should protect it? And then they take off as if nothing wrong just happened.
Okay, thank you. Next caller.
Chairman, you have the next caller.
Hello, please state your name and your address, and then you can begin to testify. Thank you.
Hi there. My name is Jackie Rogers, and I live at 3815 Moss Rose Drive. I just really opposed to this development. 30 cluster homes just seems like an excessive amount of housing. I just don't understand why so much greed in this time of global warming, and we just had tornadoes. I mean, I would just think that you would want green space in your neighborhood. I mean, you need the earth to absorb all this water that it rains so much, and my backyard is just floods all the time, and the crawdad population in my backyard has just dwindled since that last flood we had. I just don't understand the greed of this. I mean, maybe 5 mansions on that property would be acceptable, but 30 cluster homes, come on. This is just not appropriate. And I'm going to stop my ranting, and thank you very much for hearing my thoughts. Bye-bye.
Thank you. Any other calls, Sean?
Chairman, I can confirm that we do not have any other calls at this time.
Thank you. All right. With that said, we are on rebuttal, and then once the applicant has 2 minutes for rebuttal, and then the council person. So is Mr. Sloan on the line?
Chairman, he should be ready to speak now, yes.
Applicant, you got 2 minutes. Mr. Sloan?
Chairman, he is unmuted.
Can everybody hear Mr.
Hello,
Sloan?
Chairman, can you hear me now?
Yeah, I can hear you now. There you go.
I think my last device just died. I apologize for that. I wanted to address a couple of the issues that were raised And one in particular was regarding the grading. The plan currently is to build the homes with the grade as it exists, and not to grade down the lots. I know that issue was raised a while back. To that end, the record has a communication that was sent to the planner handling the case. And if I could just read what was sent in, it says that the existing stream buffer is preserved in an open space and shall not be disturbed. The majority of the steep slopes will be preserved in open space outside of the lot boundaries. Those lots that do contain steep slopes will be labeled critical lots and will be permitted with detailed grading plans so that so as to preserve the natural slopes in excess of 20%. I do also want to point out that they are meeting the requirement of recreational facilities, and the language in particular in 1712-090 states, as it defines those recreational facilities, as I'm trying to get it, for the purpose of this section, recreational facilities mean active play facilities, including but not limited to tennis courts, basketball courts, swimming pools, playgrounds, basketball, softball diamonds, and volleyball courts, and passive amenities, including but not limited to
you have 30 seconds.
Walking trails, picnic shelters, gazebos, and shared docks, and similar passive amenities also qualify. Those are some of the issues raised. I would again point out that I didn't hear any challenges to the staff's recommendations or their application of the guidelines.
Thank you. And is Councilor Benedict online?
Yes, Chair. Thank you so much.
You're recognized.
Thank you. So first of all, thank you to the members of the Planning Commission, and of course to you, Chair, and most importantly to the folks that have called in tonight and expressed their concerns about this, and also to the applicant, who I know is I'm going to talk through some things first. I feel hopefully won't take much more than 5 minutes for you, but I want to read into the record the letter that I sent to the Planning Commission this morning. I think it's important for the community to hear that. So I'll start there. Members of the Planning Commission, I stand with the neighbors in opposition to this plan as currently outlined. I've met and spoken to the developer and the neighbors many times over the past 2 months. The developer has offered a handful of concessions to make their plans more acceptable to the neighbors. However, he will not reduce the proposed density. This location is deep in the neighborhood. From downtown, it's a 16-minute drive, which is the same amount of time as it takes from downtown to Goodlettsville or Antioch, both suburban neighborhoods generally with less density. Although the current zoning code allows the density being proposed and that it technically matches the density in and around the property, it is far more dense than our city should allow in a location on sleepy 2-lane roads just steps from the Shelby Bottom Greenway. Moss Rose Drive is a gateway to the city for cyclists. This greenway is to Englewood what Percy Warner Park is to Bellevue. This development, as currently proposed, will forever change the peace currently enjoyed by the area residents. There has been much talk of equity lately and of putting people ahead of profits. This developer stands to profit at the expense of the community, and even more troubling, at the expense of the deer, wild turkeys, and red foxes, in addition to losing oak, maple, and hickory trees. I urge you to rule against this concept plan. This does not create affordable housing density, as these homes will sell at 33 to 50% more than the current average home value in our city. You can help protect the tranquility of this little nook in Englewood. Some density could be expected, but again, this is too much. Let's keep this area equitable for Nashvillians for decades ahead. And then, Chair, I'd like to read a timeline of events. In addition to that letter, I think it's important to share this timeline with the Commission of events that have taken place. So on February 25th, we held an in-person meeting, which included Mr. Wilkinson from the council office, Ms. Ziegler from the Historic Commission, and the applicant. Over 100 community members attended. And at the conclusion of that meeting, it was clear that a subsequent meeting needed to be held in advance of the March 12th Planning Commission meeting. A week later, Nashville was ripped apart by tornadoes, and just over 1 week after that, we were put under a safer at home order. The March 12th Planning Commission meeting was canceled as a matter of public safety, and this item was then deferred to March 26th. An additional community meeting was held on March 18th via Zoom. After that, the March 26th Planning Commission meeting deferred all agenda items except for those on the CIB. I was then asked by the community for a call with me alone, at which time I shared details about the subregs and information that the planning department had provided me about these types of developments. I shared that in both verbal and in written form. That meeting took place on April 2nd. In the meantime, I had begun conversations with the applicant to determine if he would make any concessions to the community. As you heard from Mr. Sloan, Mr. Kenner, Mr. Kenner began a dialogue with me about providing sidewalks from the development north to Fremont Avenue, in addition to design input from the neighborhood, tree conservation, public walking trails, and a three-way stop at Moss Rose and Ivy Drive. Finally, the April 9th Planning Commission meeting did not provide a good way for the public to be heard. And on the recommendation by the Planning Department, the applicant agreed to another deferral to today's date. The Planning Department and I had a conference call yesterday with Robbie Lynn Hunsinger, who's the founder of the Save Ivy Drive group, and her council also attended that call. In that call, Director Kemp, Ms. Milligan, and Mr. Poole helped provide an understanding of the subregs as well as details for today's meeting. In the past few days, I've communicated with the applicant and the neighborhood group about a community benefits agreement, and also about creating a specific plan that would memorialize the commitments to the community that he's offering. That concludes the timeline of events. I've been clear with the community and with the developer that I do not support this type of development. This land will eventually be developed. I would like it to be less dense, perhaps with 15 to 20 homes instead of 30. This is a sleepy neighborhood with narrow lanes and within walking distance of Shelby Bottoms, which is the largest park that East Nashville has. My understanding is that the cluster lot option is a technical review by this body, and that if the applicant meets those criteria, then the concept plan will be approved. I asked this body to review each lot to see if fewer homes could be built, or if changes could be made to preserve as much of the natural habitat as possible. If there are any technical criteria that have not been met, then I ask you to use your role to disapprove your plan. To disapprove this plan. With that in mind, I'm aware that there are at least 3 backup offers from other potential buyers of these parcels. I anticipate that any developer will build in a manner that will maximize their profit as well. While nearly no one wants density in their neighborhood, I do think that there is an opportunity to work with this applicant to find what I would call the least worst development for the community. My constituents have my commitment that I will work with him to improve his plans as much as is possible, including seeking his commitment to move forward with a community benefits agreement as originally offered. However, again, if there are any criteria that have not been met, I respectfully ask you to disapprove this concept plan. Thank you again for your time and for your commitment to the city of Nashville and the betterment of our community here in Englewood and in District 7.
Thank you, Council Eddie. Appreciate your comments very much and all of your hard work on it. So at this point, seeing that there's no other callers, let's double check. No, we've already heard rebuttal. So there's no other callers. There's no other recorded comments. We declare the public hearing closed, and we will go to discussion on this item with the commissioners. Vice Chair, do you want to go first?
Sure. Lovely. Okay, this is definitely not a very easy one at all. So the intent with the cluster lot is to be focused on preserving and protecting all the environmental features. And clearly we've heard that steep slopes are a concern on this property. can staff tell me again, what are the slopes on the site? And do we have steep slopes that are greater than 20% or greater than 25%?
Hi, this is Logan here. We do have a slide that I think we can show here that demonstrates the existing topography on the site. The legend in the top left describes the level of slope that each color represents. So we do see here some slopes that exceed 15, 20, and over 25.
Okay. And does the plan that we have, does it show development around these slopes? Or has it pulled out these steep slopes in order to do the development plan?
So the applicant has provided a description of how their plan attempts to protect the natural features of the site, including the slopes here. Mm-hmm. If you notice, the street layout follows the non significant slope portion of the site.
Right.
And you'll see the open space also reflects where that red greater slope area is. So when staff reviewed this description of the plan and the preliminary grading plan that they provided, we did not have any concerns.
Okay.
Logan, can you clarify, since this, forgive me, the stars, what do those represent on the screen there so the commission knows?
The stars represent critical lots. Those lots have portions of them with slopes exceeding 20% slope. If I'm not mistaken, I believe it's 20. So those lots, when they come in for permitting, will go through the Hillside Development Standard Review, which is basically a more detailed review of their standards in the code about where the footprint of the structures are proposed, any retaining walls, if those are being done, that they're being done so that they're being as sensitive as possible to the landscape. So those have an extra level of review during the building permit process.
Okay. And have we seen a grading plan yet? I know that was one that was brought up. I mean, and is there the concern about mass grading versus individual lot grading?
We haven't seen a grading plan of what the proposed development would exactly look like during the concept plan phase. We get a preliminary grading plan, which is essentially the plan that was shown earlier with the site plan overlaid on the existing grading of the site. Staff takes that plan in combination with the description of how the developer intends to preserve the site, and we try to identify any conflicts or potential conflicts with the plan that they've shown and the grading of the site. And staff didn't have any concerns with what we were shown.
Okay. Does staff feel like it's appropriate to build on these critical lots, given in those where the slope is 20% or greater? It seems like, trying to protect the natural features is a critical component here with the cluster lot, and yet we're talking about building on those same lots.
So this is Lisa. Let me just say that it does allow for lots to be created with slopes over 20%, but they then are designated as critical for further review. And so that's what the regulations permit.
Okay. I mean, I just think that's something that we should consider. It's an area that we want to try to preserve, and to end up seeing, significant development I know we'll see how they're going to do that going forward, but in terms of us approving this tonight, those raises a lot of concerns for me that I think we should consider and address. And can you also talk, a couple of people mentioned the length of the cul-de-sac. Is that something that we need to take into consideration?
So the subdivision regulations allow for an option that is a walkable subdivision is what it's called. And that provides for a shorter cul-de-sac allowance than a conventional subdivision. But this is under the conventional subdivision regulations, and it does not exceed the maximum length that's allowed of 750 feet.
Okay. So does the commission have any discretion around the treatment of the critical lots and whether or not there's an option to look at development not including the critical lots? Or to look at a concept plan that would not include the critical lots?
Lisa, it might be helpful to read perhaps into the record so the commissions has the language that governs this section of the code and the subregs, where the 20% and 25% are called out. Do you want me to? I can read it. It's in the Hillside Standards. Sorry, go ahead.
So from the subdivision regulations, under 3-3 suitability of land, number 2, it says when a proposed lot contains natural or man-made features that affect the feasibility of construction, it shall be designated a critical lot during the concept plan, final site plan, and final plat review process. It says a lot shall be designated critical when the lot is created on a natural slope of 20% or greater, or where it contains natural floodplain. And then it says that under number 3 of that same section, any lot that will be created as a result of the grading process that meets the definition of a critical lot shall also be identified as such, and then it should meet the applicable development standards. I'm sorry, I skipped the wrong part. C under 2 is lots on steep slopes shall be subject to the hillside development standards of section 1728.030 of the zoning code. That section of the zoning code, I'm sorry, I'm flipping. States that within residential districts, the development of residentially zoned properties shall minimize changes in grade, cleared area, volume of cut and fill on those hillside portions of the property with 20% or greater natural slope. Approval of final site plan for a critical lot established by the subdivision regulations shall be based upon demonstration that the proposal takes into consideration factors such as, but not limited to, soil conditions, degree of slope, and feasibility of construction. The standards for review of critical lots from the adopted subdivision regulations shall apply. In regards to cluster lots, it says that single and or two-family subdivisions in areas categorized by 20% or greater slopes are encouraged to employ the cluster lot option provisions of section 1712.080. In general, lots shall be so created shall be clustered on those portions of the site that have natural slopes of less than 20%. The Planning Commission may authorize lots on natural slopes ranging up to 25% subject to special standards and conditions noted above. Large contiguous areas containing natural slope in excess of 25% should be recorded as a common open space and permanently maintained in a natural state.
So if I heard you right, it sounds like the Planning Commission is authorized to determine whether or not we think development is appropriate on those lots that are that have up to 25% or up to 20% steep slopes.
The Planning Commission may authorize lots on natural slopes ranging up to 25%, subject to the special standards and conditions noted above.
Okay. So that does imply that there is some discretion from the Planning Commission in terms of whether or not we think these lots should be included on the overall concept plan.
The zoning code says that you may approve, may authorize.
Okay. I think that's something that we should just take into consideration. I mean, given we're trying to preserve as much open space as possible, we have, you know, there's actually quite a few critical lots in here. I mean, you've got 1, 2, 3, 4, 5, 6, 7 out of 30 that are considered critical lots. If I'm counting my stars correctly, I just think that's something that we should take into consideration. And, you know, I would prefer to see a plan that actually, or have some conversation about whether or not we should actually be including these lots in the final concept plan. I guess I'll turn it over to other commissioners to ask some more questions, but I'm definitely still thinking about this.
Thank you, Vice Chair. How about we go to Commissioner Tibbs?
Yes. Lisa, or I forgot, but can you put the slide up again that did the subdivision, like how it met all the requirements? You had it, I could put, yeah, there you go. So I was trying so basically the analysis that it met all the standards that it did. I guess I do want to pause real quick too to say that, can you guys hear me okay?
Commissioner Tibbs, let me point out that these compatibility standards only apply to the 2 lots that front on Ivy Drive, because those are the only lots that are fronting on an existing street. So those are the only ones that are required to meet these standards.
Okay. All right. Thank you very much for that clarification. I was trying to go back to that. One more thing back to, I think the Vice Chair brought it up, but can you just restate again? So there's understood about the preliminary grading study that is required, and I'll admit that was what the applicant's attorney brought up. I tried to write down 3.2.4. And I think basically you are saying that they did meet that requirement, but even though it's very preliminary.
Logan, do you want to address that?
Sure. Essentially, yes, staff found what they submitted to meet their requirements.
Okay. So now these are general comments. I generally feel like, you know, if I guess it meets the requirements of the subdivision, and I've been, you know, during all of it, I was trying to look for tools that we had. I do feel like it's dense, and but I don't see the tool that I can use probably to really lessen up the density on it. I also, but I, you know, as I think the council person said, it's not necessarily that it's the wrong place for development, it's just the density. I also want to pause to say that although they all were very, we're not exactly happy about this format, I was very impressed actually with how all of the community people spoke, and they were very clear. And in some ways, it was actually more impactful for me. So I do feel like, although there's definitely not ideal not being in the room, but they did a great job, and it gave me an opportunity to really study a lot of the things they were saying. However, I just haven't been able to come up with a strong enough case, other than I was, was concerned about the grading issues, because it did seem like it's going to be a lot different potentially, well, by what I studied on the grading, and it's going to be a little bit different than what they've actually presented today. I wish I could maybe see it a little bit further along to understand exactly how they're planning to achieve it. Because, Public Works has signed off on it, and everyone I'm gonna just, understand they probably have met the requirements that were necessary. One last thing, and forgive me if just during the time I forgot it, but was there a traffic study done, or was it necessary for this?
I believe we have Public Works on the line as well.
This is John Bogosian with Public Works. Are you able to hear me?
Yeah, hear you fine.
Okay. And the question was a traffic study done?
Yes.
So the guidelines set by Metro Council define thresholds for when traffic studies are required. Threshold for residential development is at 75 units, and so a traffic study was not required with this development.
Okay. Yeah, that was what I was wondering, if it was able to have a traffic study. Well, like I said, I do feel like there's a density potential issue here with it. I wish there was a few less units, but I don't see a tool necessarily to be able to reduce that. So I'm interested in hearing what my other commissioners are saying. There's other maybe comments after that. Thank you.
Commissioner Sims?
Yes, sir. Okay. I have several concerns about this, and if you'll bear with me, first of all, my sincere gratitude and awe at how well we've been able to pull this off, particularly the IT department and the planning staff. A meeting like this, with being able to hear from as many people as we could, has been pretty awe-inspiring for me, and I appreciate how hard you've worked to keep our city going. I do have several questions and concerns about this. One is, I think you've been over backwards as a staff to make sure that we really meet the open meeting laws, and that we really give as much footing as we can for a fair public hearing. So I'm not concerned about the process of this meeting as I am the process of engagement with the community prior to this, and their ability to be notified in a timely manner, and their ability to work with the developer during a stay-at-home order in a pandemic. I think the councilwoman articulated it very well, that there are some opportunities here to get this better. And so I'm really concerned that we look at, are we doing all we can to not just meet the letter of the law, but also the appearance of fairness. And there is a real, in public policy, there's a term called the appearance of fairness doctrine, which really says we not only have to meet the letter of the law, but we need to appear to be fair in all the areas that lead up to our public decision. The second thing I'm kind of concerned about is the intent of the law for these cluster subdivisions is not a new area. It's been debated for decades in our country. And it has always been a struggle between how do we build more density in areas as cities grow, and at the same time preserve valuable land, conservation land that may have some areas that are simply difficult to build on. And there's always that tug of war between those goals. And in this case, because we are operating in really uncharted waters and with a multitude of challenges, I really think we have to err on the side of caution here and make sure that we are preserving the environment. I loved what Commissioner Farr said about these critical lots. And although there was a preliminary grading permit, it doesn't offer us the kind of detail that I would like to see in determining what should be open space, what should be buildable, what's not. And I am concerned about that one of the trade-offs for communities in looking at the technical part of this is that there should be open space and there should be recreational area that meet the needs of the community. And I've always struggled with how we meet the needs of community if we're not in dialogue with them. And just simply giving space that can't be built at all or is under some kind of federal guideline is not really the intent of this law. The other thing I have is I think we do have a real issue here of having two really opposing goals. One is trying to build on something that it will be built on, as the councilwoman said. It's not a question of if, but it's when and how do we do it well. And on the flip side of that, of really taking into consideration what compatibility means. I really kind of resist being put into a technical review only. I think, and for the public that's listening to this, and I know there's hundreds of you guys out there that are concerned about this particular project, I don't know how we can do simply a technical review in a time when almost all things have come to a stop. And so I'm concerned that we really move on, like I said, err on the side of caution here. And everybody so far has not said, well, many people said vote no, but many have asked simply for deferral. And particularly because the developer seems to be willing to offer a CBA, but how do you really pull a community benefit agreement together when the community is by law not able to convene? So all those are concerns I have about this, and I know I'm always kind of the outlier voice in terms of making sure the neighborhood is really heard loud and well, but that's where I am right now. So I want to keep listening, but I am leaning towards saying no to this.
Commissioner Goebel? Pardon me. I'm not used to being quiet this long. First of all, I want to compliment the neighbors for giving an excellent presentation. I think it was very thorough and a lot of detail. And also, I agree with the staff and their initial analysis. One question for legal, if I might. When we talk about a cluster lot option, it's really the option of the landowner or the applicant to choose to decide if they're going to go that option. It's not our option to pick one or the other. Is that correct?
Yeah, this is Cornpool from Metro Legal. That is correct. It's in the code, and it's sort of a by right entitlement that they have. Moreover, it's also listed in the subdivision regulations as something that's appropriate as an option for any property owner to use. And so it's up to the applicant to decide whether they want to cluster their property in the manner that's provided by the Title 17 and as provided in the subdivision regulations.
Okay, thank you. So that being said, I think that this kind of meets the letter. I mean, again, I'm sympathetic to the neighbors, and I understand it. It does meet the criteria of the regs, and the courts have been very clear. That's really all we can look at. Now, the grading issues are an issue of concern. I am concerned about the lots and the critical lots, but I'm also concerned about, how do you actually put in a 100-foot cul-de-sac in the side of a hill like that, as one of the speakers pointed out. Is there a way we can ask for more information on that, or is that something that we can put in as a condition into this structure? And I'm not sure who I'm asking on this, but that area where you've got you're kind of squeezed in between a retention area and a cul-de-sac. It does seem difficult to understand how they're planning on engineering that. Is there some way we can ask for more information on that?
This is a good question for our director.
Yes. What I would recommend, as we typically would, is once all the commissioners have raised the questions and issues, and we have a sense or a motion of the direction we want to go in, then I can offer some suggestions about, either conditions or requirements as is appropriate. So let me put some pen to paper on that while we wait for the remaining commissioners.
Okay, that's my concern. You know, again, the courts have been very clear about our ability to, we have to comply with the law, and I don't see any reason this doesn't comply with the regs. So I'm inclined to support it with those conditions. That's me. I'll listen some more.
All right, how about Councilor Murphy?
Thank you, Chair. I have a lot of notes scattered all over my paper here that I hope I can be at least without jumping around too much. But first, I wanted to start with saying that it's interesting that Mr. Sloan quoted so much of the Pennington case. As many of you on the commission know, the Pennington case that overturned a subdivision approved by many of you on this commission was a subdivision in my district. And in fact, tonight, Mr. Sloan was also representing a client that was re-subdividing what you overturned. That doesn't necessarily make sense. So let me back up. So y'all turned down a subdivision because it was harmful to the environment and not harmonious to the neighborhood. The courts overturned that, and it turned out that it simply was not a developable plan. So a new developer came in, and Mr. Sloan is representing them, and we have already passed it on consent to re-subdivide that property. So I find it very interesting that Mr. Sloan would almost, I don't want to use the word threaten, but, it remind us of our legal responsibilities and how often the court would come down on us in subdivisions when the very court case he is quoting is a property that we re-subdivided tonight because that plan was simply not developable. So I wanted to kind of put a little bit of, it is nice when we have some legal history and theory and case law given to us. That is very useful in guiding our decisions. But I think that when so much time was focused on that, I think it is almost a red herring to look at the real problems with this cluster lot in front of us. And in fact, the more I see cluster lots come before the Planning Commission and looking at them in planning reports before I was on the commission, there are problems with almost every cluster lot, and I think we really need to look at the subdivision regulations around them. So when I first looked at this cluster lot plan, what stuck out to me is just the odd shapes of the lots. And I understand that cluster lots are supposed to, as the analysis says, it's to promote creative designs. I do not think creative designs are lots you draw up to avoid hazards. Like if you're designing a golf course and trying to avoid the sand trap and the water hazard, that's basically what we've done here. I find it extremely disingenuous and almost disgusting that this creek was somehow reclassified from being a creek when I know firsthand that less than a mile from here, there was a whole street flooded out in 2010. Literally, this is an area that floods and that our Metro firefighters had to evacuate residents because of the 2010 flood. And that's extremely concerning to me when additionally the fire marshals revised comments to us that came to us today said limited building details provided subject to further review and approval. To me, that's not an approval by the fire marshal. That says that they weren't given enough details, and that's not a sign off in my opinion. Having represented firefighters professionally for 13 years and hearing them talk a whole lot, looking at these two little cul-de-sac roundabouts, I don't see how, if you had a major fire in here, how you get a tanker truck and a ladder truck in here safely and evacuate people if necessary. And I have serious concerns about the lengths of streets, the way that they are laid out. And clearly they were done that way to avoid the steep slopes, which takes me to, I think, echoing Commissioner Farr's concerns about the steep slopes. There's a lot of steep slopes. And again, the grading plan, reclassifying this creek when so close to this area, it flooded, not just in 2010, but on a regular basis. It leaves me with a lot of concerning questions that it seems like the homework was almost halfway done here. That the full story is not being told here, and that really this property could be developed. And I know that developers a lot of times say the highest and best use, but the highest and best use also takes into account the highest and best use for the end user. And I'm concerned about the future property owners here and the future neighbors and future constituents of Nashville and taxpayers are going to find out that they're going to have a lot of water issues and a lot of flooding issues, because I think that they are being ignored or brushed aside here. The fact that the developer or Mr. Sloan threw out there that the developer's willing to do a community benefits agreement, including $50,000 for sidewalks on streets, to me, that you don't agree to do a community benefits agreement, but then you turn down an SP. That basically is saying like, oh, I'm willing to do a non-binding agreement to get the neighbors to say yes, but I don't want to take Council Lady Benedict's offer up for a free rezone that would hold me accountable for the promises that I made in community meetings. So that's very concerning. I am concerned about what was brought up about the notices to neighbors. I want to make very clear that I am not criticizing the staff here. I think this is just an issue of what we are going through with the fact that there was a tornado nearby this district, and then COVID-19 hitting us in the face right behind that. And notice to neighbors and making sure signs are accurate and re-noticing things, it's important. And I'm concerned that, did all the neighbors even get re-noticed if there was notices? Were there even re-notices of when this was going to be up, how the format was going to be, and things like that? And again, I know it's extremely difficult, and I know our staff has worked very hard. And let me tell you, this meeting has gone a lot better flowing with community input than the council meetings have gone. But this is no way to proceed as a quasi-judicial body by any means. And so I really feel that this is not a development that is harmonious to the surrounding area. I do not feel that these lots that are tiny next to like shallow lots next to deep lots are harmonious with the greater part of the neighborhood. I don't think that I do think that if we approve this, we are going to be doing environmental damage. That there is, I don't even understand how you reclassify this creek without notifying property owners further down the creek that were flooded out, that all of a sudden this is no longer a creek that floods. So I think all of y'all can read between the lines that I'm a little fired up about this, because I just see red flags all over the place. And in good conscience, well, earlier I did say that we don't, we needed to hear this out. And I'm glad that we heard the neighbors out and we heard the developer out. But I do not feel that we have sufficient information or sufficient information to draw a conclusion that this anywhere meets our subdivision guidelines, or that it is good for our community. So with that, if you want to come back to me for a motion, I'm willing to come up with one, but I am very uneasy with this plan before us.
Thank you, Councilor Eddy. How about Commissioner Moore?
Thank you. So I have quite a lot of notes that I'm having a hard time following. I think a lot of my questions have been answered through some of the other commissioners' questions. I think what's really sticking with me, so we know that we looked at the compatibility standards and it meets those. But I think I'm concerned about two things. The biggest one is the ability, not today with, I think we've done a really great job of making do with the current pandemic we're in with allowing the public input today. But I think Councilor Murphy mentioned all of the notifications and how those could have been lost within the tornado and the COVID-19 pandemic. And I know Commissioner Sims mentioned that if you're going to have proper community input, it's kind of impossible under our circumstances. And this is a very beautiful piece of land, and I can understand why all the neighbors are so passionate about wanting to maintain as much of that as possible. I know that the applicant mentioned that they were working with a tree conservation specialist, but I was wondering, what do we as a commission have any tools to kind of follow that process? Because obviously there is a lot of environmental features that are very sensitive that I think we should look to preserve. And I know we had quite a few questions and concerns about stormwater. So I also wanted to get input from staff on kind of how that is looked at this stage in the process and moving forward, if this would move forward.
Sure. Lisa, is there someone from Stormwater on the call who could walk us through the phases of stormwater review?
Yes, Gabe Moore with Stormwater is on the call.
Okay, Gabe, so all you need to do is unmute yourself. Sorry, the chairman, I'm kind of weighing in your job here. Sorry. Unmute yourself, and then if you could walk through the phases, that would be great. Sorry about that.
No, thank you. I appreciate that.
Can you hear me now?
Yes.
Hello? Gabriel, can you hear me?
Gabriel, we can hear you. Go ahead. This is good, Chairman.
Thank you. Thank you, Commissioner. So a couple of the issues that I can address quickly and expound upon if needed be, of course, with the stream that was brought up by Commissioner Murphy a minute ago, that is and I can read directly from the regulations here. Let's back up. So when a stream from our regulations channels identified on Metro's GIS layer as streams or as draining 40 acres or more must be buffered, and the developer can clearly demonstrate the water course in question. When that is the case, the developer has an opportunity to prepare a hydrologic determination, which has been done for this stream. That determination is completed by what's called a qualified hydrologic professional. That is someone who's been qualified by TDEC to make that determination, to form the report and submit that document to TDEC. That has been done in this case, and TDEC typically will either agree with or not agree with that determination. In this case, they have agreed that the stream basically begins at the spring box as what is being shown in the plans. Certainly understand and know that there's been flooding that's occurred downstream, at least from the 2010 flood in this area. And my opinion, I have not studied that, but would be a backwater issue from the Cumberland there. But that is simply an opinion at this point and has not been studied. Of course, with any project like this, we take the review process is to make sure that the post-developed conditions meet or less impactful than the pre-developed conditions. And typically for a site like this, you're going to have, as you commissioners, I'm sure you well know, detention type facilities as well as water quality facilities, and they've designated areas on the plan for those. And of course, at this stage in the review process, it is simply conceptual. Calculations have not been submitted, so we can't really review in detail, but they've certainly allocated those areas to mitigate the post-developed conditions to meet the pre-developed.
Thank you, Gabriel. Or Gabe.
Either way, thank you.
Thank you.
Thank you. And then my other question was about looking at tree canopy and things like that. Again, the applicant mentioned they had some things in place, but do we have any tools to add conditions or see that the heritage trees are saved during the development process or anything like that?
Hi, Commissioner. I can weigh in on that. In regards to tree preservation, there is no specific requirement for tree preservation in subdivisions of 1 and 2 family homes.
Okay. So overall, I think I am leaning towards Commissioner Sims and Council Lady Murphy with real unease in moving forward with this right now, but I'll continue to listen.
All right, thank you. How about Commissioner Johnson?
Thank you, Chair. First of all, I want to thank again all the community and IT and planning staff. So this public hearing were not ideal, but under the circumstances, that's the best possible public hearing we could conduct. And I really do appreciate everybody's participation and input. So, and I do appreciate, previous commissioners, all the great questions and input. So I have been studying about subdivision regulation. It's a 105 pages document. So it's not easy to state and, remember every time when we have to approve or disapprove, consider subdivision proposal. But I think, what we as a commissioner, I believe we have to adhere subdivision regulation. So in that regulation, it clearly states the purpose of this regulation is intent to provide the harmonious development of the municipality and its environs and for the coordination of the street within subdivision and so forth. And also interpretation. These regulations are intent to promote the health, safety, and welfare of the persons within this jurisdiction. And towards that purpose, these regulations may be liberally construed. So to me, it's our duty and authority to fully understand regulation and apply those regulations to determine the proposed plan meets intention and interpretation. I mean, most important thing is to promote health, safety, and welfare and within jurisdiction. So it does not mean only this within that development plan, but have to consider all the surrounding neighbors, streets, and all the environment. So, my concern, I mean, if you would, I don't know if you can do that, can you bring up the map showing the elevation, the colored map, green, yellow, red? Thank you. So the lot 29 and 30, those are measured, identified as a critical lot. And I do not see how this lot will be. I see the line, the parcel line, how will be created as a square, but I do not see how it will be graded and how this subdivision will not have any negative impact to the surrounding neighborhood, especially the lot adjacent to this proposed subdivision on Moss Road. I see they are in the floodplain, FEMA identified floodplain. So creating those two lots in this slope and not knowing exactly how it's graded. And it was explained that grading will not be, considered until final plot approval or until final development. So for that, I am so uneasy to approve this. And we do have, 7 altogether critical lots. And I am not convinced, by creating those critical lots, by creating those 30 lots will really promote harmonious development considering surrounding neighborhood and promote health and welfare to the neighbors. So those are my, number one concern. So having that much concern, at this juncture, approve this is just irresponsible for me. And I won't be able to sleep knowing this if we approve it, because this is the last time we as a commissioner be able to determine the good, bad, improvement and so forth of the project. And I don't think this plan is there yet. And I do appreciate the developers, county trees, and I do appreciate their outreach effort to come up with a community benefit plan. But I don't think this is the best plan for that lot to create 30 lots, including 7 critical lots, which at this juncture, as a commissioner, we do not know how it will be developed and how it will be graded. And so I personally do not have any assurance this will not cause adverse effect to the surrounding neighbor. So that are my biggest concern. But I do have not heard from another commissioner, so I will keep listening.
Chairman, this is Lucy. Forgive me for jumping in. I believe our legal counsel wants to make sure that he's putting some information into the record and clarifying a couple of the legal context for some of the commission's discussion. Let me ask Quan to pop in.
Yeah, Quan.
Yes, this is Quan from Metro Legal. So the portion that Commissioner Johnson just mentioned, the purpose, what she is reading from is section 1.3, which is the purpose section of the subdivision regulations, which states that they are intended to provide for the harmonious development of the municipality. If you go on to read, it states that that's the reason that they adopted the subdivision regulations to promote that harmonious development. So it's not really, that's like the purpose, almost like a mission statement. It's not really a separate specific factor that the commission considers. For example, like we have listed all of these regulations, and the applicant has to be considered against all of those regulations. That's how it provides for the harmonious development. It's not really some catch-all at the very end that and this is what the case law has cautioned about, that you don't get to that provision and sort of say, well, yeah, but they've done these things and they've done this, but I just don't think it's quote unquote harmonious. The cases that I've read have cautioned against that type of activity of using that as sort of a catch-all provision as a reason to deny a subdivision application, because again, it's sort of a ministerial function where the commissioner is looking at the regulations and looking at how this particular development meets those standards, which are laid out in great detail, not just the sort of purpose statement of harmonious development. And another thing that I wanted to also put, another thing I wanted to put on the record, if the commission has a number of options on how to proceed on the subdivision regulation, that they can approve, they can disapprove. But another thing to consider is you can add reasonable conditions to an approval. And so if you think a particular part of the subdivision regulation, staff has made a recommendation that it meets the subdivision regulations. If the commission doesn't want to adopt that, there is still an ability to add reasonable conditions on its approval as it considers it, as it works through these particular topics and these issues.
Thank you, Quan. We appreciate that explanation. And now, Commissioner Johnson, are you finished? I want to make sure. Done.
Thank you, Chair. So in that case, I think I would like to add one requirement, critical lot plan. I mean, we as a commissioner, before we approve, I'm sure prior to concept plan approval, we have to consider the critical lot. And so I do not have any information how the critical lot and sensitive environment will be protected, and grading plan, the applicant is supposed to provide those detailed plan to executive director. But we, as a commissioner, I do not have a detailed plan to be provided. So I do have those questions as well.
Okay.
Thank you.
Thank you. Commissioner Haynes.
Good evening. Kudos to the IT department and the staff for an incredibly well-run meeting. Most of my questions and concerns have been addressed, but I too, much like Commissioner Farr and Commissioner Johnson, are very concerned about the critical lots, especially lots 17 through 20. Would love to get Public Works to comment on the grade of the sidewalks around the proposed cul-de-sac in the middle of lots 17 through 20, and if that meets ADA standards for the sidewalk.
This is John Bogosian with Public Works. So you were asking for me to comment on the sidewalk design within the cul-de-sacs and if it meets ADA standards?
Correct.
This is a conceptual plan, and we did not get into that level of detail. The expectation is that they will have to meet ADA standards when they submit final designs for permitting. that I don't believe we'll make an exception to that.
Okay. Just from a common sense perspective and looking at the grades in that section of the proposed plan, I think that's going to be very difficult to achieve.
Yeah, I would expect they would probably have to utilize retaining walls of some sort in order to meet the ADA standard, but ADA standard is a requirement.
Okay. So, given that most of my questions have been answered, I think I would turn to legal. And is there an opportunity for us to ask the applicant to remove all the lots with slopes greater than 20%? Is that a plausible approach for us to suggest?
I mean, that could be a condition that's placed. I don't know. I mean, I guess you could pose it to the applicant. I don't know if they're in a position to be able to answer that on the spot. They may be open after hearing the conversation that's been had. They may be open to a deferral, but I would say, yes, that is a reasonable condition that could be placed if you're able to tie that to specific things, material facts that you've heard based upon the record that's been presented tonight.
Okay, thank you. Let's, anything else, Commissioner Haynes? And I think
that's it for me. Thank you.
Thank you, sir. And I think the vice chair, she's got a few more questions, and she had initially raised some of this. Vice chair.
Well, I think Jeff kind of just got my question, but I did want to make sure that we had the discretion to make that kind of a request of the applicant to look at a revised plan that would take out those lots with greater than 20% slope.
So the question is, let's ask the director. I know Mr. Sloan, the applicant is probably still on the line.
I mean, we read through sort of the guidance from the code, which said generally we're to avoid slopes over 20%, and that the commission may impose, additional restrictions around the critical lots. And so one scenario is to recommend a deferral with a revised plan that does X, Y, or Z in terms of the slopes and in terms of the grading plan with information that you're looking for regarding how the roads are going to be and how the infrastructure is going to be addressed, not by current contours, but by proposed contours. Right. And so that's one path forward. I think sort of your discretion if you want to ask for a response from the applicant, but what I'm hearing from legal is that you do have some discretion if you can tie it back to the evidence that you've considered from the staff presentation, as well as the other evidence from the case.
Well,
is that correct? Is that correct, Quan? Do we have our interpretation down there correctly?
Yes, I would agree with what the director said.
Okay. Well, Vice Chair, you could try to craft up a motion to look at the critical lots, and also.
I think I would prefer to do a motion for deferral versus trying to create a bunch of conditions at this point.
I mean, it would be a motion to defer, but the applicant we have to tell the applicant something to do.
Right. No,
like,
so I think if I were to make a motion, it would be a deferral and ask to look at a new site, a new concept plan that did not include development on this lots with the steep slopes. And also to consider a better grading or new grading plan, or to submit a more
detailed
grading plan that incorporated a number of the things that several of the commissioners highlighted.
And so would it be, it would be a one meeting deferral. Let me get this correct. So it'd be a one meeting deferral and we would not open the public hearing back up.
Well, yeah, I didn't get to that point yet. I was sort of brainstorming out loud, but I guess a question for staff, is it a one meeting deferral or do we need a 2 meeting deferral? And I guess before we go all the way down there, I guess we should also revisit some of the questions about noticing and see what, because there are so many people listening to this, what expectations there should be for any new noticing or anything like that, just to make sure everyone understands, the public understands the process that we're going through.
Yes.
Hi,
Lisa,
Commissioner
go
Farr.
ahead, yeah.
Yes, I'm on it. Hi, Commissioner Farr, so I can speak to the noticing question. So for subdivisions, we do mail out a public notice. Signage is not required for subdivisions in the way that it is for zone changes. So it is written notice only. What our rules and procedures state is that you do have to mail notice to residences within a certain distance. Those notices for this case were mailed compliant with our rules for the March 26th meeting. Now, at the March 26th meeting, the applicant at the request of the applicant, the item was deferred to April 9th. At the April 9th meeting, at the request of the applicant, the item was deferred to April 23rd. Our rules and procedures indicate that new noticing is not required if an item is deferred to a date certain. If the item had been indefinitely deferred, new notices would have been required. But because it was posted on the agenda and deferred at the meetings on March 26th and April 9th to date certain, new notices were not required. If deferred again tonight to a date certain, new notices will not be required.
Great, thank you. So then second question for you all is, do you think a 1 meeting deferral is sufficient or do we need the 2 meeting deferral better? I mean, and then I guess just because of the process questions, I think we've done extremely well tonight, but, and I know we won't reopen the public hearing. Our intent is so far is not to reopen the public hearing, but do we want to give ourselves a 2 meeting deferral just to see if we're meeting in person again in two meetings? I guess I'd welcome your thoughts on that.
Well, before we get to I think it would be helpful to think about what it is that you would want to accomplish in a deferral and to be very clear about that. So then that will help us know the complexity. So what I've heard a couple of different things. One was a concern about some very specific lots, but then I also heard just a broader question around 20% lots that are located with slopes, contiguous slopes above 20%. So those are 2 different things. And then I heard that from Commissioner Gobble and others that you would be interested in a grading plan with the proposed contours, so the proposed contours for the roads. And so there's an understanding of how the road layout would respond to the environmental features. I do think that what you heard from Public Works, that the ADA standards is probably something that would need to be looked at much later. But I think that the grading, kind of the grading proposal, it wouldn't be a full grading plan, is what could take some time. May I ask Lisa if she has a view on this piece of it?
Yes. Hi, Lucy. So we do have an extra week. This is one of those odd times where we have a 5th week in the month. And so we do have an extra week before the next meeting, which is scheduled for May 14th. You know, I do think that if relying on sort of the Hillside Development Standards section regarding cluster lots and saying that the Planning Commission may authorize lots up to 25%. I think some guidance from the commission to us of that they want a plan that doesn't include any lots over a certain that would give us an idea of the level of change, which I think would help us better make a determination in regards to how much time is needed. Does that help? I'm sorry if that's still a little bit.
It does. It does. And if you, I'd also like to just complicate things a little bit more and ask our legal, sort of given the discussion that we had earlier on tonight about deferral dates and the like, is there anything that the commission needs to consider in its motion that you think better preserves our ability to comment on this case? You know, we don't want to get into a scenario where it's deemed approved. And we had that conversation earlier, but just in terms of timing, I wanted to make sure you had an opportunity to speak one more time to that, given the course of the discussion.
Thank you. Well, I mean, I think we could always defer at one meeting, and you know, even based upon that, the timeline of March the 26th, which even arguably if that was the initial consideration, that May 14th date would still be within 60 days of that. If we were to get to May 14th and that's not enough time, then, you know, obviously it could be deferred again. I know there were some conversations about potentially deferring it to be, you know, meeting in person, and I guess there's just no real time frame for that. I will just note that the governor's executive order currently runs until May the 18th, so the May 14th meeting would be covered by that, and there's a good likelihood that one would probably or likely be virtual as well. Obviously, the governor's order could be extended past May the 18th, but that's the date that we have now, and the May 14th meeting would be within that time frame. So I think it would hit both of those 2 points there.
Okay, so I think I'm hearing the advice to defer for one meeting, and then if we can consult with the applicant based on the guidance we get from the commission, and then proceed from there.
Yeah.
So Lucy, I mean, I guess this is, I would be in favor of looking at a plan that took out all of the lots that exceeded the 20%. Or all of the critical lots with 20% slopes. But I don't know if there is a specific look at the lots that Commissioner Haynes mentioned as well. I don't know if you can do both, but my inclination is to try to get a new plan that excludes all of those lots. I mean, the thing we're trying to do with this cluster lot is protect those features. And so I think it's pretty important that we try to do that to the best of our ability and to see a plan that does that.
Well, I think it's up to the commission, obviously, but yours is broader. And so I would think that his would be included within whatever motion you want to make. I would only suggest that you clarify that you are looking at contiguous slopes, because there's some times when it can be spotty, and that's really a function of GIS. And so you're asking, I think, for the continuous slopes areas that you and Commissioner Johnson were pointing to. Okay.
So I will make an attempt at a motion.
Go ahead, Vice Chair.
You can wordsmith as necessary. But I would recommend a one meeting deferral and request that we have a revised plan that would remove the lots that have contiguous slopes of greater than 20%, and also to have a more detailed grading plan that addresses a number of the concerns that were raised by commissioners this evening.
I have a question, please.
Oh, Commissioner Sims, you're recognized.
Yes, I would like to see us keep the public hearing open under the circumstances.
Okay.
Commissioner Farr, I would, just to put a cap on it, reference the Hillside Development Standards. That way it's very clear where you're deriving that requirement, and that is 172830, section A2, and you could just say as referenced by the
So referenced by the hillside development standards.
Yeah.
That gives the commission discretion to authorize slopes up to 20%.
Yeah, and I'm going to interpret your grading plan comment as not a detailed sort of almost a construction grading plan, but with proposed contours to define where the roads are going to go. So you can, I would recommend to the chair that the motion stands, but just to be clear for the record, what we would be looking for, that would be my recommendation.
Chairman,
Hey,
Chairman,
everybody.
I would like to
Hold
ask
on.
for, can I add a comment?
Yes. So we have several people that have raised their hands. So let's handle one person at a time. And Councilor Murphy, you're recognized on to ask a question. Yes.
Thank you. I guess I'm not sure if this needs to be part of the motion or something I just request from staff. I would like, and I know some of this has been covered, I want a whole lot more information about the reclassification of the creek and whether property owners downstream were notified. I don't know if that's in the realm or our scope of ability to find out, but that's extremely concerning to me that a creek was reclassified and property owners were not notified.
Director?
I think what I would recommend, we do have the TDEC report. We will review those findings, and I will ask for, I know water has already sort of, I believe, certified is a good way to describe their action on it, but I will ask them to kind of revisit the report, the conditions that led to TDEC's approval, and make sure that the standards by which water would certify or agree with those findings are made very clear. And I'm happy to figure out if there's a way that we can present those findings, and then in the follow-up, we're happy to do that. Would that be
fabulous?
satisfactory?
Yeah. Like if stormwater, I mean, I understand TDEC and stormwater don't always agree, and TDEC is a little bit, more they're above us and things like that, but I am extremely concerned about downstream water and the reversal process of water. That one thing I have learned over the last 5 years on council that stormwater has just really taught me is water will continue to go where it has always gone. You can redirect it, but it will go where it wants to go. And I would just like a much thorough report from stormwater. And that's something, I mean, I talk to stormwater all the time as a council member. I can talk to them that way, or if it needs to be on the record because of the quasi-judicial boundaries of this case, happy to have them here. I'll leave that at the will of the chairman and the director, but I think I've made my point. So
yeah, we'll
get
that information.
That works.
To you. We also, I see a hand up from Commissioner Johnson. Did you have a question on the motion?
Yeah. In the beginning, we have a lot of discussion regarding the date when 60 days clock ticking. And the legal advisor for the applicant stated March 12th, and we established March 12th meeting is canceled. Therefore, that date is not in play. But could we hear from the legal counsel from the applicant that the applicant's lawyer concur our Metro Legal's interpretation, and so March 12th date is no longer in play. So we are safe to defer one meeting.
Well, I think that's a question for our legal counsel, Quan. I think our interpretation is that he stated that well, I'll let him talk. Quan?
Right. It was our interpretation that the statute at play. I apologize. I've got so many screens up. It's a little bit more difficult than when I'm at the meeting. I want to make sure I cite the correct statute. 134304 contemplates an item being placed on the agenda 30 days after filing or the next regularly scheduled planning commission meeting after that 30-day period. So that 30-day period, according to the applicant, would have been March the 12th. There was no March the 12th meeting. It was canceled completely due to COVID-19. So the next regularly scheduled meeting became March the 26th. And so, again, and I just want to make the distinction that it's our interpretation that the 60-day clock would start from today based upon what we read, based upon 13.4.304. However, to the extent that the commission has some concerns and they would prefer a more conservative approach, they could still use the March 26th date, and that May 14th date would still be 60 days within that time frame.
And so, according to our Commissioner Johnson, according to our legal counsel, it seems that we feel pretty comfortable with a one meeting deferral.
Yes, I do agree. I mean, personally, I do agree with our legal's opinion. Today is the day the item is placed on our agenda. However, I just want to hear from opponent, applicant legal representative. They concur our legal application, because the last thing we need is we file it and then the applicant challenge us and this plan to be deemed approval in the court. I just avoid that situation.
I totally agree and was concerned as well, just given the discussion, although I certainly rely and trust on our attorneys. But I am getting a note from the applicant, if you'd like to confirm, he does not think that a one meeting deferral, let me read exactly what he said. I agree that a one meeting deferral would not violate the 60-day clock. So if you would like, that came through, if you'd like to confirm that for the record, we could probably have him do that.
Yeah, let's do that. Just let's get Doug on the phone. Mr. Sloan. If y'all will get it.
Thank you, Commission. That's Doug Sloan. I agree that a one meeting deferral would not violate the 60-day clock, even by my calculations, and that the applicant's willing to look at the grading plans and supply the commission with some that's hopefully responsive to what they've asked for.
Thank you. Thank you, Mr. Sloan. Appreciate that. Commissioner Johnson, that answers your question, I hope.
Yes, Chairman, I appreciate it. And thank you, Mr. Sloan, for confirmation.
All right, so we are back on the motion. So, Vice Chair.
Do we have has my motion changed? I'm not sure it did. I think it's
no,
the same motion.
If you'll repeat it, so it's if you'll repeat it one more time, and then we'll go from there.
Okay, so we're looking at a one meeting deferral. One point before we go, we did not make a decision about Commissioner Sims' question to leave the public hearing open. I'm fine with leaving that. If others feel strongly one way or the other, I guess tell me now before I make a motion again.
Well, I think Commissioner Sims requested it. I think with we should honor that request. I don't think a lot of times, sometimes we do that on controversial cases, and this one has a lot of neighborhood things. So I think we should include Commissioner Sims, keep the public hearing open. One meeting deferral, keep the public hearing
open. And we would request that the applicant provide a new concept plan, or would look at a new concept plan that would remove the lots that have contiguous slopes of greater than 20%, and also provide a more detailed grading plan to address some of the items that we've discussed and as the director outlined in her comments earlier.
I think that's a proper motion with lots of discussion. I appreciate that. And is there a second? Please raise your hand. If there I don't see a second yet. Is there a second? If Commissioner Haynes?
Second.
All right, it's a proper second. Any other discussion? Make sure if you'll raise your hand in the app and or voice. I don't see any other discussion. And now we will go through roll call on approving that particular motion. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilor Murphy. Councilor Murphy.
Sorry, I said aye.
Oh, now I heard you. Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
Ayes have it, 9-4, none against. And now we are on to item 32. And that's Jason. Is he? Director, is Jason on the line? Are we?
I'm here. Can you guys hear me?
There we go. Go ahead, Jason.
This is a request for a periodic review for a portion of the Canyon Ridge Plan Unit Development Overlay. Next slide, please. You go to the next slide, Lisa, please. This slide identifies the overall boundary outlined in red, and the portion of the overlay requested for review is highlighted in orange. As you can see, portions of the overlay have been constructed, including approximately 800 multifamily units and 54 single-family units. The subject site is approximately 22 acres in size. It's wooded, and the site includes some steep hillsides. Next slide, please. Staff is recommending that the commission find the subject portion of the overlay active. The next slide shows the last approved plan for the subject site. It includes 142 units. Please note the staff report indicates 162 units. However, 142 is correct. It was a typo. The overlay was originally approved in 1983 and included 78 single-family lots and 514 multifamily units. The overlay was amended by council in 1986 and reduced the number of single-family lots and increased the number of multifamily units. Next slide, please. The zoning code allows for a council member or the planning commission to request a periodic review. The code also allows the property owner of a property in an overlay to request a review. In this case, the council member made the request. The commission must determine if the overlay, in this case, a portion of the overlay is active or inactive. If found active, then no further action is required, and if found inactive, the commission must make a recommendation of an action to council as to if the overlay should be maintained, amended, or canceled. Depending on the action, the commission may also have to recommend a rezoning. It is important to note that the commission's recommendation is time sensitive, and the commission must hold a public hearing and make an action by May 13th. The next meeting is May 14th, so this should not be deferred without the request of the applicant. Next slide, please. To determine that an overlay is inactive, the Planning Commission shall establish the following three findings. First, 6 or more years have elapsed since council approval. This is true as the last council action occurred in 1986. Second, on-site construction has not begun. In this case, a sewer line was previously constructed across the subject site to serve the site as well as the adjacent single-family development. All lines were sized accordingly. Water lines were also placed along the edge of Lake Drive to serve the subject site and other sites. Lastly, right-of-way has not been acquired from a third party, nor has construction of off-site improvements required as a condition of council approval begun. In this case, Edge of Lake Drive and Pebble Creek Drive were both constructed to serve the subject site, as well as other portions of the overlay. Roadway requirements were based on the totality of the development. The code also allows the commission to take into consideration the aggregate of actions, if any, taken by the owner of the overlay within the prior 12 months to develop that portion of the overlay under review. Next slide. The owner has indicated that a boundary and topo survey were completed at the end of last year. Availability letters for water and sewer were updated, and 30% capacity has been paid for both. Construction drawings were drafted, and a final site plan application was submitted prior to this request. The plans have gone through one round of review by metro agencies. Next slide. This slide shows the final site plan for 142 units that is currently under review. Next slide. If found to be inactive, the commission must recommend an action to council as to whether the overlay should be maintained, amended, or canceled. If the commission recommends an amendment or cancellation, then it may be necessary for the commission to recommend a zone change. If this is the case, the recommendation must be based on whether the existing overlay is consistent with the goals, policies, and objectives of the general plan and any applicable specific redevelopment, historic, neighborhood, or community plans. Staff finds that this portion of the overlay is active. Major infrastructure has been completed in order to serve the subject site, including but not limited to the construction of water and sewer lines and public roads. 30% of the capacity fees have also been paid for water and sewer. Construction plans have been drafted, and a final site plan application was submitted, and the plans have gone through the first round of review. That concludes my presentation.
Thank you, Jason. We appreciate it. And we'll open this item for public hearing, and the applicant is the councilwoman, and I'm not sure. Let's see if the councilwoman is on the call. She had testified earlier. Is Council Lady Vercher on the line? Seeing that she's not, let's go through our process. And at the first, at the remote location, is there anyone at the remote location?
There is not.
There's no one. Thank you, Greg. Mr. Claxton, do we have any voice calls that recorded? Lisa?
Hi, Chairman. This is Lisa. We don't have any calls or emails on this item.
Okay, no calls or emails. I appreciate that. And Sean, we are now to public live calls. Are there any calls on this particular item?
Chairman, this is Sean. We do not have any calls. Periodic reviews of PUDs are a little unusual in that the applicant is usually the person who requested the review, which is the council member, but the owner or owners within this overlay are usually also given the opportunity to speak. We do have a representative for the property owner on the line if you would like to recognize them. I don't know if they need to speak given where we are, but they're here if you need them.
Director, do we think that we need them to speak, or it's getting kind of late? I think.
Oh, I don't, unless questions come up from the commission, but I don't think so.
Yeah, if there's questions, just let them know, Sean, that if questions come up before we vote, we'll get them on the line.
Okay.
But there's no one else on the line?
There are no other calls at the call-in center from the public on this item.
All right, seeing there's no one else willing to speak, we will declare I declare the public hearing closed, and let's try this with the commission. Since this seems pretty cut and dry, instead of going to each commissioner, let's see if there's any questions. And Commissioner Haynes, your hand is up in the app.
No questions, but I'd like to move approval of staff's recommendation.
That's a proper motion. Is there a second? Council Lady Murphy? Council Lady Murphy? You're still muted. There we go.
You know, I pressed one button and forget to press the other. I did have a timeline question, and then I'm happy to second the motion.
Yes, please.
This is something that I know Southeast, the council members from Southeast have brought up periodically before the council, before the commission. And so I just want to verify that, had anything happened in the last 5 years or has everything happened in the last like year and a half? Is that easy to explain? If it's not easy to explain, I'll just second and we'll move on.
Jason?
This is Jason. Commissioners, I would have to do some research, but the last part of this development that occurred, if I recall correctly, is a single-family development that is along Pebble Drive that is adjacent to the site, and that's where the sewer line was placed in for that site as well as the subject site. But I cannot recall what year that was, but it's probably many years ago.
If you would like this is Lucy, if you'd like a follow-up email, we could provide that information. Also, there is a site plan that is currently under consideration. It has not been approved. It's going through the regular department review, so that's happening today. But it is not part of. Yeah.
And so the site plan is what is triggering the recommendation to find the PUD active?
No, they're unrelated. So, sorry, go ahead, Lisa.
No,
I'm in your space here. You go ahead. You tell it.
Hi, council member. So the timeline of events essentially was that a revision and final site plan was submitted for review. At that time, the council member Vercher asked for a review of this part of the PUD. And so they are unrelated, but one triggered the other for the council member. But a periodic review is really a review that is based on specific findings that are outlined that the commission would review. And those are the findings that are on your screen now. And so it's a very specific criteria.
Okay, I guess what I was seeking clarification for, and y'all have given me, is I know some of these PUD review findings have come up in SP reviews as well, quite frankly, specifically in the southeast portion of Davidson County and those council districts. And so what I guess my experience has been is that something happens and then the council members try to get the PUD or the SP reviewed. And so maybe this is something that we can talk about another time, but some way to talk to council members about just maybe a review of the state law vesting law, and kind of PUD reviews and SP reviews and things like that. Because one thing that I hate to do is that it is on the agenda to review a PUD, and then we look like we're the bad guys because we find something active. When if we could have reviewed it 6 months, a year, or 2 years, or 3 years ago, we may have found it inactive. That was something that happened once or twice last term. So I think that's probably something that staff and I can work on to help council members with. But with that, I'll second the motion.
Thank you, Councilor. It's a proper motion. Any other discussion? Let's try this. Please raise your hand or by voice. I don't see any other discussion. So seeing no other discussion, we'll do roll call vote. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Hayes.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilor Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tiff.
Aye.
Ayes have it, 9-4, none against, and item 32 is approved. So we are now on to item 33A and B, and we'll vote on these separately, but that would be, is Jean doing this?
That's right, That's right, Chairman.
Okay. Nice, Jean.
Jean, we're not able to.
And hold on.
There you go.
Hey, Jean, hold on 1 second. We do have the council member on the line for this, and obviously, we give the council member the time to speak at the end. So I just wanted to let y'all know council member is on the line. So Gene?
Chairman, let me attempt to reach out to Gene to see if he has a technical issue. If you'll give me one moment. Sorry, just give us one more moment.
Mr. Chairman, can you hear me now?
Yeah, you're good.
Okay. Sorry about that. Not sure what happened. So this is item 33A. This is a request to amend the Antioch Pre-Slate Community Plan by changing from T3 Suburban Community Center Policy to District Industrial Policy. Next slide, please. Staff's recommendation is to approve. As a side note, the area outlined in a solid black line represents the plan amendment area in the request. Also, conservation policy at this site will remain. Next slide, please. Let's see the existing conditions. The proposed plan amendment area consists of vacant commercial land that is part of the former Starwood Amphitheater site, a large outdoor music venue. This site is located along Hobson Pike near the Murfreesboro Pike, near the Murfreesboro Pike, Hobson Pike intersection in the Antioch community. Next slide, please. This request proposes to change the lanes policy from T3 Suburban Community Center Policy to District Industrial. T3 Suburban Community Center Policy encourages the enhancement and creation of suburban development that permits a variety of land uses that serve communities within a 10 to 20-minute drive. District Industrial Policy encourages the creation, maintenance, and enhancement of industrial parks. Next slide. District industrial areas maintain, enhance, and create industrial districts in appropriate locations. Uses usually include non-hazardous manufacturing, distribution centers, and mixed business parks. This policy intends to enhance industrial development in general. Next slide. On March 5th, staff hosted a community meeting at the Smith Springs Community Center, located at 2801 Smith Springs Road, to discuss the applicant's request. Over 20 people attended, including the district council member. Staff spoke and answered questions regarding the plan amendment process. The applicant discussed reasons for the request. Reaction to the request was generally positive with some concerns. Concerns included the potential for additional truck traffic on Hobson Pike and industrial uses that may pose as a nuisance to adjacent residential development along Hobson Pike to the west. And expressions in support included potential to attract additional jobs and services to the area at the time of redevelopment. Next slide. Staff will explain why this request for district industrial policy is appropriate in this location. Next slide. The growth and preservation concept map of Nashville Neck designates this site as neighborhood. The neighborhood consists primarily of residential areas that offer a mix of housing types and character, with smaller civic and employment areas and small neighborhood centers. Surrounding properties are designated as special uses, which envision industrial and institutional development. This site can serve as a transitional area between parcels designated as special uses there in the lighter blue color to the south, which is adjacent to the site on the south side, as well as the mix of uses along Murfreesboro Pike to the north. Next slide. The site is located at the north edge of a large area of district industrial policies. You'll see the big blue area, and then you'll see the site outlined in the solid black line toward the top portion of the picture. This site was part of the larger district industrial policy a long time ago, but it changed from district industrial policy to suburban community center policy over time. Reverting it back to district industrial policy is appropriate in this location. The site will serve as an adequate transitional area for potential industrial development by coupling it with smaller properties that already have district industrial policies. You can see the small parcels already in blue that wrap the site on the south side. This will provide an opportunity for the larger area of industrial policy to be developed simultaneously. Next slide. The site is located away from the moderately intense policies of Civic and T3 Suburban Mixed-Use Corridor policy along Murfreesboro Pike, kind of near that intersection. The proposed policy is located across the street from T3 Suburban Neighborhood Maintenance policy along Hobson Pike, which is like to the left side of the graphic or the west side of the site. T3 Suburban Community Center policy covers each corner of the intersection in Hobson Pike and Murfreesboro Pike. Next slide, please. The site is located near that intersection. Hobson Pike is classified as a 5-lane scenic arterial boulevard, and Murfreesboro Pike is classified as a 5-lane arterial boulevard, both by the Major and Collector Street Plan. Each designation requires new pedestrian infrastructure, such as sidewalks and bike lanes, that will enhance connectivity within the broader area. WeGo also provides bus service along Murfreesboro Pike with nearby access to one inbound and outbound bus stop located near the Murfreesboro Pike Hobson Pike intersection. Next slide. In conclusion, staff believes that this amendment request is suitable for the following reasons. 1, the site can serve as a transitional area between parcels designated special uses south of the site and a mix of uses along Murfreesboro Pike, which is a suburban arterial boulevard, making application of district industrial policy appropriate. 2, converting this site back to district industrial policy will allow for the consistent application of policy in the immediate area, leading to compatible development. 3, adequate infrastructure currently exists as it pertains to transportation options, connectivity, and access is in place to support this request. And then 4, there's potential for additional access and multiple travel modes if the area is redeveloped. Given the aforementioned, staff recommends to approve.
Thank you, sir. So we are considering item 33A and B. We will open the item up for public hearing. We'll vote on these two items separately, but discuss them at the same time. And now is the time for the applicant to do their 10 minutes, but I want to remind callers.
Hi, Chairman. I'm sorry. We have the 33B to be presented.
Oh, gosh, I thought that
By
was
Logan.
Sorry. Sorry, let's not open the public hearing yet. 33B, I'm getting ahead of myself. 33B. Sorry.
Thank you, Chair. Item 33B is a request to amend the Starwood Town Center SP. Next slide, please. The request is to amend a specific plan for a 65-acre property located at 3839 Murfreesboro Pike, the former location of the Starwood Amphitheater, for a mixed-use development. Next slide, please. Staff's recommendation is to approve with conditions and disapprove without all conditions if the associated plan amendment is approved, and disapprove if the associated plan amendment is not approved. Next slide, please. This property is zoned specific plan. This property has undergone a series of SP amendments. The most recent approval from the Planning Commission was at its February 22nd, 2018 meeting for an amendment to a specific plan zoning district to permit 200 single-family units, 350 multifamily units, 421,500 square feet of non-residential uses. And features of this specific plan included public streets, a common green space, and design standards for the various land uses. You can see that the site is surrounded by a mixture of commercial, residential, industrial, agricultural, and mixed-use zoning. Next slide, please. The policy for the site currently is Suburban Community Center policy with conservation. And as Jean presented, they are proposing to include district industrial policy for the southern portion of the site. Also, the portion of the site that fronts on Murfreesboro Pike is within the Murfreesboro UDO. Next slide, please. The specific plan amendment proposes 3 distinct zones with specific standards for each zone. Zones 1 and 2 are site plan based, and Zone 3 is primarily a regulatory plan. The applicant has provided for architectural standards that apply to all 3 zones. The applicant has also provided for cross sections for Hobson Pike and Murfreesboro Pike, as well as their private internal roads that are all consistent with the major and collector street plan for the street standards. Lisa got a little bit ahead of me, but that's okay. So now looking at Zone 1. Zone 1 is primarily a residential zone with live work and small scale retail also permitted as accessory uses to the residential use. A mixture of single family and attached townhome units are provided at a density not to exceed 15 units per acre or a total of 120 multifamily units. This zone is accessed via Murfreesboro Pike. The plan proposes a vehicle and pedestrian connection to the commercial and residential zone to the east, Zone 2, and a pedestrian connection to Zone 3. Also, Zone 1 provides interconnectivity opportunities to the property immediately adjacent to the west that's located at the intersection of Hobson Pike and Murfreesboro Pike. And this zone also partially provides for a common green space that is shared with Zone 2, which we can go to the next slide. So Zone 2 is a mixed-use district with commercial uses on the first floor and a mixture of commercial and residential permitted above the first floor. The zone also draws access from Murfreesboro Pike and completes that interconnectivity with Zone 1. They also provide for a pedestrian connection to Zone 3, and similarly, this zone provides for interconnectivity opportunities to the property to the east on Murfreesboro Pike. Moving on to Zone 3. Zone 3 is primarily a regulatory plan that proposes a private loop road to access these office and industrial uses. The applicant has provided bulk standards and facade standards for office uses and for industrial uses in this zone. And next slide, please. In conclusion, staff recommends approval with conditions and disapproval without all conditions if the associated plan amendment is approved, and disapprove if the associated plan amendment is not approved. This completes staff's presentation.
Thank you, sir. And I apologize, I was getting ahead of myself. So now we'll open the public hearing for 33A and B. We'll vote on them separately, but discuss them together. At this time in our meeting, we'll make sure we tell people to call in to the number. If you're wanting to call in, now's the time. We open the public hearing, and the applicant gets 10 minutes and can save 2 of the 10 minutes for rebuttal. And is the applicant on the line?
Chairman, this is Sean. The applicant is on the line, and he should be unmuted and able to speak.
Please state your name and your address, and go ahead.
My name is Josh Rowland. My address is 214 Oceanside Drive in Nashville, 37207.
And who you represent?
I represent the developer, and I'm a consultant with Kimley Horn.
Okay, go ahead.
Thank you, everybody, especially for your patience and your good nature tonight. I know this has been a long night, and I've just been real impressed with everybody's work so far. So thank you for all that you're doing. I want to thank Gene and Logan for their presentations. They did a great job with an overview of the request this evening. Yeah, I think a lot of this application has a backstory related to the previous SP approvals. The property has been vacant since 2006. There was an original SP in 2008 that is similar in a lot of ways to the one approved in 2018. Both had a high intensity of retail and restaurant and office uses, and varying amounts of residential uses as well. What the developer has found is that the market has not been able to prove the viability for those mixes. Those particular mixes create a very high intensity amount of traffic and burden to both the infrastructure and the surrounding school district as well. And so our goal here with this amendment to the SP is to add a third component. It's supported in many ways by previous land use decisions that were changed for the purposes of these earlier SPs. And now it's, with the market in Nashville with a lot of businesses looking to relocate, this mix of business park with a mix of industrial and office uses has a lot of appeal to corporations and businesses moving into this area. So we feel like there's a lot of good advantages that go along with this new amendment to the SP. One of the great advantages actually is that this new traffic and impact represents about 25% of the impact that was realized from the older SP versions that had a higher intensity of residential and commercial uses. Those high impacts are part of the problems in getting those earlier plans developed. They triggered a lot of off-site infrastructure improvements that made the project financially unfeasible. But I think our goal in working with the councilwoman and with the residents is to retain the important aspects of the previous SPs, to retain a neighborhood component, and to retain a commercial component that has some retail and restaurant uses, so that there can be a destination and a location that has some personality and has a sense of gathering and a sense of a place for this community to go and to recreate, both in the park setting that's between our two uses, providing new homes, for sale product for the residents in this district, as well as some great opportunities for commercial uses that represent a mix of commercial, retail, restaurant, and office uses. So certainly was our goal to retain those uses along Murfreesboro while adding in the use along Hobson Pike for the business park. A few additional details that are identified in the SP regarding the new use. We have many improvements happening along our frontage on Hobson Pike. Currently, it's a 2-lane road with just minimal widening at the intersections at the old access points to the Starwood Amphitheater. You'll see in comments from the transportation group with Public Works that we'll be adding a center lane to the road for left turn movements, and we'll be adding right turn in and out lanes along the project frontage. That's going to create safe traffic movement into and around the site. The roadway master plan for this section of Hobson Pike includes a 12-foot multimodal trail that'll be on our side of the property. So in addition to road widening, the addition of curb and gutter, we'll be adding a detached 12-foot trail. So we're going to have a safer condition for vehicles as well as a safer condition for pedestrians. A few of the considerations that we've made based on comments we got from the community members, they were concerned about the visual nature of the business park with larger, more industrial type buildings potentially being constructed. We have retained the vegetative buffer. There's an existing berm with heavy vegetation, trees, and an understory along Hobson Pike, and to the greatest extent practical, after we construct the road widenings and the bike trail, we're going to retain that berm and those trees to screen the property. We've also restricted having any truck loading or or truck bay storage areas facing Hobson Pike. They all need to be internal to the site and screened. And as Gene and Logan mentioned, we do have some architectural controls that require minimum percentages of glazing and facade enhancements to make sure that this is an attractive development on all fronts. We've had a lot of interest from potential business park users, including potentially data centers, corporate relocations for R&D, pharmaceutical type companies. We feel like we're going to be bringing not only a good mixed use component along Murfreesboro Pike, but a good job building component that's going to bring good paying jobs, as well as increasing the current tax rolls for this property. It's currently just a vacant property that's not doing anything for Metro Nashville. We feel like this is a great benefit to the community. We've gotten a lot of very positive feedback from many residents and from our councilwoman. So we welcome your comments this evening and thank you for your time. That's all I've got.
Thank you. And Sean, how much time is left?
Chairman, there are 3 minutes and 16 seconds left, so we'll reserve 2 minutes for rebuttal if needed.
Perfect. And before we go to the remote location, let's let the councilwoman go. There were several references to the councilwoman. Councilwoman Lee, are you online?
I think I am. Can you hear me?
Yes. Good to hear.
Oh, great. I don't have a lot to say. It was explained very well, except that we have been working with this company intensely for over 2 years. I will kind of put the two together so that I won't use up time talking on the other one either. But we have had extensive meetings with the community. The original plan that came together, the community was all for it. It was wonderful. I mean, it was going to be breathtaking, and I was so proud of it. But what happened was, as you heard, the financial burden because of so many houses and everything that could have done increase the population, and the financial burden of fixing the roads and doing a lot of improvements, that we had to do something creative to still be able to have a showplace area in this Antioch area and make it feasible for the developer to do it. And I think we have that. So in most of our meetings, I will say there were some folks that had some concerns, but I will also add that most of those concerns were from people that were not in the district. Most of the people I've heard from my district are actually for this. And I feel secure because the developers that we have been working with have done whatever it is that we have asked them to do or to change. And so I feel confident that this will be a good looking development. And I don't know if there were any other questions or anything else specifically that you all wanted me to say.
No, that's good, Councilor. We'll call on you at the very end. So,
okay.
And we appreciate it. And then if there's questions that come up, we'll ask you, okay?
Thank you so much.
Yeah, thank you, Councilor, for joining us tonight. We really appreciate it. So now we're on to the remote location. Mr. Claxton, is anybody at the remote location to testify?
There is no one at the remote location.
Thank you. And Lisa, we are now on to voice call-ins, voicemail.
Hi, Chairman. We did not have any voicemails on this item. We did receive 3 emails. One of the emails was in opposition. 2 of the emails were in support. And one of the support included a petition signed by 10 others in support.
Okay, thank you for that information. Very helpful. Now we are on the public live call-ins. And do we have any of those, Sean?
Chairman, we do have some call-ins, so we will begin entering those into the meeting.
Hello.
Okay, perfect.
Are you ready for the meeting? Okay, hold on.
And Chairman, you have the first caller.
Thank you very much. Welcome to the meeting. If you would state your name and your address, and then if you're either for or opposed to the project, and then you can begin testifying. Thank you.
Thank you, Mr. Chairman and Vice Chairman. And thank you all to the council, to the commissioners. My name is Martez Coleman. I live on Singing Hills Drive, 5140 Singing Hills Drive, which is right around the corner from Starwood. I am for this development. I've been attending, in fact, almost all the meetings, and most of it was positive. And I just want to say that I have, lived in this area for about 20 years. I've also ran for public office. I'm an advocate in my community. I have heard numerous of times and many times about when are we going to start breaking ground in the Starwood community. I've looked at the plans and reviewed the plans, and I think it's going to be great for District 33. It seems to me sometimes that our district, by backing up against the Rutherford County line, has been overlooked. I don't think it's done intentionally. I just think that we need to bring more people to our area, such as from Laverne and Smyrna, instead of people going over and crossing the line, and maybe also going to Mount Juliet to shop. I'm excited about this. I want to thank Councilwoman Lee. She's put her heart into it, and I've supported her along with the developers.
Caller, you have 30 seconds.
And I just want to thank, I know we're running out of time, but I just want to say I think this community will be very good. This development will be very good for our community. Thank you.
Thank you, sir. And next caller.
Chairman, you have the next caller.
Hello, welcome. Please state your name and your address and whether you're for or opposed to the project, and you can begin testifying. Thank you.
All right. Thank you very much for the opportunity. My name is David Chilton at 1416 Forestville Way, Antioch. I have lived the last 34 years in the Antioch area, and I am for this proposal. I've attended numerous meetings concerning this development over the past few years. This property has sat in our neighborhood as an ugly eyesore for at least the past 10 years. And I know that there is some negative talk out there. One of the negative items that I've heard is that there's not enough retail and office space. And I feel that the developer has provided adequate retail and office space. And also, I've heard some negative talk about the potential for ugly warehouses. I think this developer has shown us that he does not intend to have what many perceive as ugly warehouses. He has shown us the type of buildings that he wants to have there, and I find that they are very attractive and would be quite suitable for the area. We have a local developer who has listened to our community's desires and has been more than willing to develop a plan that is pleasing and beneficial to us. It will enhance Southeast Nashville and benefit the entire county financially. And I ask that you please allow this provision so that we do not have to live any longer with the existing Starwood eyesore.
Caller, you have 30 seconds.
I have finished, and I thank you very much for your time.
Thank you, sir. We appreciate it. Next caller.
Chairman, I would like to report that you have no further callers.
Thank you, Sean. Seeing no further callers, I want to thank everybody who called in. We really, really appreciate it. And the applicant has 2 minutes if they want to speak, and then we'll go to the councilwoman. Applicant?
I don't have anything further to add other than a thank you to those supporting the project.
Council lady?
I only want to say thank you for everyone's hard work on this and for all of my constituents who came to the meetings and for what you guys do. Thank you.
Thank you. With no one else wishing to speak, we declare the public hearing closed, and we are now on the commission. Let's try this. How about we start with the vice chair, or is there any discussion? Let's see if anybody has any discussion or questions. If you'll raise your hand on your app or by voice. If not, I don't see any. How about vice chair? Do you want to make a motion?
Sure. I guess I'll just make one comment, which is that it's always nice with such a giant project like this to see good community support and good community engagement. And thank you to the developer and the council person for facilitating that. And with that, I will make a motion that we accept staff's recommendation on item 33A.
33A, yes.
33A.
That's a proper motion. Is there a second? And we, Commissioner Johnson. Commissioner Johnson?
I second the motion.
It's a proper second. Any other discussion? I want to make sure, if raise your hand in your app or by voice. Hearing no other discussion, we'll do a roll call vote. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson. Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilman Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
Ayes have it. 9-4, none against. 33A is approved. Now we're on 33B.
Chairman, I'll make a motion that we approve staff's recommendation for item 33B.
That's a proper motion. And is there a second? Commissioner Tibbs.
I second that.
Proper second. Any discussion? Please raise your hand in your app or by voice. Seeing no other discussion, we're on the roll call vote. Vice Chair Farr.
Aye.
Commissioner Gobble.
Aye.
Commissioner Haynes.
Aye.
Commissioner Johnson.
Aye.
Commissioner Moore.
Aye.
Councilman Murphy.
Aye.
Commissioner Sims.
Aye.
Commissioner Tibbs.
Aye.
Ayes have it. 9-4, none against. 33B is adopted. Now we are on to other business. Historic. Commissioner Tibbs. Anything on historic?
No report. We had our first meeting as well yesterday, actually, and it also was went well and successful.
Excellent. And Commissioner Haynes, anything in parks?
No, first meeting is next 10 days.
Okay. Executive committee, I will just say that the vice chair and I really appreciate everyone. We both want to thank the staff and the public and everyone. It takes a lot of energy and thought into these new processes, and the IT department, they've been just amazing. I can't thank you all enough. I want you all to know that our team at the Planning Commission loves Nashville, cares for Nashville, and works their heart out. And so I want to thank Director Kemp and her team for all they do in all of the departments, and I want to thank the commissioners for being patient, hanging in there with us, having thoughtful discussion. And I know each one of you, I truly believe that all of you care about Nashville and want to do the right thing. And so I appreciate everybody for that. Vice Chair, is there anything you want to add?
No, that was very eloquent, and thank you for doing a nice job keeping us going for 7 hours tonight.
7 hours, no break. It's a big one. So, Director, we're on anything from you?
I'll be super quick, brief. Thank you for acknowledging the staff. There was sort of a symphony of efforts and different team members who pulled this together. We appreciate your support. I would just ask the commissioners if you have any feedback for how you think it went tonight, things that you would like to improve, things you think went well. I welcome it. We are learning, and I want to acknowledge the great team at ITS who have really been trying to craft a model of engagement that meets our commission's expectations. And so thank you very much. Y'all have a wonderful evening.
Oh, and I didn't thank Quan, our attorney. He had a lot of action tonight. So thank you, Quan, for that. Thank you, Director.
You're
Council
very
Lady.
welcome.
Thanks, Quan. Hey, Council Lady, any update?
Yeah, I don't want to take too long, but there has been some legislation that doesn't necessarily come to the Planning Commission that deals with what the sponsors consider affordable housing, that I'd like to have a conversation with maybe the chair or the executive committee and the director to talk about that, dealing with landlord tenant issues. But then also, my second thing is that maybe Chairman, this is a motion we need to make. I think the council needs to hire the planning staff to run the rest of our virtual meetings, because this was amazing.
Well, on the affordable housing council, if you would, in order for us to keep with open meetings law, if you'll talk to the director first, and then if we have to hold a workshop eventually or something like that, we can discuss that.
Yeah, I think that'd be great. I just think that we need to be weighing in on some landlord tenant legislation coming through the council that we have not been given the opportunity to.
Okay, perfect. Yeah, if you'll reach out to the director, that'd be great.
I'll do it. Thank you, Chairman.
All right. I think that concludes our meeting. Director, does that conclude all of our business, I believe?
It does. Thank you very, very much.
All right. Well, we'll need a motion to adjourn.
So moved.
And there's a motion to adjourn, and without objection, we're adjourned. Thanks, everybody, and good night.
Thanks, Mr. Chairman.